So the first item on the agenda is roll call. Neil Hoffman, Nevada Board President, present.
April Long, Treasurer.
Alex Leader, present.
Perry Nixdorf, present.
Koki Booth, Board Member.
Jeanette Benaldi, Board Member.
Gary Landry, Executive Director.
We also have staff that needs to introduce themselves.
Sarah Bradley, Deputy Attorney General.
Colleen Platt, Deputy Attorney General.
Yours or mine? Sorry about that. If you would like one of those.
Charlene Marsh, Inspector.
You guys, we don't need to have roll call for Jeff. And and then Annie as well.
Good morning. Annie Curtis, Chief Inspector.
Good morning. Joanna Tran, Board Member.
Excellent.
Deborah Blasco, Accountant.
Monica Bradford, Administrative Assistant.
Okay. Agenda item number 2, we're going to do the Pledge of Allegiance. If everybody could please stand. Thank you. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. Agenda item number 3, we're going to be discussing the mission statement of the Nevada State Board of Cosmetology. The mission of the Nevada State Board of Cosmetology is to protect the public health, safety, and welfare through education and ensuring only qualified persons are granted licenses to perform cosmetology in the state of Nevada. Okay. This is the time in the meeting when we're going to open up to public comments. So if anybody would like to step forward and has anything to discuss before the board. Anybody down in Vegas looking to step forward and say anything to us?
No.
Okay. Moving right along. Agenda item number 5. Need to find out if the agenda has been posted in accordance with open meeting law.
It has.
Okay. Yeah, so I'll entertain a motion.
Mr. President, I'll make a motion that we approve the agenda and its posting.
I'll second.
Okay, so I have a motion on the table and a second. Any discussion? Okay. Those in favor?
Aye.
Aye.
And those opposed? Okay, so that motion's unanimous.
Aye.
Oh, unanimous. Okay, so item number 6, consent agenda. The board will now consider approval for agenda item number 6, the consent agenda. Today's consent agenda contains minutes from the August 5th board meeting, along with the executive director's report.
Move to approve.
I'll second.
Okay, so we have a motion on the table with a second. Is there any discussion? Anything anybody wants to do? Remove an item, add an item?
Mr. President, I have a couple of questions when you're ready. I wanted to pull out the inspections for the internet activities. It would appear to be item number 8 on the list of the reports, to discuss that separately from the consent agenda. I also wanted to pull out the budget report for the finance. It's item number 12. And I also had a question on the letter from October 11th of 2013 regarding the Versa override edit functions. I'd like to pull that out of the consent agenda.
Okay.
And I believe
Alex, could you repeat the last one?
the last one is the letter dated October 11th, 2013 from Holdsworth, Russo and Company. And I believe that the notes to the financial statements dated June 30th of 2013 is also part of the consent agenda, and I'd like to pull that out as well. And then finally, the notes to the financial statements continued regarding the operating leases. I'd like to pull that out of the consent agenda
Okay.
for additional questions.
Okay, so the motion would need to be amended to reflect that those items want to be pulled out by Mr. Leader.
Thank you.
And if we pull those out, where are we putting those?
It would seem to me that because they're financial, that they could be discussed when we go to,
It's an approval item. What you would do is you would move them to later in the meeting. You would just reopen item number 6 and talk about the ones that you want to talk about. So they don't actually get like a new number, but
Just shuffle to the end of the
Yeah.
day.
I'm thinking it would be better to do them after the hearing and after the citation appeal if possible. But other than that, it's up to you whenever
Okay.
you'd like to recall
All
them
right.
back.
Well,
you
so
know-
we'll move them to what agenda item then?
Could
Alex?
I make a friendly amendment here, or just a suggestion that we move the executive director's reports and everything that falls under that to the end of the meeting?
Would you agree with that, Alex? Great. Okay,
Second that then.
so, yeah, so the motion's been amended and now,
I'll amend my second.
okay.
Could possibly be Alex.
I'm sorry?
Did you want to correct your motion, or I do? Okay, I'd like to correct the motion to read that the executive director's report and all that follows under it be moved to the end of the meeting.
Okay, so agenda item where?
So that's a motion, so it's seconded.
What you're motioning really is just to defer item 6 until later in the meeting.
Okay.
I'll second.
Okay, so we have a motion and a second. I think we cleared all the muddy water up.
Thank you.
So, a vote then. All those in favor?
Aye.
Aye.
Aye. Those opposed?
Aye.
Okay, so that's unanimous. So we'll be moving to those portions of the executive director's report to the end of the meeting. Okay. Okay, so moving right along, item number 7, the appeal of citation number CM-214, alleged violation of NRS 644.430. Are all parties present for this agenda item? We're looking for Jody Allard. Jody, are you here? Okay. Jody, if you'd please come forward. Everybody being testifying before us today needs to be sworn in, so if you could step forward so that Mr. Nelson could swear you in.
Mr. President,
Yes?
I did want to clarify, in the executive summary of this staff recommendation for agenda item 7, it said that the inspection team observed Miss Allard on August 19th. I just wanted to double check that that date is or should be June 21st, 2013, as noted on the citation. And if that's relevant, I just thought I'd bring that up to you.
Okay, so we want to make sure that the dates are all correct. Where's the paper, Alex?
It's this cover sheet right here. And June 21st is
It's just the agenda.
Oh, as far as,
No action would be needed, Mr. President.
That's
It's just
that's
a formality.
The agenda. I believe it would be just a typographical error on the agenda. I think
okay.
the items included in that document after that regarding the citation itself and the citation appeal would be the ones you would want to look at.
okay.
There's a subsequent date if you look on that page, right where your finger is.
Oh, yeah. So, yeah. Okay. All right. So the burden of the proof falls on the board. So we actually get a chance to present our case first. Sarah Bradley will start that, and then you'll have an opportunity after she's presented her case to present your side of things to us. So long as that's all straight and everybody understands, I guess we'll get started. Sarah?
Charlene, would you please state your name and spell your last name for the record?
Charlene Marsh, M-A-R-S-H,
And who is your employer?
Nevada State Board of Cosmetology.
And what is your job title?
Field and Office Assistant 1.
And as part of your duties as Field and Office Assistant 1, did you issue the citation in this case?
Yes, I did.
And can you tell us about that?
Miss Allard was doing a haircut, and I noticed that she was doing a haircut, and I waited for her to finish before I went over to ask her for her license. And when she showed me her license, it had expired April 11th of 2013, and the date that I was there for the inspection was June 21st, so over 2 months.
Okay. And you did you see it posted on the wall?
No, she had it inside a cabinet, and she did present it when I requested it.
Okay. And so then you issued the citation?
I did.
And that was for violation of what provision?
NRS 644.300, working with an expired license.
Okay. And was this a first offense?
Yes.
And what's the fine for a first offense expired license?
$200.
And were you able to verify that her license was in fact expired with the Reno office?
I did call the Reno office and verified to make sure it was an expired license.
Okay. I have no further questions for Ms. Marsh.
Okay. Do you have any questions you'd like to ask of Ms. Marsh? No? Okay.
Do I talk now?
Yeah.
I just want you to push the mic so they could hear you.
So it's your turn to ask her any questions you have.
Okay, can I just state my case?
Not at this moment.
No, at this time,
Okay, no,
just if you have any questions for Ms. Marsh. Okay. Okay, Sarah?
Do any board members have questions for Ms. Marsh?
No? Okay.
Then I have no further witnesses. I don't know if Ms. Tran in Las Vegas might have anything she wants to say.
No, I'm good, thank you.
Actually, Ms. Marsh, is this the first offense for her?
Yes.
Okay.
So, Ms. Bradley, you're finished with your...
I would rest. I don't have any further witnesses to call.
Okay. Ms. Allard, it's an opportunity now for you to present your case to us, if you would, please.
Okay, I just want to say that I've had my license since '84 and never let it lapse. It just, with the change with the birthday and not having the slip on the back and my life, I just wanted to state that. But I left right away because I had to go. I had another haircut that I had to do, so I had to go get my license renewed because I was leaving for San Diego that night. Anyway, so I never got I went and paid the fee, $130. That's what I thought I had to pay, and then a month later I got this $200 fine, but I had paid it to the salon, so I thought I was good. So I have the canceled check that I paid to the salon for the $200 fine.
You paid to the salon, not to the state board?
Yeah, because I never got the notice until a month later that I was supposed to pay it through myself.
Oh, okay. Are there any board members that have any questions of Ms. Allard?
Mr. President, I have a question. Ms. Allard, you just indicated that you've never let your license expire since 1984.
No.
But the reason why you were cited is for an expired license, so that's an inaccurate statement.
Well, that's the first time. I had never let it lapse until...
Thank you.
Can Ms. Marsh, can you tell us, when would she be notified she owed the $200? At the time you gave her the citation? Or do you automatically mail them an invoice?
Actually, Miss Allard left immediately, so what I gave the citation to was the person in charge there and told her it needed to go to Miss Allard. And I always do tell them that within 20 days, if it's not paid, that they will be given a notice from the office for the bill.
Okay, thank you.
Miss Allard, you've been doing hair since '84. Have you ever written a check to the salon before for your license?
No.
Okay, that's not usual protocol. Usually
Fine.
take it to the state board office or mail it to the state board office. Is that correct?
I had never had an expired license, so I didn't know. This was the paper that I was given.
Okay.
How have you renewed your licenses before? Usually through the mail?
I believe so.
You said there wasn't something attached to the back. What did you mean by it?
You used to have a yellow sheet in the back of your license.
Okay.
And it wasn't always on your birthday that you would have to...
How long have the yellow sheet been absent from that? Does anybody know? Ms. Marsh, do you know?
I don't know a specific time, but it's been a long time since we had those attached.
Okay, so more than 2 years, more than 4 years?
I would say more than 4.
More than 4, so that's 4 times that you've registered it without that yellow sheet, or twice?
You know,
Okay.
my life's been a blur since my divorce, so...
Yeah. Thank you.
I have one last question to ask here. When you wrote the check for $200, was that possibly for the fine that the salon was going to get?
I believe it was, yes.
Okay, thank you. I'd like to make a motion now, if that's, is that possible?
I think there's additional questions.
Oh, sorry.
Mr. Nixdorf? No, nothing? Okay. Ms. Booth?
And I would like to actually recall Ms. Marsh briefly, if I could.
Okay.
Ms. Marsh, was the salon cited for this as well?
Yes, they were, and it was a second citation for the fine, for the unlicensed or an expired licensee working, and it was $500.
Okay. And the record should reflect that I'm showing the respondent what's been pre-marked as State's Exhibit 1 in this case. Ms. Allard, have you seen those documents before?
Yes.
Do you have any objection to those being admitted into evidence?
No.
Okay, I'd ask that the letter that's noticing her for the citation today, as well as the answer and consent decree, a copy of a check made out to Aqua Salon, a copy of her license, the citation, and the report of establishment be admitted into evidence as State's Exhibit 1.
So admitted.
And I have no further questions for Ms. Marsh.
Ms. Allard, is there anything else that you'd like to present for your case today?
Like I said, I just didn't, I was given this from the salon, and so I felt like I have to pay it. So, and the salon is closed now, and I guess he didn't pay it, pay his fine. So in a sense, I guess I paid his fine.
Are you a booth renter or are you commission?
I was commissioned.
Mr. President, I did want to ask a question of Ms. Blasco regarding the prior response that the citation to the establishment was $500. Ms. Blasco, was that fine paid?
I would not have that with me, Alex. It's not on the agenda.
Thank you.
Okay.
I'd like to make a motion.
Alex, would that reflect your decision in not having that information?
It seems to me that the check was written to Aqua Salon. In the memo line, it says salon fine. If the fine was $500, it's only a partial payment. And so I'm just kind of curious as to the status of the two fines.
My understanding is that Aqua is no longer open.
Just because an
correct?
establishment
Yeah.
isn't open any longer, does that mean the fine just goes away? Ms. Blasco?
No, not necessarily.
So if an establishment closes with an outstanding fine due, what is the protocol for the administration office?
If the salon was owned by a licensee, it may follow them. But if not, then within a certain amount of time, I have to write it off as a bad debt.
Do you know if you've written that off as a bad debt at this time?
Probably not.
No, I don't have any of that information with me.
Thank you.
You're welcome.
I would like to make a brief closing statement
Okay.
before you.
Please.
I would just submit that the testimony that Ms. Marsh has provided has established that the citation was proper and should be upheld by the board. Thank you.
Okay. Ms. Allard, is there anything you'd like to say in a closing statement before we come to a decision?
No.
Okay. I'll entertain a motion.
I'd like to make a motion to uphold the fine for Ms. Allard violating 644.320,
We
working
have
with
to
an expired license.
have findings of fact before, correct?
I'd like to make a motion that we uphold that she was guilty.
Okay.
I'll second
the,
that.
The proper way to do this is to find that the facts have been
finding of
proven,
facts are-
and then that's one motion, and then the second motion.
Right. So do you want me to withdraw my motion?
Or amend it.
Or amend.
Amend my motion that we uphold that the finding of facts are true, and we uphold the motion.
I'll second that motion.
Okay, any discussion further to that? Anybody in Vegas? No? Okay. All those in favor of finding the facts of the case to be true, say aye.
Aye.
Aye. Those
Aye.
opposed? That motion carries.
Mr. President, I'll make a motion that we uphold the fine of $200.
I'll second.
that.
Okay, so that was motioned by Mr. Leader and seconded by both Ms. Benaldi and Mr. Nixdorf. Any discussion? Those in favor, say aye.
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 Those opposed?
Nay.
That motion carries. Thank you, Ms. Allard. The office will be in touch with you with regards to how you can pay that fine.
You'll get an order in the mail from the board letting you know about the fact that the citation was upheld, and then if you need to work that out with the board office, you can talk to them about that.
Thank you. Okay. Agenda item number 8 on the list is the board will consider the appeal of citation CM-224, alleged violation of NRS 644.360.1. Miss An Thin Pham, okay? Yeah. So, Ms. Pham, if you could stand up, please, so that Mr. Nelson can swear you in. Okay. The way that this will work is Ms. Bradley will have an opportunity to present her case to the State Board, and after she's finished and summarized what she's doing, then it'll be an opportunity for you to present your case and tell us your side of the story, and then we'll decide from there. Okay? Ms. Bradley?
Ms. Marsh, I think you previously testified that you are, what's your job title with the State Board?
Field and Office Assistant 1.
And as part of your duties as Field and Office Assistant 1, did you issue the citation in this case?
Yes, I did.
And can you tell us about that?
I was doing routine inspections, and Van Nels was on my list because it was a first inspection. They had changed.
Is your microphone on?
I'm sorry. No. I was doing a routine inspection, and Van Nels was due for a first inspection because they had changed to skin and nail service from nails. And when I walked in, they had their old license for just nails only posted, which had already expired. And she couldn't find the new license. And she looked for quite a while and still couldn't find it. And that's when I issued the citation for not posting the license, the salon license. And it was a first citation for $200.
Okay. And so the license was current, it just wasn't posted?
Yes, the new license.
Okay. May the record reflect that I'm showing the respondent what's been pre-marked as Vonda Nails Exhibit 1. Do you have any objection to those documents being admitted into evidence? I believe that's the letter that was sent to you regarding the citation appeal and your answer and consent decree and the citation and the report of establishment.
Could you please press the microphone button in front of you so we can hear you? Thank you.
Okay. I think in my case, because of my English is not good and something I don't understand clearly, something I receive it.
So right now, you just need to answer Ms. Bradley's question. If you have any objection to the documents that she just showed you, have you seen them before?
Yes.
Okay.
When she come to my my shop for.
Excuse me, I can't hear her very well. Can you speak in the microphone, please?
So right now, all we need to know is if it is okay for the documents
Yes.
to be entered into the record, to be presented to the board.
Yeah.
It'll be your turn in just a second.
Charlene, could you pull the mic maybe closer to her so that we can hear
It's attached.
Get their mic on.
Okay, so if we have a situation like this where it seems like there's a little bit of lost in translation, how do we move forward? Or do we need to postpone this case until such time as she can have a translator so she knows what's going on?
As of right now, there hasn't been a request for one. So you would be...
Sorry. If she needs, I don't know how it works, but if you can ask Ms. Bradley, because she is Vietnamese and I am also Vietnamese, I could understand or help out. I don't know how that would work.
But she's a board member, so how does that? play out.
Mr. President,
Yes, sir.
if you will, we have been through this many times in our board meetings. These respondents or complainants or appellants have been advised that if they need translation services, to provide those and bring them on the date of their hearing. This has been a constant struggle for the board, and it is very clearly outlined that if translation services are required or necessary, that that person should be bringing that translator with them. If this individual has chosen to attend this hearing without translation services, the hearing should proceed.
Okay.
She did not understand the information she was given that she had a translator or could bring a translator. Would that be problematic, or would we be able to postpone?
My question would be, if you're practicing in the state of Nevada, that then they should understand what the laws and the rules are, and if they couldn't understand the paperwork that was sent to them, that they should go and take it to somebody that can help them with that, so that they would understand they had the right to the translator. So I think we've done our part, and I think that the hearing should go forward myself.
I agree with that.
I agree.
Okay. So we were about to enter into the record the documents that you were discussing, Ms. Bradley.
Yes. So it sounds like, I don't know that she has an objection to them being admitted, so I'd ask that they be admitted.
So admitted.
And I have no further questions for Ms. Marsh.
Okay, so you're resting?
Well, I think it's time now for the respondent to question her, and then the board.
Okay. Now is your opportunity, Ms. Pham, to have any questions of Ms. Marsh with regards to her inspection of the salon on the date in question?
Oh, no, I don't have any question with Ms. Mark. I only talk about my case because this time, because sometime happened to my health from the July. I go to check up for my health, and then there is something happen, make me very worry about, and like make me have the bad memory. I go to the doctor office. I forgot the whole thing in the envelope, and then when Mr. Mark come, and then I don't know where I put my new license, and then I ran to the office. I make the new license. About 2 days later, they sent to me whole envelope like that, and then I put whole my license in here. That's all.
Okay. Do we have any questions for Ms. Pham?
I do. You are the salon owner?
Yes.
Okay. So you understand that you do have to have your license posted?
Yes.
Now, if you get sick, is there somebody that steps in and covers for you?
Like that, because when I receive my new license, and there are some work that let me have to call the office before I am ready. But because I renew my license, like my salon is open, I don't know why I have to call, because I should add a new service. I really don't understand that. I put the envelope in my cabinet. I put right there.
Okay, my question was, do you know you have to have that license posted?
Yes.
And do you have someone that covers for you when you are sick? Do you have who deposits your check, oversees the salon when you're sick?
Oh, I still working.
You still work, so you were still coming in.
Yeah.
Okay, thank you.
Any other board members have any questions for Ms. Pham?
Mr. President, Ms. Pham,
Yeah.
it sounded like you said that you knew that your license was not posted because it was in an envelope in a cabinet.
Oh, no, like that, because I want to let my daughter call the office and ask because they said when I ready for work about I think for work about skincare, but I'm not ready for skincare. Even I apply for open more one service. That's why I still put my envelope in the cabinet. And then when someday I grab the more something in my cabinet, go to one, and then I go to the doctor. I let all of them. That's why when she come, I don't have the license right there.
You didn't have the license available when she came?
Yes.
Thank you.
Can I make a motion?
No, I think at this point what we need to do is figure out if the cases are going to be summarized, and then we can find the findings of facts. So, is there anything else, Ms. Pham, that you want to add? A closing statement, perhaps, that you want to give us? Anything
No,
like that?
I just want because I am a person always obey the rule. I'm not do something wrong or something like that, because this time I think because something many things happened to me, make me like that. That's all.
Okay. Ms. Bradley, is there anything else you'd like to add?
I would just ask that the board uphold the citation. I believe Ms. Marsh's testimony, as well as actually Ms. Pham's, does support the fact that when Ms. Marsh was at the salon on that day, the license, the current license was not posted, and in fact it was the previous license that was actually expired. And so I'd ask that you uphold the citation. Thank you.
Now I'll entertain a motion for the findings of fact.
I make a motion to uphold the findings of facts on CM 224, case number C13732.
I'll second that.
So I have a motion and a second. Is there any discussion? Okay. Those in favor?
Aye.
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 Those opposed? That motion carries.
Mr. President, I'll make a motion that the fine be upheld.
I'll second.
Okay, so we have a motion on the table to uphold the fine and a second. Any discussion beyond that? Okay, so those in favor?
Aye.
Those
Aye.
opposed? Nay. That motion carries. Okay, so the State Board will be in touch with you. You'll receive a notice in the mail with regards to your fine. Thank you so much, Ms. Pham. Okay, item number 9 on the agenda is Dainty Nails.
Mr. President,
Yes, sir.
I'm anticipating this being a longer matter, the rehearing. May we take a 5-minute recess?
Okay, so we're going to do a little 5-minute break, and we'll be back at 9:49. Okay, so I'm going to call the meeting back to order at 9:51. The board will consider disciplinary hearing for case number C12-244 being reheard. The complaint notice of hearing was originally filed with the board in April of 2012. Okay, so do we have everybody present for the case?
Yes. I am Michael Mateska.
The mic button.
Michael Mateska. I'm here with Maria Trian, who is the owner of the Dainty Nails Salon, and her daughter, Jenny Trian, who works with her at the Dainty Nails Salon.
And then Mr. Nelson, I believe you need to swear everybody in, yes?
And this is Mr. Jeff
And
Green.
Mr. Jeff Green for the State Board. Thank you, Jeff.
You and each of you would raise your right hands. You solemnly swear the testimony you're about to give before this board to be the truth, the whole truth, and nothing but the truth. Yes.
Mr. President?
Yes, sir.
Before we begin, I have a couple of questions, if I might, please.
Okay.
I just want to be very clear that as the immediate past president, I was the individual that signed the order denying the request for reconsideration, and I signed to grant this request for the rehearing. I want to be very clear about that.
Okay.
Thank you.
Duly noted. Was there something else that you wanted? Okay. Okay, so in a rehearing of the case, I imagine it moves forward the same. Ms. Bradley, you're going to be starting?
Yes.
Okay.
I would first call Mr. Jeffrey Green. Mr. Green, would you please state your name and spell your last name for the record?
Jeffrey Green, Green.
And who is your employer?
Nevada State Board of Cosmetology.
And what is your job title?
Inspector 2.
And how long have you had that position?
It'll be 6 years in December of this year.
And have you had training regarding your position?
I have.
Can you tell us about that briefly?
I had training in an investigative technique, Nevada laws, statutes, inspections, computers, those type of things.
And did you start out were you promoted to the current position that you have?
I was.
And when was that promotion? Do you recall?
Maybe 2.5, 3 years ago.
Okay. I would first like to admit, I'm going to show the respondent's attorney what's been pre-marked as State's Exhibit 1. It's just the complaint and notice of hearing in this case. Just so that we have a clear and complete record, I would ask that that be admitted. Do you have any objection to that?
No objection.
So admitted.
All right, and Mr. Green, I'm now going to show you what's been pre-marked as State's Exhibit 2. Do you recognize these documents?
I do.
And what are they?
These are the front sheets from the license folder for Dainty Nails, Louis Tran, and Huang Nguyen.
And does it tell you the date that those were printed?
All three were printed March 17th, 2012.
And is that something that you normally do when you start an investigation, as you review your file records?
Yes, check the board records, yes.
Okay. I'd ask that State's Exhibit 2 be admitted.
No objection.
So admitted.
All right, so Mr. Green, did you do the investigation for this case?
I did.
And can you tell us about how that happened?
We received a written complaint from Nancy Hall complaining that she had contracted MRSA from a nail service at this salon.
And so when you received the complaint, what did you do?
When I first received the complaint, I staffed it with Ms. Curtis, our chief inspector, as well as Mr. Jimno. I spoke to Ms. Hall on the phone. I reviewed all of the board files. I took a preliminary statement over the phone from Ms. Hall and made arrangements to interview her in person, and looked at the medical documentation she had provided, as well as after I contacted her, she had her attorney from a civil matter send additional photo documentation.
And so when you say you staffed it, what does that mean?
Well, basically, Ms. Curtis and I would read the written complaint, look at the medical documentation, sit down with the executive director at the time, Mr. Jimno, and go over the facts of the matter as they were at that moment.
Okay. So I'm now showing you what's been pre-marked as States Exhibit 3. Is this the complaint that you're referring to, that you received?
Yes, this is the complaint we received from Nancy Hall, the written copy.
And does it appear to be a true and correct copy of what you received at that time?
It does.
And it looks like there's some additional attachments. There's the handwritten portion, and then there's some typed out narrative.
Correct.
Do you recall receiving something like that?
Yes.
I'd ask that States Exhibit 3 be admitted.
So, do you have any objections, sir?
I would stipulate to its admission for the limited purpose only of showing that this was sent to Inspector Green, but I would object to admission for any other purpose, especially since Nancy Hall apparently is not here today and I won't be able to cross-examine her on the contents. So I don't think this can be admitted for the truth.
And your response, Sarah?
Well, my response is that hearsay is admissible in an administrative hearing. It can't be the sole determining factor that the board uses to find anyone's guilt, but hearsay is admissible, so I'm going to object to any limitation being placed on the complaint. Further, the complaint is a sworn complaint. It's sworn, and then in addition, I will be admitting testimony from Ms. Hall that was previously recorded at the previous hearing, and she was sworn at that time, and the respondent was present, had opportunity to cross-examine at that time. And being that Ms. Hall is now outside the state, she's outside the jurisdiction of the board, and so we couldn't require her to be here today, but there is that previous statement that I think will corroborate this as well. So,
can I follow up on that?
Okay.
It's not just a question of hearsay, it's a question of the right to cross-examination. This is a rehearing. It was her decision not to testify in support of her own complaint. So I don't think the issue of unavailability means that we get to submit her written statements without the ability to cross-examine her, and for this board to ask her questions today.
I'm not trying to admit her statement currently. I'm just wanting to admit the complaint, and I'm objecting to any hearsay objection on the complaint because, again, hearsay is admissible in an administrative proceeding.
Mr. President, I had a question regarding this. Are we to keep in mind the previous testimony from May 21st
Not at this
of
time.
2012?
Not at this time.
So the information that we have from that meeting, we are only making our decision from today's meeting?
Not at this, yes.
Thank you.
Okay, so your motion to admit, it was item number what? I'm sorry.
It's what's been pre-marked as States Exhibit 3, and it's the complaint from Ms. Hall that the board office received.
Okay, so admitted. Well, we're establishing that we're just admitting it into evidence, right?
And Mr. President, I do have another question of the Deputy Attorney General. If we are not to be taking into account previous testimony from the May 21st, 2012 hearing, we were also presented with a notice and a petition for judicial review, which on page 2 does make some claims listed under item 4, A, B, C, D, and E, which reflect that testimony from that date. That is part of our board agenda packet. That means it was posted for public record.
Okay.
And so what do we do with that information?
Okay, at this time, what is before you is, what's happening now is they're introducing evidence as it comes along, and so the prior documents haven't been introduced at this moment in time. So at this point, I would hold off on those questions and allow them to proceed with each of their cases.
Okay. Even though they're going to be referencing May 21st, 2012.
It's possible that they will be referencing that in their case in chief. However, at this time, nothing has been introduced into evidence before the board regarding that particular hearing.
Even though it's part of our packet, public record packet. Isn't that being introduced?
All that's in your packet is the notice that the order granting the rehearing. So, and I think the request for rehearing, that's there just for background. That it just was included. Those are public documents, but you don't need to worry about those. Your decision is on the evidence, which is the exhibits and the testimony you're going to hear today.
Okay, thank you.
So, though you stipulated that you wanted to amend what Sarah was admitting into evidence, we're going to go ahead and admit it as is for its full purposes.
I understand. Thank you.
So, Mr. Green, you said you were investigating the complaint, so you spoke to Ms. Hall by phone, and what else did you do?
I spoke to Ms. Hall by phone. I reviewed the file for the salon, for the licensees, gathered all the information. I made an appointment to meet with Ms. Hall at the Reno office. And I received contact from her attorney. Like I said, she sent the photo documentation along as well. I did some online research as to MRSA and pulled some documents off of the CDC website. I also contacted the state epidemiologist, Dr. Azam, and sent him an email to ask some general questions about MRSA and how it is contracted.
Okay. And so was the next step in your investigation the appointment with Ms. Hall at the Reno office?
Yes.
And can you tell us about that interview?
Yes, on March the 14th, I met with Ms. Hall and her husband at the Reno office. She basically reiterated the elements of her complaint, indicating that on November 1st, 2010, she went to the Dainty Nail Salon. She said she had been there 3 or 4 times in the past for nail services as well. She indicated that her usual nail tech was Louis Tran, and when she entered the salon, Mr. Tran had a client at his desk, and that he had requested that his wife, Miss Nguyen, begin to remove the old acrylics from her nails. She said, Ms. Hall indicated that she sat at the right rear nail station in the salon upon entry. She sat down at Ms. Nguyen's workstation, and Ms. Nguyen took a Dremel tool with a hard sandpaper type of bit and began removing the old acrylics. She indicated to me that she couldn't make an assessment as to whether the instruments at that time were clean or had been sanitized. She did recall the workstation to be dusty on that date. She said that Ms. Nguyen began drilling on her left index finger and that there was a dark line on the nail which she believes Miss Nguyen was trying to remove and ultimately drilled a little too deep and went through the nail bed. She said that she flinched and kind of pulled her hand back. Miss Nguyen asked her if it was hot, and she said that it was. She further indicates that after about 5 minutes, at this point in time, Mr. Tran had completed his service with the customer that he had at his table, the adjacent table, and Ms. Nguyen had also finished removing the old acrylics. So at that point in time, she got up, moved to Mr. Tran's station, where he began applying the acrylics. She indicated to me that she had no pain, she didn't see any blood, there was no discomfort at this time. I asked her about Mr. Tran's station and tools. She indicates that he took the tools from a plastic box in the drawer of his station and applied the acrylics to her nails. She could not make an assessment if the tools were clean or had been sanitized, or she didn't recall if Mr. Tran washed his hands between completing the service with the previous client and beginning to work on her. Ms. Hall indicated that 2 days later, she experienced swelling in the first joint of her left index finger. She soaked it in Epsom salts. She said on November 3rd of 2010, she returned to the salon, showed her finger to Ms. Nguyen, who removed the acrylics and gave her a bottle of what she called Chinese oil to apply to the swollen area. I showed Ms. Hall the license photos of Ms. Nguyen and Mr. Tran, and she identified them as the two people who had worked on her on that date, November 1st, 2010. Ms. Hall indicates that on November 7th, she ended up going to the Carson Valley emergency room, and she began her medical treatment, which is extensively documented in that exhibit with her information on there. One thing I noted in the medical documentation, she saw a Dr. Robertson, and there was an entry on the chart that I reviewed from Barton Memorial Hospital, where in the patient history, Dr. Robertson noted that, in quotes, she said that she may have trimmed her fingernail too short. I asked Ms. Hall about that discrepancy. She indicates that was a misunderstanding on the doctor's part, and she was actually telling the doctor that the nail tech trimmed her fingernail too short. Ms. Hall further stated that her medical ordeal was very long and arduous. On this date, March 14th, when I met with her, I did take a photo of the current status of her finger. I asked her why the delay. We had not received this information till more than a year after her medical treatment and the incident occurred. She indicated that her attorney had sent a few letters to the salon owner to pursue the payment of medical expenses, but could not get any response from the salon owner to these letters. She said that's the reason a lot of time transpired. She was trying to work this out. And that was basically it.
Did you take a photo of Ms. Hall's hand on that day?
I did.
So I'm showing you what's been pre-marked as State's Exhibit 4. Do you recognize that photo?
Yes, this is the photo I took March 14th.
Okay, and that's a true and accurate depiction of what her hand looked like on that day?
Right, I asked her to put her left and right index fingers next to each other and took a comparative photo.
Okay. I'd ask that State's Exhibit 4 be admitted.
No objection to Exhibit 4.
I'm going to hand the board out black and white copies. I do have a color copy if anyone wants to see it, but I just have one.
So admitted.
So on the same day that you met with Ms. Hall, did you also then go to Dainty Nails?
I did.
And can you tell us about that visit?
Yes, I went with Darlene Scott, an inspector from the Reno office, and we went to visit Dainty Nails to conduct an inspection, and I also met with the owner, Maria Tran.
And do you recall if Ms. Tran is the same Ms. Tran that's here today?
Yes.
Okay.
Yes, she is.
And so you talked to Ms. Tran, and what did she tell you about this incident?
Ms. Tran indicated that she was aware of the allegations from Ms. Hall. She indicated to me that Louis Tran is her brother and Ms. Wynn is her sister-in-law. She said that in June of 2011, they had stopped working at the salon, moved back to California. I think she said that Louis then was working at a salon in Carson City. She indicated anecdotally that what Louis told her about the incident was Ms. Hall had come in on that date, and he saw infection in her finger. And she said that Louis indicates to her that he told Ms. Hall she should not be putting any acrylics on her finger until the infection is gone. But Ms. Hall indicated to Louis that she had to get her nails done since she had to attend an event with her husband that evening, and that she promised to come back in a few days to remove the acrylics. Ms. Tran said that Louis told her he reluctantly agreed and did as Ms. Hall requested. And we verified mailing address and et cetera. And then Ms. Scott conducted an inspection of the salon.
Okay. I'm showing you what's been pre-marked as state's exhibits. It's actually 5 through 6. Do you recognize those documents?
I do.
And so I believe the top document might be the report of establishment that Ms. Scott completed on that day?
Correct.
And so what did she note in her inspection?
Okay, on March the 14th, the inspection was conducted, and the following were areas of concern where the requirements were not being met. The floors needed to be swept behind the Petit Spa area. The Petit Spa chairs, there's a note, please clean the basins. Workstations, the workstation number 4, which is at the right rear station in the salon, had behind the station a box with dirty drill bits sitting in an open container, and I looked at those as well because that was the station where Ms. Hall was alleging the incident took place, and I did see the drill bits in the box with like residue powder on them, and in the box as well. She further noted that cuticle nippers and clippers were left in an open container at that same station. She saw a Credo blade holder in a container at the second station.
So when you say there were dirty drill bits in an open container, what's supposed to happen with the drill bit after it's used?
Well, the drill bit is a metal item, and after it's used, it needs to be sanitized and disinfected before it can be offered to the next client.
Sure. I'd ask that states 5 through 6 be admitted. Just so before we do that, Mr. Green, can you tell us what the second and third pages are of that document, just so the board knows what they're going to be seeing?
The second inspection is dated August 19, 2011, and this inspection was conducted by Ms. Marsh, and
then there's a last page. I think that's a different date for an inspection. November 17, 2011.
there's another inspection dated 11/17/2011 done by Ms. Scott, and this inspection does not appear to find any problems.
Okay. I would ask that states 5 through 6 be admitted.
No objection to 5 and 6.
So admitted.
And just so the record's clear, Mr. Green, do those exhibits reflect a true and correct copy of what's in the board's file for those inspections?
They do.
All right.
Excuse me. Hello. I'm sorry, but I don't have any of the documents that you're talking about, the inspections or anything in my folder. So,
and I apologize for that. That's because you can't see exhibits until they're admitted on the day of the hearing. And I know that you weren't planning to be in Las Vegas this morning, and so I apologize. I'm not sure if there's an easy way to get copies of the exhibits to Las Vegas, because they're...
I believe LCB has a fax machine that we may be able to utilize.
Okay.
To that room or somewhere nearby, we can...
If I can offer, I'm not sure it's going to be an issue. We aren't really contesting the contents of those inspection reports.
I think she
anyway.
just wants the documents in front of her.
That's okay.
So we'll do what we can. I'm sorry, Ms. Tran.
Her last name's Tran, right?
Mr. President, Ms. Tran,
yes.
were you provided with the prior meeting minutes of the prior hearing? No. I mean, and were you aware of the multiple citations for this salon? Was that?
Yes.
And so if we just gave you the dates and the content of the paperwork that Ms. Bradley is providing us, would that facilitate you for the time being?
I think your board counsel is
That's fine.
trying to get the
But I just
documents there, and I apologize for that. We'll work on that.
All right.
Dead air. Probably take a recess. Well, I was thinking of that too. If there was a way that somebody could take a picture with their cell phone and send it to her. Yeah, how many more documents? You have a whole stack of documents. Okay, so that's probably not going to work then. We need to at least fax it.
So the exhibits that have been admitted thus far will be faxed down through LCB staff. I believe it will come directly to that room. So just be aware that LCB staff is going to be faxing it down.
I was going to offer 2 very short exhibits also.
Yeah. We'll be slowly trying to use LCB staff to try and get those documents down there. They're graciously allowing us to do that. Ms. Tran, are you okay with us continuing on before you have the documents?
Yes, go ahead. Yes, go ahead. Yes, she's going down there to grab it for me right now. Thank you.
Miss Bradley.
Okay. So, Mr. Green, so I think we just finished talking about what happened at the salon when you talked with Ms. Tran and inspected the salon that day. Did you also speak to Mr. Tran that day?
I did. After we left the salon, we went to the salon in Carson City where Mr. Tran was working at that time.
And so can you tell us about the visit that you had with Mr. Tran?
Yes, I inquired if Mr. Tran recalled the incident. He said he did recall Ms. Hall coming in to the salon on November 1st of 2010. He indicated to me that he had worked on her maybe 3 or 4 prior occasions. He recalled that on the date when she came in, November 1st of 2010, he indicated that he saw what he called a green fungus infection in her finger, and he advised her not to get acrylics applied. He told me that Ms. Hall indicated to him that her husband had a party they had to attend, and if Mr. Tran would apply the acrylic, she would come back and have it removed in the next few days. And Mr. Tran indicated to me that he reluctantly agreed. He applied the acrylics after his wife prepped Ms. Hall.
And did you ask him if he's aware of the sanitation and infection control rules and regulations?
I did. I asked him if he was aware of and practices all sanitation and infection control procedures. We had a short conversation reviewing cleaning, sanitizing instruments between clients, and he indicated that he was aware of all of that.
And then did you also speak to Ms. Nguyen?
I did speak to Ms. Nguyen 2 days later by phone. She indicated to me that she was currently living in California. She updated her address. She also indicates that she recalled the incident on 11/1/2010. She indicated that she was prepping Ms. Hall for her husband to do the nail service, and while she was removing prior color and acrylics, she indicated that she saw the nail to be red. She said that she was sitting at the station next to her husband, and she informed him in Vietnamese that Ms. Hall's nail was red. And at that point, she indicates that Mr. Tran advised Ms. Hall against getting her acrylic service, but Ms. Hall insisted that she had to attend a party with her husband that evening and would come back and remove the acrylics after the affair.
And did you also ask her if she was aware of and practices all sanitation and infection control procedures and rules?
I did.
And what was her answer?
She indicated that she was aware and she does practice all proper sanitation and infection control procedures.
Okay. And as a part of your investigation, I believe you testified previously that you looked up MRSA on the Centers for Disease Control and Prevention website. I'm showing you what's been pre-marked as States Exhibit 7. Do you recognize that document?
I do.
And what is that?
These are documents that I printed off of the Center for Disease Control website that talks about MRSA, how it's spread, just general overview of what MRSA is.
And as a part of your training with the board, were you already somewhat familiar with MRSA?
I had limited knowledge of it. We had never had a case before where an individual came forward alleging they had contracted MRSA from a service. So I tried to learn a little bit more about it.
Okay. I would ask that States Exhibit 7 be admitted into evidence.
No objection to Exhibit 7.
So admitted.
And I think you also testified that you spoke to Dr. Azam, who works for the state as the state epidemiologist.
I emailed Dr. Azam.
Okay. I'm showing you what's been pre-marked as States Exhibit 8. Do you recognize that document?
I do.
And what is that?
This is, the top page is the response I received from Dr. Azam, and the bottom page is the email I sent to him asking some questions.
Okay. And so do you recall what you were asking him, or does this refresh your recollection about what you asked?
Well, on page 2, my email to Dr. Azam was basically, do you want me to read it? Or?
Well, if you could just summarize it.
Okay. I indicated to him that we had a member of the public who was coming forward alleging that she had contracted MRSA from a manicure service at a salon in Gardnerville. She indicates that the nail tech had drilled through her nail bed to the skin, and I told him that we had certain facts that we could establish at that point. There was a manicure that took place in the salon November 1st. By November 3rd, her finger began swelling, became painful, and on November 8th, she went to the hospital, and I included the diagnosis from Dr. Robertson and post-op treatment. And then I concluded by saying to Dr. Azam, my question for you would be based on the timeline, based on the scenario presented, is it conceivable, possible for this MRSA infection to have been contracted at the nail salon on the date indicated? And
And what was his response?
His response was the lengthy answer on the first page where basically he said that the conditions in a nail salon could establish that it's possible. The timeline could establish that it's possible. But barring actual physical evidence of MRSA at the salon and tying that to Ms. Hall, we couldn't say with 100% certainty.
Okay. I would ask that State's Exhibit 8 be admitted into evidence.
Any objections?
No objection to Exhibit 8.
So admitted.
Okay. And then as a part of your investigation, Mr. Green, did you look through the board file to determine whether there had been any previous citations or inspections noting concerns regarding dainty nails?
I did.
And could you summarize what you found for the board?
With regard to citations, I found that on February 14th of 2007, a citation was issued to Julie Tran for working without a license and to the salon owner Maria Tran for allowing the unlicensed activity. And on that date as well, a citation was issued for the salon being open and serving the public with no licensed person present. I further found that on May the 30th of 2007, another citation was issued to Julie Tran for unlicensed activity, second citation, and a second to Maria Tran for allowing the unlicensed activity. They both were second violations under that license number. And there was also a citation issued on that date for the salon not having hot water. On October of 2007, a citation was issued for operating the salon on an expired establishment license. And then on February 12th of 2010, citations were issued to Larry Tran for unlicensed activity and to the salon owner Maria Tran for allowing the unlicensed activity. This was a first offense for Larry Tran, who was the person who worked on Ms. Hall. And it was a first offense for Maria Tran because the salon establishment had changed licensure and was under a new PIN number at that time.
Okay. And then can you tell us about the prior inspection history that you found in the board file?
Yes, in researching the inspection history, I found February 24th of 2009 inspection noting the following deficiencies. Instruments and brushes were not being properly stored. Clean towels not stored in a closed cabinet with a fumigant. At that time, the salon license was for skin and nails, but they didn't have anyone licensed to do skin services, working there only nail techs. And then 2 days later, the license changed back. The owner applied for a nails-only license. And this was conducted by Charlene Marsh. August 5th of 2009, deficiencies noted were instruments and brushes not being properly stored. This was also done by Charlene. November 19, 2009, deficiencies noted were nail tools and brushes not being properly stored. The inspector at this time was Hope Costanza. February 12, 2010, deficiencies noted were nail tools, brushes, and drill bits not properly being stored. A citation was issued for unlicensed activity on that date, also by Ms. Costanza. June 3 of 2010, deficiencies noted were petit spa bowls were not properly cleaned, and this was done by Inspector Costanza as well. October 15, 2010, deficiencies noted were manicure tables, stations were not being properly cleaned between clients. Implements, instruments, and tools were not stored properly. Clean towels were not properly stored. Inspector on this date was Charlene Marsh. March 31, 2011, deficiencies noted were a inoperable petit spa chair and bowl. Restroom door was locked, not accessible to the public. The salon was not using dry fumigants where they stored their instruments, clean instruments. The floors were not clean. Single-use items were being reused. The salon at this point was licensed for nails only, but Ms. Marsh, who was the inspector, observed evidence of waxing equipment that seemed to have been used in the salon. Next inspection, August 19, 2011, deficiencies noted by Ms. Marsh were petty spot bowls and drains were not properly cleaned, nail brushes were not properly stored, clean towels not properly stored, trash cans were not covered, and Ms. Marsh still was observing waxing equipment for skin services. She noted an esthetician's bed, linens, and wax setup, and the salon was licensed for nails only at that time. March 14th, 2012 was when I was there with Ms. Scott, and Ms. Scott noted floors were dirty behind the spot chairs, the petty spot bowls were not clean, the dirty drill bits in the open container at station number 4, cuticles, nippers, and clippers were not in a closed container at station number 4, and she observed a Credo blade holder at station number 2, but didn't see the blade there.
So I'm now showing you what is NRS 644430, and I was wondering if you could look at 1K for me. Are you familiar with that provision?
Yes, I am.
And could you tell the board could you read that for the board? So read
The
number 1 and
following-
then K.
The following are grounds for disciplinary action by the board. Any other unfair or unjust practice, method, or dealing which, in the judgment of the board, may justify such action.
Okay. And in your experience as an inspector with the board, are you aware of sometimes, have you seen salons attempt to save cost and not employ proper sanitation procedures?
Yes.
And can you tell us about examples that you've seen?
I'm going to object. I'm going to object that line of questioning. Unless there's evidence about cost cutting, it's really just a supposition, and quite frankly, prejudicial. There's no testimony about cost cutting here.
Well, that's what I'm trying to elicit by this questioning. One of the allegations in the complaint violation, the 5th claim for relief, is that respondents have engaged in an activity that is unfair or unjust practice, method, or dealing, and which is grounds for disciplinary action pursuant to NRS 644430-1K. Mr. Green has been an inspector with the board, has been trained, has done, I can ask him in an offer of proof how many inspections he's done. I think he's familiar with what sometimes people do in salons in an attempt to save money, and which is why they're not following sanitation. So I think he's qualified to answer the questions, and the questions are relevant to the complaint.
What he sees in other salons is just a supposition of what he thinks happened here. And unless there's some evidence of cost-cutting measures, then I think that line of questioning is irrelevant and quite frankly, it's prejudicial.
There has been, again, testimony put forth by Mr. Green about extensive previous citations as well as sanitation reports. And so I want to ask him what his opinion is on why this might happen in a salon. I think he's qualified to give that expert opinion.
Same, it's irrelevant unless there's evidence that happened here.
Yes, but in the previous hearing, no? Okay, well, for the purposes of this hearing, the 5th claim of relief is to establish whether or not it's an unfair, unjust practice, method, or dealing. So you're
right, and there's been no testimony about that. What she's asking him to do is to testify about unjust dealings in other salons, and unless they can establish a link here, it's irrelevant, prejudicial.
I believe Ms. Bradley is trying to attempt to lay that foundation to see how it applies to the particular case at hand.
But there's been no evidence about how it applies to the particular case.
And I'm trying to ask him those questions right now.
Mr. President, Ms. Bradley, is there any other reason why they would be doing this other than just for cost savings?
Well, I can't answer that, but I'd like to ask Mr. Green that.
And with the repeated history of unlicensed activity, is that an indicator that this establishment was attempting to save costs?
That's what you're here to determine.
Okay, so your objections are noted. Thank you. And overruled.
So, okay, Mr. Green, in your experience, why would a salon have unlicensed individuals working? I mean, you can give us all the reasons that you might be aware of.
Well, I would imagine that, salons would have unlicensed people because it would save money. To get somebody who is licensed, has gone to school, is properly credentialed and trained, might cost more money than to get a family member to work there who is not licensed.
And for example, I think some of the citation or some of the inspections here noted that single-use items were being reused. In your experience, why would a salon reuse a single-use item?
Well, I can only assume it's to save money. If you have a nail file and you know that according to the regulation, you use it on one client and then the regulation stipulates that it has to be immediately discarded. So if you put it back in the drawer and reuse it, I imagine it's a cost-saving measure. And the same thing with instruments that can be sanitized and disinfected. You know, when you're in a salon and you have one client after another and an owner doesn't allow for time in between services where the operator can get up, wash their hands, take their instruments to the sink, or obtain a new set of instruments that have been sanitized and disinfected. Again, it's churning the clients and not allowing for that brief moment to take the necessary precautions to protect the public.
And I think there was another note from October 15, 2010 regarding manicure tables and stations not cleaned properly between clients. Would that be the same reasoning?
I would imagine so. When, like I just indicated, when you have a client at your station and you have another client waiting, it takes those few moments to get up, clean your station, and wash your hands, sanitize the instruments, throw away the single-use items, the necessary precautions that are in place to protect the public. And if you don't take those few moments and you hurry the next client to your station and you begin the service, I think it places the public at risk of harm. And the only logical explanation I could see is to save money and let me hurry up and get that next client, through here.
So in your opinion, would that then possibly fall into an unfair or unjust practice method or dealing that the licensee and or the establishment is employing?
Most definitely. I would think it's unfair and unjust to the public, and it's unfair to the other salon owners who have those safeguards built into the work that they do. And it doesn't allow for a level playing field when you have one salon having unlicensed people and not following the regulations, and everybody else is trying to follow them.
Thank you. I have no further questions for Mr. Green at this time.
Do you have any questions for Mr. Green, sir?
Yes, please. Thank you. Mr. Green, just so I'm clear, did you make any conclusions on whether Nancy Hall became infected with MRSA as a result of the nail service she had performed on November 1st of 2010?
No.
Did you make any conclusions on whether her finger was already infected when she came for the nail service on November of 2010?
For that, there was conflicting testimony. So I couldn't make a conclusion because I had Ms. Hall indicating that her finger was fine, and I had the two licensees indicating that they saw a problem on her finger.
Do you have any more information or evidence to submit to the board today to corroborate Ms. Hall's testimony that she acquired MRSA as a result of the nail service on November 1st of 2010?
Do I have any other evidence?
Yes.
Is that what you're saying? I don't have any evidence other than what Ms. Bradley is presenting.
And isn't it true that the only evidence you have that Ms. Hall may have acquired MRSA as a result of her nail service on November 1st, 2010 is Ms. Hall's own testimony?
We have Ms. Hall's testimony, and we have the state epidemiologist indicating that the factors were present for it to have happened. Not substantiating it 100%, but saying that the environment and the timeline met the story that was being presented.
Would you agree with me that a finding that Louis Tran performed a nail service on somebody with an infectious disease on November 1st, 2010 would preclude the contrary finding that Louis Tran's nail service on November 1st of 2010 caused the infection?
I don't understand the question.
Do you have a copy of the complaint, of the board's complaint with you? Okay. Could you please turn to page 7? Do you see the violations being alleged on page 7?
I do.
You see the first claim for relief, then there's a second claim for relief, and then the third, fourth, and fifth claims for relief continue on page 8. Do you see that?
I do.
Can you read that first claim for relief just real briefly for me, please?
By failing to employ proper sanitizing and/or infection control procedures, respondents violated NAC 644-340, which is grounds for disciplinary action pursuant to NRS 644-430-1A.
And would you agree with me that first claim for relief is not alleging that Ms. Hall contracted MRSA as a result of the nail service on November 1st of 2010?
Well, I don't see any reference to MRSA in the claim.
Or November 1st of 2010, right?
Oh, and I don't see November 1st, 2010.
And no reference to Nancy Hall?
Correct.
Okay. Can you...
Excuse me, Mr. President, could the Attorney General respond to that question? I didn't understand that question that Mr. Green just answered. Could you just repeat that back from the record so I could have a further clarification of that question? Because I didn't get that question. Mr. Green is not making a decision regarding these claims of relief. That's a board responsibility. Mr. Green isn't authorized to make a determination whether or not the first claim of relief was violated or not. And so I'm not quite sure why he's answering a question which he's not qualified to answer.
I think there's a good deal of confusion on this part, at least, about which the allegations are. Quite frankly, I'm not even clear if the allegations are that Ms. Hall contracted MRSA as a result of...
I think the allegations are very clearly stated, and so if I could just have that question read back to me so I can understand what Mr. Masuka's question of Mr. Green was.
So I think you want the court reporter to do that for you.
Question, do you see the first claim for relief and the second claim for relief and then third, fourth, fifth claims for relief continuing on page 8? Do you see that? Answer, yes, I do. Question, can you read that first claim for relief just real briefly for me, please? Answer, by failing to employ proper sanitizing and/or infection control procedures, respondents violated NAC 644.340, which is grounds for disciplinary action pursuant to NRS 644.4301A. Question, would you agree with me that first claim for relief is not alleging that Ms. Hall contracted MRSA as a result of the nail service on November 1st of 2010? Answer, well, I don't see any reference to MRSA in the claim.
Thank you. Ms. Bradley, is that an appropriate question to be asking our inspector?
He can ask him whatever he likes about the complaint. And Mr. Green's job is to answer the best he can under the oath that he gave.
Thank you.
Can you look at the second claim for relief, please?
Yes.
Without asking you to read that aloud. When you read that, does that claim, at least in your mind, relate to Nancy Hall's allegation that she contracted MRSA on November 1st of 2010 as a result of the nail service?
I didn't write these claims for relief. I'm not an attorney. They were written by the Attorney General's office. I have to agree with Mr. Leader. I can speak to the facts of the case, to the investigation, to everybody I spoke with. I can't speak to the legality of these claims for relief. Maybe Ms. Bradley can answer these questions. I mean, if you're asking me if Ms. Hall's name is in this paragraph, no, it isn't.
I need to go a little further. Just please indulge me a little bit. And actually, that second claim for relief alleges that someone at Dainty Nails performed a nail service on a client with an alleged infectious or communicable disease, right?
What is the question?
Do you see any of these claims for relief which are based on Nancy Hall's claim that she contracted MRSA as a result of the nail service on November 1st of 2010?
You're asking me, do I see Ms. Hall's name in any of these claims for relief?
Do you understand what's being alleged in those claims for relief?
Yes.
Okay. Then, based on your reading of those claims for relief, do you see any allegation that Ms. Hall contracted MRSA as a result of the nail service performed on November 1st of 2010?
Let me see. Again, I don't see specific language to Ms. Hall contracting any MRSA on that date in these 5 claims for relief.
Okay. And other than the conflicting testimony which you already cited, do you have any evidence that Ms. Hall's finger was already infected when she had her nail service performed on November 1st of 2010?
No, only the testimony.
And were you able to corroborate that testimony either way?
I was not.
Did you ask Ms. Tran or anyone else at the Dainty Nails Nail Salon for information about their purchases of, about the cost they were saving on their sanitation procedures?
No, I did not.
Do you feel that it's within the authority and your powers as the state's investigator to obtain accounting information that might reveal whether they were saving money?
I've never done that.
If you thought that somebody were cutting costs and placing the public at risk, do you feel it's within your power to ask them for their accounting or bookkeeping information about their costs?
Like I said, it hasn't been our practice to ever do that. If I felt that that was necessary or something that was that needed to be done, I would probably speak to Ms. Curtis, Mr. Landry, and probably Ms. Bradley as well to see if that was within our jurisdiction or purview.
Okay. But at least in this case, you did not ask for any information about the alleged cost savings, correct?
That is correct.
And at least in this case, the owner did not deny you any information about their expenses, correct?
That is correct.
In fact, have you seen this complaint before?
I have, yes.
Do you recall seeing any allegations in this complaint about cost savings on the part of the owner?
No.
Do any of the inspection reports that you prepared or that your staff prepared contain findings or allegations of cost savings at the risk of the public?
The complaint and the inspections don't have specific reference to cost saving. I think we spoke earlier about our experience in this area and how certain not following of regulations and statutes could be construed as a measure for saving costs.
Did you observe during any of your inspections whether the employees at the Dainty Nail Salon were in fact hurrying customers through the stations in order to save money?
No.
Do you have an explanation? Just to recap some testimony that you provided, did Ms. Hall report to you that when Louis Tran was drilling her nail, he took the bit from a box with other bits?
Let me check my notes. Okay, Louis Tran didn't drill her finger. That wasn't the testimony I gave.
What was the test? Please clarify.
Ms. Nguyen is the one who drilled her finger.
Okay. But was the testimony that Ms. Hall saw Ms. Nguyen take the bit from a box with other bits?
No, Ms. Hall didn't indicate that.
What was indicated about, what did Ms. Hall indicate about where the bit was drawn from?
She didn't recall. What Ms. Hall told me is that Ms. Nguyen used a Dremel tool with a sandpaper type bit and began removing the old acrylic. I did ask her if the instruments appeared to be clean or sanitized, where they came from. She didn't recall those factors. She did recall the workstation to be dusty.
Okay. Do you have an explanation of how one bit would allegedly be infected with MRSA when the other bits were not?
No.
And you did testify correctly that there have been no other allegations of a member of the public contracting MRSA from a licensed cosmetology establishment?
Correct.
And you did testify, correct, that the records from Dr. Robertson reflected Ms. Hall's statement that she trimmed her nail too short as her explanation for how she contracted MRSA?
Correct.
Did you ask Dr. Robertson for his records?
I did not. They were supplied by Ms. Hall.
Well, how come those aren't with... Where are those records?
Where are they?
Yeah. Do you know why they're not being offered today?
You'd have to ask Ms. Bradley.
Do you recall, okay, so did you actually look at Dr. Hall's, or excuse me, Dr. Robertson's records that contain that statement?
I did.
Okay. Could I have this marked next in order, please? Excuse me.
If you'd like it entered, it'd be Respondents Exhibit 1.
Thank you.
Any objections, Ms. Bradley?
I just want to review it first, sorry.
Okay.
It's the first I've seen it. I don't have any objection.
So admitted. Is that your only copy of that? Do we need to get copies so the board can?
I did not bring 13, I'm sorry. I brought 4 copies, so I have a couple of extras.
Okay,
It's a
well,
version.
I mean, if one or two, we can probably look at it.
I'll approach the board now and.
Please.
Yes.
Thank you. Gary, that also needs to be faxed down to Vegas.
President Hoffman, just one question while there's a slight break here. What I'd like to do is instruct Administrative Assistant Monica Bradford to go to the, we're faxing this to the main fax number at the Grant Sawyer Building, and I'll ask her to retrieve any fax copies from there to bring those to Ms. Tran for her use.
Thank you.
Mr. Landry, I've tried to get into that door. It's a key card entry. I have no way of getting into that office unless someone opens the door from the inside.
I've been given information that there's an assistant named Melissa who's at the Grant Sawyer Building. If you can track her down within in the information technology area, she can give you assistance on getting entry into that room.
Okay, will do.
Shall I proceed?
Please.
Thank you. Inspector Green, can you please just read the first 2 sentences of the passage that starts with a history of present illness?
Yes, the patient is a 63-year-old right-hand dominant retired female who presents for evaluation of a left index finger problem. She reports the finger started swelling and became painful about 5 days ago.
I said 2 sentences. I'm sorry, I need you to read the next one.
She feels like she may have cut the nail too short.
Okay. Was this the...
I'm sorry, I don't believe we have a full record in front of us. We appear to be missing a page. We don't. Yeah, the second page is blank.
You have a second page that he's reading from. We don't have a copy of that up here. It's blank.
Let me approach the board again.
Okay. This will be Respondent's Exhibit 1? Yes?
Yes.
Okay.
Thank you.
So admitted again.
Mr. Green, you've also reviewed a number of photographs of Miss Hall's finger, is that correct?
Correct.
Was her finger green in any of the photographs that you reviewed?
I'm colorblind.
Do we have in our records the photos that you reviewed?
We have,
Do you want to admit them?
yes, the photos that I reviewed, I tried to just put them on one, do a montage and put them on one sheet, and this is the exhibit that Ms. Bradley has.
Did you ask anybody in your office to look at those photographs to describe the coloring to you?
No.
Has anyone who's looked at those photographs told you that that the finger is green in any of the photographs?
No.
Have you ever? I was going to ask if you ever seen a green finger, but that wouldn't help, would it?
I probably have, but I couldn't swear to it.
I don't have any further questions for Inspector Green.
I have a couple redirect, if I may.
Is that before the board asked?
Mr. Green, how many inspections have you conducted of salons in your employment with the board?
It would have to be several thousand.
And do you receive a complaint on every incident of injury that occurs in a salon?
No.
How many, in your time with the board, how many complaints alleging injury have you investigated? Just a ballpark if you can.
A ballpark figure, maybe 100.
Okay. And if we go back to Exhibit 8, which is the statement from Dr. Azam, would you read what he indicated as number 1?
Yes. The biological agents in this case, we know it was MRSA. And we know that almost everybody is regularly exposed to MRSA because MRSA is everywhere. And we need to protect ourselves from this widespread infection. Even modern hospitals that have state-of-the-art sterilization and decontamination systems have a hard time preventing and controlling MRSA infections.
And then would you read, it's under number 2, it's the second paragraph there, and it starts with, again, people. Would you read that part?
Again, people are exposed most of the time to MRSA from shared surfaces at work, schools, shops, computer keyboards, etc. And if they have wounds or if they practice inadequate hygiene, they will be more vulnerable to contract MRSA.
And then under number 3, there's a sentence that starts with although, and then if you'd read that sentence, and then the one that says additionally.
Although the time frame between the nails cosmetic procedure and the negative health outcome infection is consistent with exposure to MRSA, it is clearly unknown if the patient did not have an existing nails infection prior to her procedure. Additionally, it is extremely hard or maybe impossible to know where this patient contracted MRSA.
Thank you. I have no further questions.
Mr. Leader.
Mr. Green, I also wanted to just recap your testimony just quickly. You indicated that you did not ask regarding the accounting or cost-saving measures that were being taken?
That is correct.
And then you also testified that your only summation was a cost-cutting measure for some of this egregious behavior? That was like your summation?
In my opinion, yes.
And that is because you ruled out a conscious willingness to harm a client, I presume?
Correct. I did not find any evidence of any conscious, willful desire to harm Ms. Hall.
And that left you only the summation that it was cost-cutting?
That is correct.
Thank you.
Are there any other questions of Mr. Green?
Mr. Green, if I remember correctly, there is no indication that the tool or the tip that was used on Ms. Hall was reused. We don't know that, correct? We don't know whether that was brand new or reused because it's not part of her testimony, nor is there any way that we can determine that fact, correct?
That is correct. What we do know is that on the March 14th, 2012 inspection that took place at the same station where this incident occurred, we did find the same type of tool, a Dremel drill with bits that were not sanitized, had residue, and appeared to have been used and just sitting at the station.
Were those bits the filing portion, or were they the metal bits? Like, because
the metal.
the metal bits. But as far as the file was concerned, the item that may cause dust, for instance, that was, you didn't see any indication that those had been used or reused, right? Because they have the little
sleeve.
the little sleeve that goes over it.
The sleeve
right?
was there as well and appeared to have been used.
Okay, thank you.
In that inspection that you were just previously discussing, you're talking about those implements being left out on the station, not in a container, not...
They were, if this is the station, I believe there's a table behind the station, and that, I think that's where Ms. Scott observed them.
Thank you.
Mr. Green, so Louis Tran had stated to Mrs. Hall that he shouldn't work on her because she had an infection?
Yes, he indicated that she shouldn't get the acrylics on that date because she had an infection.
And he's the one who actually applied the acrylics?
Correct.
And he was the one who came over from another client without washing his hands, correct?
Well, I don't know that. I asked Ms. Hall that, did he wash his hands between the services from the client he had just finished? Where did the instruments come from? She had no clear recollection on that.
But he was working on a client, came over and worked on her.
Correct.
Is there a hand?
Well, he didn't come over. The testimony was that she moved over from the station where his wife was to Mr. Tran's station.
Because he was working on another client before
Working
that.
on another client. That client got up and left. Ms. Wynn had finished removing the acrylics, so now Ms. Hall gets up from Ms. Wynn's table, sits down at Mr. Tran's table.
Mr. Tran didn't move. Do we know that?
That's what I tried to find out. I asked Ms. Hall that question. She did not have a clear recollection if he got up, went to the sink, washed his hands, or did not.
The sink, there's no hand sink in their operating room that they're doing manicures and pedicures in, is there?
I believe there is a dispensary sink in that,
Right, in that
room. Yes.
And so we have no way of knowing that.
But we don't know.
Okay, thank you.
Mr. Green, when they moved tables, just for clarity, from Miss Wynn's to Mr. Tran's, those were two different sets of implements that were being used. So she went from using one set of implements to using somebody else's implements, and both implement. Is that correct?
Correct. Ms. Wynn was using the Dremel tool to remove acrylics. Then Mr. Tran used the implements and tools to apply acrylics.
And both observed were not sanitized or allegedly not sanitized.
Say that again?
Both allegedly were not sanitized. Is that correct? So when she used the new implements that Mr. Tran was using, those implements were not sanitized either.
Well, let me just look at my notes so I say exactly what she told me.
I'm just wondering if she went from one table of allegedly unsanitized implements to another table of, allegedly unsanitized implements.
When I asked Ms. Hall about that, she indicated that Mr. Tran took his tools from a plastic box in the drawer of his station and began applying the acrylics to her nails.
Okay.
She indicated she couldn't say if these tools were clean or sanitized, or if Mr. Tran washed his hands between serving her and his previous client.
Thank you, Mr. Green.
I have one more question.
Okay.
At the time, there was a discrepancy between Ms. Hall saying she had no infection and the testimony of the nail technicians that say she was infected. Did you attempt to try to clarify that, to figure out who was telling the truth or recalling it? I'm not quite sure how that discrepancy was resolved.
Yes, when I first spoke to Ms. Hall, she presented her statement of the facts. There was no mention by her of any prior infection or anything like that. Then once I spoke with Mr. Tran and Ms. Wynn, and they both indicated to me that there was some problem with that finger the day that Ms. Hall came in, I went back and spoke with Ms. Hall by phone to try and piece that information together. And that was on April the 11th. I spoke to Ms. Hall. She indicated that there was no discussion at any time with the salon staff about her having a prior infection on her finger. And then she talked about she had a vertical line on her finger, and Mr. Tran typically would just work around it. He was always careful not to drill too deeply by that vertical line. She indicated as well in that conversation that on one of her visits to the salon, one of the female staff members made a comment to her indicating that Asians sometimes are prone to getting this type of dark line on their nails. I believe Ms. Hall might be of Asian descent, and I think that's where that was coming from. And that was basically it. I tried to, see, well, okay, they're saying that you had this infection. Was there anything about that you wanted to add? And she indicated she had no infection when she went in there.
Would it be possible that a nail technician would say that the infection was present at the time of the service in an effort to avoid a more serious implication that they contracted that infection at that establishment if no infection was present?
Would that be possible?
In your estimation, would someone at that establishment do that?
Well, it would be possible, absolutely. Yeah, it would be possible, and it would help to explain how this infection was there and absolve the salon.
Thank you very much.
I have a question. On the Chinese oil, did the Ms. Hall tell you that they gave her the Chinese oil, or did that come out in the hearing that we had?
That was, let me check my notes real quick. Yes, Ms. Hall indicates that 2 days after the service, on November 3rd, she did return to the salon because she had experienced swelling in the first joint of her left index finger. She soaked it in Epsom salts. And on that day, she returned to the salon. She showed her finger to Ms. Nguyen, who removed the acrylics and gave her a bottle of what she called Chinese oil to put on the swollen area to help with that.
Any other questions? Ms. Bradley, is there anything else you'd like to present?
I have no further questions for Mr. Green. I don't know if Mr. Matuska has any recross for him after you guys have questioned him.
I do not.
Okay.
I do not, thank you.
Okay, the next thing I would like to do then is I would like to admit to the board previously sworn testimony of Ms. Darlene Scott, who is unavailable, as well as Dr. and Mrs. Hall, who are unavailable. And then I have some exhibits that their testimony authenticates that I would like to admit. I'm anticipating we're going to argue about this, so I may need to make an offer of proof from Mr. Landry, at least with regard to Ms. Scott.
Okay.
So I have copies of the testimony. I have blacked out anything other than the testimony of Ms. Scott. And as it turns out, her testimony goes directly into Dr. and Mrs. Hall. And then there's a later when Dr. Hall is recalled. It's just one page. It's not hearsay because it's previously recorded statements of unavailable witnesses. They were sworn under oath in the previous hearing. The respondent was present and able to cross-examine them. And so given that, I would ask that the previously sworn statement of both Dr. Hall, Mrs. Hall, and Ms. Scott, the board inspector, be admitted so that the board could read those and take that testimony as if they were here today. definition of unavailable witnesses in NRS 51055. A declarant is unavailable if they're unable to be present to testify at the hearing because of death or then existing physical or mental illness or infirmity. Mr. Landry can testify that Ms. Scott is out of the board on medical leave at this time, and so that's why she's unavailable today to be present and testify.
And I could support that as well, too, because I know that that's the case with that particular witness.
Okay. And so he can swear to that if need be, so that you can make that finding that she's unavailable. And then as an officer of the court, I can tell you that I have spoken to Ms. Hall's attorney, as well as I received a voice message from her. Dr. and Mrs. Hall are absent from the hearing and beyond the jurisdiction of the board to compel appearance. They have moved out of the state of Nevada. They are not a party. They were the complainant. The Nevada Supreme Court has held that a complainant is not a party and they don't have standing to appeal an unfavorable decision. And so they are a witness just as any other, and we're not able to compel them to be here today, in part because they're outside the jurisdiction of the state. Further, neither of them are licensees or anything in that capacity. And so based on the fact that those witnesses are not here, I'd like to admit the testimony of them.
Any objections?
Yes, on a number of levels. First, I don't think I can review the testimony of Ms. Scott. I may not need to object to that. But as far as the continued testimony of witnesses who are not here today, respectfully, Chairman, those are the witnesses for the state, and I have the right to cross-examine them. If Ms. Hall doesn't want to come and testify in support of her own complaint, I question why this board would proceed with the allegations.
Well, it actually wasn't her complaint.
Well, she made the
initial.
Yes, and the whole case is based on her testimony. Of course, I presume that she was going to be here today. This is the very first time I've heard that she's moved from the jurisdiction and would not be testifying in support of the allegations. The same is true for Mr. Tran. Apparently, that's a witness that the state is invoking. He is a licensee. I don't care if this testimony is used against Mr. Tran, but to use testimony of witnesses who are not here against my clients, I think it's inconsistent with our right of cross-examination. I'm sorry. I objected initially. I just want to make sure I'm clear on the record. I want to make a motion now, please, to strike all of the hearsay testimony from Mr. Hall and Mr. Tran has been presented so far. It's very prejudicial.
Well, okay, I'll respond to the motion to strike first. Hearsay is admissible in an administrative hearing, and so there would be no basis to strike any hearsay. The rule for hearsay in administrative hearings is it's admissible, but the board must have other corroborating evidence before it makes a finding of guilt. So the board cannot make any finding of guilt or violation based solely on hearsay. And so Mr. Green has testified, I think, about all of the conversations he had with all the relevant parties when he was doing the investigation. And certainly a lot of that is hearsay, but it's all admissible.
Well, I think she just admitted the case can't be based purely on hearsay. A little bit of hearsay is admissible once in a while if there is an indicia that it's reliable and there is other evidence to corroborate it. But we have a case that's based solely on hearsay. And the idea that hearsay is admissible does not mean to contradict the right to cross-examine. A little bit of hearsay comes up in letters, some testimony about prior statements, but the whole case at this point is hearsay and it's unfair. If I could make just one more point.
Hang on just a second. Okay, Ms. Bradley.
Okay, and then I'd like to respond to the former testimony issue. NRS 51.325 says testimony given as a witness at another hearing of the same or a different proceeding is not inadmissible under the hearsay rule if the declarant is unavailable as a witness. And so I would submit to the board that both Ms. Scott, Dr. Hall, and Ms. Hall are unavailable as witnesses. And if the proceeding was different, the party against whom the former testimony is offered was a party or is in privity with one of the former parties. And so we have the same parties. The fact that the attorney was not present at the previous hearing doesn't negate the fact that the parties were present. They had an opportunity. The record actually shows the president, who at the time was Mr. Leader, asking them, giving them an opportunity to question those witnesses. And there were some questions asked of those witnesses. So it's not the board's fault or the staff's fault or my fault that the two licensees have moved outside the jurisdiction. Further, they didn't testify at the previous hearing, so any reference to Mr. Tran and Ms. Nguyen, we have what Mr. Green is able to tell us, but they didn't actually testify at the previous hearing. The testimony...
Ms. Bradley, they did. I'm sorry.
Okay, well, I didn't bring their testimony then, so I guess that's my bad. But I have the testimony of Ms. Scott and Dr. Hall and Ms. Hall to ask you to admit, and like I said, it's not hearsay under the rules of evidence.
You have a response to that?
We have nothing from Ms. Hall saying that she is unavailable. A witness is not unavailable just because they move. I don't have anything that indicates to me that she was asked to attend. I can remind this board too, I think you're aware that she has a civil case going, which really probably is what a lot of this is about. But she's going to,
How does a civil case have bearing on what's before the board right now?
She wants to get the findings from this body to use in her civil case. But she has to return to Nevada to testify in the civil case. If I had known that she were not available today, or that were going to be claimed that she was not available, perhaps we could have made an accommodation to reschedule at such time as she's already here on her civil case, or possibly to continue this until I've had her cross-examination in the civil case. So I'm not convinced that she's unavailable. We have nothing to support that. Just being outside of the jurisdiction does not mean that she's not available or willing.
Well, I mean, as an officer of the court, I can tell you that I spoke to both her attorney and I called her in Hawaii, and she returned my call, and she and her husband are now living in Hawaii. So I can tell you that my information is that I believe to be true. I have no reason to believe it's not true. I didn't actually go there to see her there, but as far as I know, she is in Hawaii. They have relocated to Hawaii. That's where they're living. And so under the rules, that makes her unavailable because she's outside the jurisdiction of the state of Nevada.
She's unavailable, she's outside the jurisdiction, and not willing to return to the jurisdiction. In fact, she has to return. She has to return to our jurisdiction. But I don't think it's relevant for this reason. I'm sorry if some of my questions to Inspector Green were a little confusing, but the violations alleged are not alleging that she contracted MRSA in this establishment. So all of her testimony about where she contracted MRSA is out. It's in the factual allegations of the complaint, but it's not part of the violations that are being alleged. So it really isn't even necessary to these proceedings today, and I wish I would have had an opportunity prior to the commencement of these proceedings to clarify that. So it isn't even, it's not relevant, it's not helpful. Frankly, I think it's prejudicial because there's this specter of MRSA that's going to be discussed when the board deliberates on the violations that Mr. Green identified when he is and his staff inspected. Is not relevant to the violations alleged.
Do you have any response, Ms. Bradley?
Well, I would just say it's relevant because part of the reason the investigation occurred was the fact that Ms. Hall filed a complaint. So everything she alleged in the complaint, everything Mr. Green uncovered, that's all either background or part of the investigation. He's correct that there's no violation alleged that they gave her MRSA. The complaint doesn't say the salon gave MRSA to the respondent or to the complainant. It alleges poor sanitation, gross malpractice, unfair, unjust practice. working on someone with an infection or working on someone with inflamed skin. Those are the allegations. The allegations are not MRSA. And in fact, Dr. Azam said it would be impossible to determine for certainty whether it did occur at the salon. But that's all background information and why we're here today and why Mr. Green investigated and why a complaint was filed. That's why that information is presented.
Mr. President?
Yes, Mr. Leader.
Did somebody else get MRSA? I mean, is that what this questioning's about? Like more than
MRSA
one
doesn't really have
person?
anything to do with it. We're hearing a case and trying to determine whether or not there was an excessive fine imposed onto the complainant, I believe is the reason why.
Okay. Perhaps I can clarify this a little bit. What is before you right now is whether or not the testimony at a prior hearing from Ms. Hall, Dr. Hall, and Ms. Scott, excuse me, should be admitted on behalf of Ms. Bradley's case to prove the allegations set forth in the Big C complaint, the complaint to Dainty Nail Salon. So she is offering right now testimony from the prior hearing, which was sworn, and an opportunity, she's presented an opportunity was had for the Dainty Nail Salon to cross-examine these particular witnesses. And she's offering that as proof to support the 5 violations of law which are alleged in the complaint, as well as some of the facts laid out in the factual allegations. That is before you right now. I will point out that the rules of evidence are relaxed in administrative hearings. Ms. Bradley has pointed out NRS 551.325, which allows the testimony to come in. I will reiterate that the definition of unavailable pursuant to NRS 51.055 is, for relevancy, is 1D. The declarant is absent from the hearing and beyond the jurisdiction of the court to compel appearance, and the proponent of the declarant statement has exercised reasonable diligence but has been unable to procure the declarant's attendance or take the declarant's deposition. I will point out, as opposing counsel has tried to say that there is some sort of element of requirement that they come back. That is not present in this particular definition of unavailable as a witness.
Is it Mitsuka?
Matuska, thank you.
You know, we've all known that this rehearing was coming. But did you have the opportunity to just talk to the Halls yourself and do whatever you needed to do to ask them questions? Because you've waited until today to say that you haven't had the chance to speak to them. What were you doing when you knew about this meeting?
Well, I don't have the right to schedule deposition as part of these proceedings. I wish I would. I did recently send a letter to their attorney asking if he was going to attend with Ms. Hall. I've been assuming that Ms. Hall was going to be testifying in support of this complaint. And yes, I recently sent a letter to the attorney asking if he was going to attend.
And what did he say?
He didn't respond.
Well, then doesn't that kind of give you an indicator that you need to press the issue a little bit more if you need to ask some questions of him?
No, the reason why I asked if the attorney was going to be attending was because our rules of professional conduct impose restrictions on us having communication with the represented party. So I just wanted to make sure that either he was going to be there, I wanted to make sure that either he was going to be at the hearing today, or that he knew that I would be questioning his witness. It never came up that she was not available out of the area or not willing to attend today. I did not know that at all. This is new information.
But you had asked. You wrote a letter asking that.
The letter was very short. It said,
did it need to be longer?
No. It said essentially, please be advised that I will be questioning your witness at the hearing on Monday.
And what response did you get back?
None.
Well, isn't that an indicator?
No, I'm sorry. I explained the opposite. I wanted to make sure that the attorney was going to be there, so that he could not accuse me of having an improper communication with the representative party. He did not respond that they had moved. In fact, I didn't know that. The civil case is still going, and she's been participating. This is new information. We still don't have a record before us that she refused to attend, and I've made the point that she will be traveling back to this jurisdiction as part of the civil case. And had I known that she was out of the jurisdiction and not willing to attend this hearing, I would have asked to continue this to such time as she would be here anyway, or at least that I would be allowed to take her deposition in the civil case and try and use that here.
And so can he compel somebody to show up to an administrative hearing?
No.
I mean, he wrote a letter, but I mean, there's no...
No, the board has subpoena power to compel witnesses. However, the subpoena power we've interpreted to be within the state of Nevada. So she is outside of the jurisdiction of the board. So you wouldn't have any authority to send a subpoena to Hawaii to compel her to attend this hearing as of today. And you need to show that you've done a reasonable diligence to procure that witness, and that's what Ms. Bradley has attempted to do by saying that she contacted the attorney and contacted Ms. Hall and Dr. Hall themselves.
Okay, I have a comment here. I would like to see the testimony because I believe inside that testimony is testimony that will help clarify the perception of whether or not there was a previous infection at the time of the nail service or not, because we have one party who says that nothing was wrong with her nail at the time when she walked in, and we have another party that says her nail was infected at the time. And if I recall, that testimony should be there and should have some bearing on this fact.
Louis Tran and Ms. Nguyen testified to that issue also. So if the decision of the board over the objections I stated was to admit it, we should admit the whole transcript.
I have that transcript.
I don't recall seeing either of their names as testifying, but perhaps I missed it, so
I have
I'll
it.
look.
Yes. I actually concur with Mr. Nixdorf. It's relevant to the question of prior infection. It's not relevant to the question whether she contracted the MRSA, which really I don't think is much of an issue here. And then the only objection then is the hearsay and whether we made good faith efforts to get Ms. Hall to testify today.
While we're figuring out what's going on with this particular transcript, let's take a 5-minute break so that everybody can relax. Okay, we're back in session at 11:39. So before the board is a admission of information, Ms. Bradley?
Well, my request was to admit previously sworn testimony of Ms. Darlene Scott, Dr. Hall, and Ms. Hall.
And the objections that you noted, sir?
Yeah, I noted the objections. It's not irrelevant to some of the violations. It may be relevant to the others. I noted the hearsay objection, and I also said that if the objection is overruled, I would just prefer to admit the whole transcript in that event, which I think is fairer.
And I have no objection to admitting the entire transcript. I do have a copy. I just have one copy, though.
I believe that there is a copy up here as well, if both counsel would like to take a look to make sure that it is a verified copy.
I believe
trust you.
I believe that it's a verified copy, and I have my own copy.
Okay, so admitted.
And I'll give you my copy if you want, so you have another one. I don't mind.
Just as long as we can move forward.
Are we admitting the testimony or the whole?
The whole transcript.
Which number, Mr. Chairman?
I'm sorry?
Which number?
What was the, it was 8 or 9?
Well, actually, could we admit it as 11? Because,
Just because?
well, no, I have photos of Ms. Hall's hand that I have pre-marked as 9, and her testimony authenticates that these photos are photos that she took. And then also I have copies of her medical records previously marked as State's Exhibit 10, which again are authenticated by her testimony. So
we're admitting 9 through 11?
well, if I don't know if Mr. Mateska isn't going to object to 9 and 10.
No objection. Just on relevance again. This is, I'll stipulate to just to speed it along, but this is all going to how she contracted MRSA still. So
The relevance to the case is the 5 different claims that we have. That's what we're discussing here today.
I don't have any objection to 9 and 10.
Okay, so admitted.
And again, I have color copies of 9 if the board would like to see. And then the only other thing I'd like to put on the record about the medical testimony is just to remind the board that even though the medical records are being admitted, they are still confidential pursuant to NRS 622, which talks about certain 622.310, the admission of medical information and records in an administrative hearing. So I just want to remind you, you can look at them, counsel can look at them, but they don't become public records, and they should be treated as confidential documents, meaning that afterward they should be shredded so that we make sure we don't release anything that we shouldn't.
So noted. Thank you.
It's just the medical records under the law. And with that, I would rest.
It's your opportunity to present your case, sir.
I would like to call Maria Tran, please.
Yes.
Just one question, ma'am.
Did we swear her in? Okay.
Do you recall when Inspector Green came to do the inspection at your nail salon?
Yes.
Did you ever tell him
I think
that
it's hard to hear. I'm sorry. I don't know if there's a way to get the microphone closer to her.
this one's still on?
Okay.
Okay. Ms. Tran?
Yes.
When Mr. Green came to do the inspection at your nail salon,
Yes.
did you ever tell him that Nancy Hall's finger was already infected?
No, I don't. I vomit. No.
Okay,
Yes.
no more questions for this witness.
Does that mean it's the board's opportunity No.
To ask her a question.
You're first.
So, Ms. Tran, do you remember speaking to Mr. Green on that day?
I speak with him because I have another business, and then he come over there first. And then my daughter called me, and I run over there. And then the first time I talk, we talking, and then he asked me about, I know about Nancy. And then I say, I heard my daughter and my brother told me about that. And then I just told Mr. Green, he asked me what happened. And I say the day I know about that, about after 1 month, when Nancy go to the nail salon and talking something with my brother and my daughter, Julie Tran. And that time, Mr. Rin asked me, what happened? I say, I talked with my brother and my sister-in-law, that's Hong Nguyen and Louis Tran and Julie Tran. I asked what happened. And then Hong Nguyen told me, when Nancy go in, it's nothing going on. And then Louis worked for another person. And then she want you to delete something about that. And then Louis say he didn't have time. And then she say she need about go to the party for the nighttime and then do for her. But I asked Louis and had Hương Nguyen about for Nancy have something is a problem. They say no, nothing. And then I asked for sure the one for question. Hương Nguyen told me because she speaking little English, but Louis don't speaking very well. And then I asked about, you see for sure about Nancy Hall. It's nothing a problem in her nail. And Helen, no, Hương Nguyen told me about little bit red because she says she picked on in her nail. That's it.
Is this answering or is this going beyond it?
That's fine. So, because I guess my question is now, because Mr. Green testified before that when he came in, he talked to you,
Yeah.
and that you told him that Mr. Tran told you that he saw infection in Miss Hall's hand on the day he did the service. Are you saying Mr. Green's not remembering that correctly, or?
No, I am sure I don't tell him about for Louis say about have infection. No.
Okay, thank you. I have no further questions for Ms. Tran.
Is there any board members that would like to ask any questions? I do. Ms. Booth? And then Mr. Leader.
Ladies first.
Mr. Leader, I'll let you go first, and I'll ask my question.
Ms. Booth, why don't you go ahead and go first?
Okay. My question, Ms. Tran, at the last hearing, you shared with us some Chinese oil. Do you remember that?
Yes.
Okay. And with that Chinese oil, what was that given to the patron for?
You know, if that's the one I use for, everyone in the Chinese or the Vietnamese people or Philippine people, they have little bit red and then they can put little bit outside like this. And then maybe about for go away because look like about alcohol, look like the one you clean, that's it, nothing. Yeah.
And why did you give that oil to the patron?
I didn't give for that Hương Nguyen, he give for her.
Okay.
Yeah, I am not in.
And who is Hương Nguyen?
That's my sister-in-law, the one for work over there, the technician working.
Okay.
Yes.
And if you pass this Chinese oil out, do you have a license to practice medicine?
You know what? That's the one I done because that's my sister-in-law. She always have in her purse, and then she say Nancy Hall little bit itching, and then she say you just use this one you around here. That's one I know.
Okay, my question was, do you have a license to practice medicine?
No, I don't.
Okay,
Yeah.
thank you.
You're welcome.
Mr. Leader.
Thank you, Mr. President. Ms. Tran?
Yes.
We just allowed the hearing materials from the May 24th 1st, 2012. Is that correct? Is that what we did? We allowed to be referencing
The
this?
full transcript from that hearing,
So
yes.
even though Ms. Hall's testimony begins on 247, the testimony actually starts on page 197 of that, so the whole thing's admissible?
Yeah,
Is that
the whole
correct?
transcript was admitted as evidence, yes.
And
Exhibit 9,
it-
10, or 11, I believe.
Thank you. Is it Jimmy Gian?
Yes.
That's your son?
Yes.
And you are aware that on page 296, that your son indicated that, I think the allegations are justified, to be honest. Were you aware that he said that? It's lines 7 and 8 on page 296. I actually cautioned your son in the statement before. I said, I'm not sure if your closing statement is helping you. And he continued by saying, I should just stop. I don't think the allegations towards us is really, I mean, it's justified, to be honest. Were you aware that your son said that?
I don't.
Did you need to see the testimony? No?
No, she doesn't need to see it. The transcript is before the board now. I think I should clarify, though, those statements were about the sanitation procedures. So you have to read the part that comes before that.
Mhm.
That's not about anything to do with the MRSA. Jimmy did not admit anything about the MRSA.
And then did Jimmy also said on page 295, he said that the fact that she went back to work after she had her nails on and she had put her gloves on, that could have actually worsened the problem. And later on, towards the bottom of his testimony on that page, when the inspectors do come in, they always come across these infractions. Are you aware that your son said that about your establishment?
I'm going to object because that statement is not about this establishment specifically. That's a general statement about inspections across the various licensed establishments.
Actually, in the beginning of that paragraph, he's quite clear about saying our nail salon.
That statement, I'm sorry, I have to repeat my objection, though. This last statement you read is about inspections in general.
I think that may be your interpretation.
What's the question?
I had asked her if she was aware of her son making those statements.
You don't have to translate at this point. She would have to translate.
And so that's no. Thank you.
Are there any other questions from the board?
I just need some clarification. We are
Okay.
not trying to decide on the MRSA part of this case. It is
Correct.
about the violations that we are addressing. Is that correct?
I would agree.
Okay.
You were looking at me, but I agree
I'm
with
looking
that.
at everybody.
Just to be clear, what's before the board is the complaint and notice of hearing, which alleges 5 violations of Chapter 644, and those are the violations that are before you today, whether or not the state has put on its case to prove those violations.
MRSA is sadly the outcome of what has happened, but case in point is the violations that we're here to talk about, correct?
That's correct, the ones that are in the complaint.
Thank you.
Okay, so on page 231, it states here, the witness, she didn't indicate, what she told me was she didn't indicate that she had an infection at that time. That was the respondent's statement to me. This was under, when you questioned her about the scenario. Yeah, not interrogated, sorry, bad word for that. But anyway, it says she didn't indicate that she had, Ms. Hall indicates that she did not have an infection. There was no such conversation. Then there was, let me see, what else did I haven't quite finished going through all of this, so give me a moment here. Yes, Ms. Tran. According to that testimony, Ms. Hall did not have an infection at the time of coming into your salon. Why would you say that she had an infection when she believes she didn't have an infection?
I don't say about she have that. I don't.
Did you indicated that you knew that she had inflamed red tissue at the time when she was in when she came in for her service, but according to her testimony, she didn't have anything wrong with her finger.
Yeah, that's
Are you certain that of your testimony?
You know, I asked my daughter and my sister and my brother. They say she didn't have nothing when she walked in the store for the nail shop, and then after she goes, she happy too. She nothing about hurt, nothing. That's the one I know.
But in this testimony that we've got here in front of us, there's a great deal of discussion where you're quite adamant about the fact that she had inflamed tissue at the time.
Oh, you know, like they just talking. I heard about my daughter say about she always pick on her nail. That's it. And then, but when she go and nothing about for infection, that's the one I know, because I am not over there.
So, would you be changing your testimony from the last time?
Are we positive that's her testimony? I'm trying to flip back and match these pages up.
Throughout this testimony, there's many times when there was statements by her that said she had an inflammation. She insisted that we apply this nail over this inflammation. We recommended she didn't do it, but we did it because the customer wanted to have it done. There's quite a bit of that. And so I'm just trying to determine whether or not that testimony then was an effort to absolve herself from a much greater perceived penalty for MRSA versus what really went on, because we still have conflicting testimony between the person who contracted the MRSA and these nail technicians.
Well, we have that, but I think it would be better if we could refer to the specific pages. I'm just a little cautious that statements that are being attributed to her. Well, we need to be sure.
I'd be
that things
happy
are
to do
being
that, but I
attributed.
have to have a few minutes to look through those.
I have a question in the meanwhile, while you're looking for that, Mr. Dixdorf. As Ms. Benaldi said, I mean, this is really about, you know, the insanitary claims that we're talking about. You've had many times that your salon has had these violations. Even your son had claimed that, you know, oh, they always find something. Why is this ongoing for you? Why is there continual violations being happening in your salon? And do you think that after numerous violations of unsanitary practice, that something like MRSA, do you think would possibly arise after years of having an unsanitary establishment?
I'm sorry, I have to object to that it's compound, but also there's really no foundation for her to testify about.
Okay, I'll rephrase my question. I'll take out the MRSA part, but why is your salon continually unsanitary? And your son even said, oh, they always find something.
You know, I just go over. Look, I don't understand. Can see.
Oh, anybody can answer. Why is your salon continually unsanitary?
This is just from
Okay, for Ms. Tran, maybe you can, if this is just for you, maybe you can answer it. Why is it continually, years worth, the 2010, 2011, 2012, can you tell me why it has been continually unsanitary?
Oh, for the, about for the not clean.
Yes, why are you getting these violations continually?
I not work over there, but I tell it the people work over there, the worker have to be clean that.
But you are responsible.
Yes,
so why is it continually unsanitary?
I just go over there and then I ask them. They told me about when they work in a last, it's powder they powder. That's why when they done and then they clean that. That's why end of day I go to check that and everything is clean. And then when they work in 3 people work is so much,
Well,
yeah.
If I can add to that, please. I know that there's a violation record here, and frankly, we didn't come here expecting to rebut the report that the inspectors made. I mean, as far as I'm concerned, the reports are what the reports are. There was an order entered after the last hearing, and part of the order was to make an appointment with one of the staff members to review these procedures, and that was done. I think there have been some inspections since then. I can't verify that myself. I don't have the dates offhand. So I want to clarify that it's not that they always have them. The record is what the record is at this point.
Sure.
They have complied with the previous order, made the effort to review these procedures, and whatever the subsequent inspections show is what they show. So I think things are in pretty good order. We're trying to address the violations that are cited here. And it just got really confused between what's being cited for the unsanitary procedures and what's being cited for the MRSA-related stuff, which is why I requested the rehearing.
Thank you.
Ms. Tran, thank you. I just wanted to also refer to Ms. Long's question on page 235 of the prior hearing. Your son also answered that the cleanliness, I would say, is middle of the road. Could you explain that to me, please? What that means, middle of the road? That the cleanliness is middle of the road? Because your son was speaking on your behalf. What did he mean by that?
I don't know.
All right.
I'm sorry.
And then in prior testimony, you heard Mr. Green refer to the multiple use of single-use items as being a cost savings. Could you respond to that? Is that accurate? Was that a cost savings for you to use single-use items multiple times?
No.
Was it laziness?
No.
What was it?
That's not right.
What is it?
We never allow for.
What is it? In a single word.
Please allow her to answer the question, at least to the best of her ability.
All right. If it's not cost savings and it's not laziness, what is it?
I'm going to object that it is an argumentative question also.
I'm just asking. I don't mean to be argumentative. It's been refuted by your attorney that it wasn't cost savings. And you indicated yourself it's not sheer laziness. Why would you be using single-use items multiple times?
No, we just throw away. We never use for the old one. I buy a lot for the supply.
And in what circumstance would you use a single-use item multiple times?
When they using the one person and then they throw away, for sure. I never save the money for that because I know by law, That's why I never, make one throwable for that. That's why I must do for them and then they understand. One person and throw everything. And then they use the new one.
So do you employ cost-saving measures with your equipment purchases and your supply purchases?
No, they
No.
follow for me. And then everything they have to use the new one for the new person. And then they have to use the love when they work for the person.
And how do you guarantee that?
Because I go over there, I check out.
How often?
Like 2 times a day, I come over there because my business not far away.
Now, in your previous testimony to Ms. Long, you indicated that you didn't go over there very often. That's why some of these cleanliness issues have been repetitively violating. Did I miss something?
What's the question?
Did I miss something?
I don't know if you missed something.
Because
honestly.
there's two different testimonies. Perhaps we need to hear her response to Miss Long, where I thought I heard you say that you didn't go over there. How often do you go?
I not work over there full time, but I come over there, I check out. But I not work over there.
So
I call them for make sure everything is clean.
thank you.
You're welcome.
I have a question.
Mr. Nixdorf was wanting to
I'm sorry.
ask a question previously, but we'll hold your question after his.
Great, thank you.
Thank you, Mr. President. Page 264. It's Mr. Han, right? Is that how you pronounce that again? You just stated that there was no bacteria infection. There was no infection on her finger that day that she came in. If you go by the 4 cardinal signs of infection, there was no infection. Infection afterwards or prior? Prior, there was nothing. There was nothing on her finger. So here we have some testimony that says that there was no infection. And then if we go over here to page 272.
Was the first page 264?
Yes, page 264.
Okay, I see it.
Okay. And then we go down to page 272, and there's a discussion here where she said she didn't even see anything that was dark or blue. She just saw the redness on her cuticle. I just said that. A few days later, she came in, and then she went to my uncle to have the acrylic put on, right? A few days later, she came in like, I don't know. So then she went to my Uncle Louis to have the acrylic put on, but there was redness. It was on the cuticle or under the nail, on the nail. So he applied the new acrylic nails on the nail, supposedly from their understanding, from what they observed was the redness on the cuticle. It wasn't anywhere remotely, or I guess it wasn't anywhere where the nail was being worked on. Then Mr. Tran says, when she comes to my table, I take over her nail's still everything good, but a little bit pink on the finger, a little bit pink. So I'm not really convinced that there was, I'm not convinced that anybody really knows at that moment in time how much pink there was on the nail or how much pink there wasn't on the nail, and whether it constituted an infection. During this testimony, I made sure to make clear that we aren't qualified to determine whether a person has an infection because we're not doctors. And so the best that we can do is determine whether or not there's redness and irritation and swelling and so forth, and not to do a service on that at that time. Anyway, I don't know. That's just my commentary, and I know that there's much more in these transcripts that I'm not finding at the moment.
You did a remarkable job of pulling out the most irrelevant portions regarding to the condition of Miss Hall's finger.
At the time that we did this, I had a great deal of concern over that, in particular the conflicting testimony.
There's one more statement that I don't think you referred to. I'm happy to point it out to you if you would like it, regarding the condition of her finger. Okay.
I would like to see that. I'd like to hear that.
I would as well.
Aren't we still in a question phase? I mean, if the council wants to make commentary, isn't there another phase where he can add his rebuttal comments?
I would like to hear this testimony first, please.
You were just referring to Ms. Tran's testimony where she says it's a little bit pink. And then what she really said, then what she said was Ms. Hall told me, or said that's an allergy, don't worry. But the next page, 274, a little hard to follow. I think this is Mr. Louis Tran's testimony. Excuse me, no, that was Mr. Louis Tran's testimony that it was a little pink. And then the testimony actually continues on page 274 down toward the very end. By that time, I hold that finger, I see a little red. So I've seen references to a little red and a little pink. Yes, those references are in our transcript.
Mr. President, I have another question.
Okay.
Ms. Tran? You might have recalled that I was the chairman at the time of your last meeting when you came before the hearing back in May of last year. You may recall that.
Yes.
Do you recall if at any time I limited any comments that were part of that hearing? Did I disallow any comments from anybody during that hearing? Do you recall? Thank you.
Ms. Booth?
And in that transcript, and I don't have the exact pages, but both the nail tech and the person removing the nail, both...
Also a nail tech.
Oh, also a nail tech. Thank you. I'm the public member here. Both admitted they did not want to put the nail on the patron. Is that correct? They did not want to put a nail on her, but she wanted to go to a party, so they went ahead and put the nail on anyways.
That's the one I heard about for Hung Wing told me. That's my sister-in-law.
And both nail techs said that they did not want to put it on.
Yes.
But she was going to the party, so that they did go ahead and do that. So the whatever wound was on this lady's nail, the pinkness, the color, whatever, gave them enough warrant that they discussed it with her that they did not want to put the nail on this person because it was concerning to them.
But they say about not wrong for Nancy Hall nail. And then she say, that's nothing wrong. That's Nancy told my brother and my sister-in-law.
Can I interject to answer that question, Koki? On page 276, I know you don't have a copy, so I'm gonna read this for you, okay? Because this we went over this, and Miss Bradley asks, and does she remember asking Mr. Tran, I guess her husband, about whether they should do the service? Does she remember having the conversation with him? Mr. Hahn, you did ask him about doing it, right? Do you remember asking him if you should do it, or do you remember asking him not to do it? She basically advised him that he shouldn't be doing it unless he feels that it's not any kind of infection, and it's his call. What she is saying, what she recalled telling him, but according to his statement, he just went by her consent and just applied the new acrylic. So then Miss Bradley says, so Mr. Tran, do you remember, I believe both of you, Mr. Nguyen and Mr. Tran, said something about her going to a party. I didn't hear her talk about that today, but I think that is what you told Mr. Green. Mr. Hahn, do you remember telling her that she had a party to go to or not? Mr. Tran, yeah. Mr. Hahn, yes, they both recall. Miss Bradley, Mr. Tran, do you remember talking to her and telling her she shouldn't have the service? I don't know if I heard that day either. Mr. Tran, yeah. Mr. Hahn, yes, he did. He did inform her that she had an infection or something on her redness, irritation, but that he was reluctant to work on it. Miss Bradley, and I believe that both of you, Mr. Nguyen and Mr. Tran, told Mr. Green that you were aware of proper sanitation in those procedures. Is that correct? Is that true? Mr. Hahn, when he asked about the cleaning, Mr. Leader, maybe keep us informed. So she was aware of the protocols and procedures as far as sanitation goes. I'm sorry. So this shows that at some point there was some discussion as to whether or not it was appropriate to put a nail or do a service on Miss Hall, but there was enough ambiguity that it wasn't quite clear, or the nail technicians did something that they weren't supposed to do, which is work on a client with inflamed tissue. And to me, a little bit of redness around the cuticle or on the nail would be a tough call as to whether or not it violates these rules about working on someone with inflamed tissue. So I don't know that this testimony works for or against anybody here, but it basically shows that there was something there that they were concerned about, and during the process they decided that the infection, the redness, was not something to worry about because it didn't appear to be anything significant, is how I read that. Anyway, that's my comment.
Next button.
Are there any other questions?
It's a little hard to determine, and I think it's a pivoting factor that if they're working on somebody that has an infection and they shouldn't be, I think that's a pivoting factor in the whole case. So I think we either need to have the whole transcript and go over it page by page, because I seem to remember, and it's just by memory, so I can't say for fact, but there was an infection involved, people were working on somebody with an infection, and that's how we originally determined the outcome of the original case. So to read a page here and there, I don't think that's really giving us all the facts that we need. If we're going to rehear it, then let's rehear it. And let's have everybody have a copy of that so we can all read through it, give us a day, and then we'll come back to it.
I think that it's very pivotal to determine whether or not it's infection, and I don't believe we're qualified to determine infection. So perhaps the language of the law is a bit not right, because it implies that we can determine that there's an infection, and I don't think that we have that right to determine that. I know that we can see it's red and inflamed, but that's something that I'll take up in the future.
Law Review Subcommittee?
Law Review Subcommittee.
Mr. President, Ms. Tran.
Mr. Leader.
Ms. Tran.
Yes.
On page 267, I know Ms. Benaldi's concerned about reciting intermittent quotes from the transcript. Your son, Jimmy, indicated at the bottom of the page that there was a discrepancy between the photo and something else, and that as the mother, that you felt that the photo had been altered. Do you still feel that way?
Can we identify which photo we're talking about, please?
There was a photo that is referenced on page 267 about the finger. It's the picture right here with the finger like this.
Right, but we have a lot of photos in our record.
Right. And so I'm asking, does Mrs. Tran, do you feel that any of the photos were altered? Any of the photos that were presented?
I don't know about that.
Thank you.
So at this stage of the proceedings, is there a summation that you guys want to come up with in conclusion to presenting your case?
I had another witness still.
Okay.
Jenny, I'm very much appreciate the board's consideration. We're going to be very, very brief. I hope that this one doesn't lead to as much cross-examination.
Okay.
Questioning for Jenny Tran.
She was sworn in, yes?
Yes. Have you ever worked on Nancy Hall's nails prior to this incident on November 1st of 2010?
Yes, I have. She indicated In the report, if I remember hearing earlier that she came into the nail salon a few times.
Could you speak a little closer, please, to the mic?
Sorry. Yes, in the report earlier in the morning, Nancy Hall indicated that she came into the nail salon prior with Louis and Helen a few times. That is correct. Before that, she did come to me. I am a licensed manicurist. I'm a part-time student. I'm a nursing student, and she came in and I performed just a regular manicure on her. And then, and I asked her a few things, because before I worked on anybody, I like to ask their condition, how their health, because I did notice that she was a little older. It doesn't mean that she's not healthy or anything like that, but I just like to ask questions first before I work on them, and I just performed just regular manicures on her, and she came in about 6 times, and we do have records of that she came in, and receipts that she came in for manicures.
Did Ms. Hall ever ask you to apply acrylic nails to her fingers?
She did ask, and I said I only like to do manicures, and I perform regular manicures on her. And she asked, and I said, when you're ready, you can ask, but she never asked me to do acrylic on her. I just perform regular manicures on her, which is just simple procedure, trimming down the nails, cleaning it, buffing it, and polishing.
And when she came to the salon on November 1st of 2010, did she have acrylic nails already applied at that time?
I was not there. I was in school, so I cannot answer that. I have no clue.
Okay. So you've met her a few times at least, is that correct?
Yes. Mm-hmm.
Did she ever tell you where she works?
Yes, she works at a dentist's office with her husband.
Okay. No further questions.
I don't have any questions.
I have a question. How long have you been a nursing student?
I am finishing up my associate, and I just got accepted at Sac State for their nursing program for their bachelor degree.
Wow, that sounds impressive. But albeit it's not a medical degree or whatnot, and you have done manicures on her before, and you've done, I'm assuming, proper consultation and whatnot. Have you ever asked if she was diabetic?
I can tell because of my experience. I do have my medical assistant and billing and coding certified. So with the medical assistant, we do learn to see if anybody has diabetic or
Have you
not.
asked her, though?
I asked her health condition, how was her health, and she said she gets sick often, but she never said she was a diabetic.
But do you know that you can't?
I don't remember if I asked her that.
Do you know that you can't use metal implements on somebody that is diabetic?
That's correct, yes.
And do you know that she was pre-diabetic?
She did not tell me, and I did not ask her that.
You didn't ask. Okay, thank you.
It's Miss Tran?
Yes.
Miss Tran? I think that you also testified at the May 21st, 2012 hearing.
I was not there.
Oh, you weren't? Okay. It was just Mr. Tran.
That's correct. That is my uncle.
Okay. On, just again, Ms. Bonaldi, if you could bear with me, on page 211, about the end of the page, it indicates that Mr. Tran advised Miss Hall against getting the acrylic service. But didn't Miss Hall have acrylics put on?
I was not working. I was in school, so if they put acrylic on her, then they put acrylic. I'm not there to see if they put acrylic on her because I'm in school.
So despite being advised against it, they proceeded to do that anyway?
If they indicated to her and said, we do not advise this, and she keeps persisting, I'm assuming that they want to make the client happy, but they did warn her beforehand, and in the testimony, both did warn her that we advise you not to put acrylic on, and she did say, please put it on, I'm going to a party. And so they said, okay, if you know we told you not to put it on, and you said you want to go to a party, and I promise I'll come back to take it off, then that's on her, and that does not have to do with me. But if they did warn her, then that's a good warning sign. If someone warned me that, I would say, you know what, you're the professional, you have a license, I'm going to believe you, and I'm just not going to put it on. That's my opinion. If someone told me that I don't think you should put acrylic on, I would listen to the professional because they have the license and they would know.
And you think that that's the best practice?
That is the best practice because they did warn her, and she consistently said, I'm going to a party with my husband. Please put it on. I promise I'll come back and take it off, which Nancy Hall did testify that she promised to Louie and Wynn to come back and take it off, but she didn't, and that's in the testimony.
Thank you.
You're welcome.
I have a question of you.
Yes.
You said you performed manicures on her half a dozen times?
Yes, about 5 to 6 times. Mm-hmm.
Do you recall that her fingers or cuticles show redness?
I saw a little pink, and I asked her about it. She says that she washes her hands a lot because she's a dental hygienist. She works for her husband, so she washes a lot. And when I was performing manicure on her, it wasn't bleeding. She didn't say ouch. She didn't say anything. And I only pushed her cuticle back because she didn't have anything. And I just did the regular manicure, trimming it down, buffing it, and polishing it. And that's all I did.
But you noticed that as on a regular basis that her cuticles, her fingers were red, or was it a one-time deal, or?
I saw only one time. I asked her about it. Maybe she can cut down just on so much with soap, or sometimes when they wash so much or they're scratching, I said, maybe just don't scratch so hard when you're washing your hands. And then, and a few times I saw, I'm like, oh, wow, the pink has cleared up. And she said, yeah, it really did.
Thank you very much.
You're welcome.
Okay, on page, this would be 211, 212, no, 210, right here, it says, and I don't know if you want to read the entire page. This is talking with Mr. Tran, Ms. Scott. I went then with Ms. Scott, so I guess I'm assuming Mr. Green went with Ms. Scott, to the New Image Salon in Carson City, where Mr. Tran is employed to obtain his statement. He indicated to me that he did recall the incident with Ms. Hall, and that he had worked on her 3 or 4 prior occasions. On the particular date, November 1st, when she came in, he remembers seeing a green fungus infection type of situation on her finger. And he advised her not to get the acrylics applied. She told him that her husband had a party to attend, blah, blah, blah. So that takes us to the reason why we're here.
If I could just clarify, right, but that was Mr. Green's testimony about Ms. Hall's, it was Mr. Green's testimony about his interviews.
Okay, but it's Mr. Tran's statement.
Being relayed by Mr. Green, right.
Right.
Is that an indicator of mistrust or untruthfulness?
An indicator of hearsay is more reliable when it comes from the speaker, and we have Mr. Tran's testimony on the same event, and the testimony is not consistent.
But we also have a sworn testimony, and Mr. Green was sworn to tell the truth. Is there an indicator that perhaps a misstatement was made?
Yes, because we do not have a single picture of a green finger, and nor have I ever seen a green finger. Nor is that consistent with anything else that we have in our record here. It would have been pretty clear if Ms. Hall's finger were green when she walked in, that nobody would have touched her, and she would have been at the hospital a lot sooner, in my mind. Yes.
And that's your perception, but
I think it's a reasonable inference, yes.
I'd like to make a statement right here. Your client just admitted that there was an infection here, that her uncle told her that.
I didn't say there was an infection. I said it was a little pink one time or 2 times, and then.
And did you just say that your uncle told you that they tried to tell her no, and
they told her, they advised her not to put the acrylic on, and she.
And why do you think they would advise her not to put the acrylic on?
Because they probably saw something that they were not happy
Thank
with.
you.
You're welcome.
So even though NAC 644-360 states that no person shall perform a service on somebody, if they feel that that's the case, they still did that, right?
Well, It's hearsay. It's what's being
No,
recounted.
it's not hearsay. Everybody that's been involved in this case has testified to the fact that what they're saying is that she walked in and her finger was pink or her nail was pink or there was something going on with it, and they still performed the service. Nevada Administrative Code 644.360 states that you shall not perform a service on somebody who you perceive to have a communicable disease, and yet they admitted repeatedly that they did it even though they said they shouldn't. They still did.
Well, I'm not sure little redness or pinkness is a communicable disease, but I was just clarifying.
As a licensed cosmetologist in the state of Nevada, if I thought for any reason in any way, shape, or form that somebody I was touching was something that I shouldn't do, then I wouldn't do it because it's against the law.
Just clarifying, though, that Ms. Tran, who is the witness now, did not testify about the condition of Nancy Hall's fingers. She said that she personally, I did not work on Nancy Hall then. What she's recounting.
Right, I
what
understand
she's
that. We're
recounting-
establishing previous, what previously was done to Ms. Hall with her as the manicurist.
Right.
But what's before us is a review of the case of 5 claimants of relief, and we're trying to establish all that, right? So,
Mr. President, there is one person that says that her nail was not red, and that would be the person who had it done to her. The client specifically stated her nail was fine.
Okay.
I have to disagree with that conversation because she actually had the conversation, and I have to look up the page now. But
Please
if I
take
could
your
just go
time.
by memory,
Yeah, take your time.
she knew that there was a discussion about her not having nails, and she was advised not to have nails, and she persisted on having nails. She was informed that something was wrong. I'm not getting that her finger wasn't red or whatever. I have to look it up. So could you-
But in her testimony, she says, I went in and there was nothing, and my nails were fine.
Okay, wait a minute. Bear with me. You can come back.
Take your time.
Please take your time. Okay, so I guess we're going to have a 5-minute recess while we get our ducks in a row. Okay, so we're called back into order or session at 12:37.
Would you like me to finish up my thought then?
Please, Ms. Benaldi.
Okay, on page 209 to page 211. Hearsay to me would be something like Mrs. Hall's testimony saying that she cut her nail too short when she could have been meaning that she had it done too short. That would be hearsay, in my opinion. And it's humble at that. But on page 209, so we went and I met with the owner, Miss Tran. So this is Mrs. Tran's involvement. Miss Scott conducted the inspection while Mr. Green was speaking with Miss Tran. So this is a conversation with Miss Tran. And she indicated, let's say, Miss Tran in our conversation indicated to me that she was aware of the incident with Miss Hall. And I think we've already went through this, but I think it's relevant to the part that we're getting to. She indicated that Mr. Tran is her brother and Miss Nigan, or Miss Wen, I'm sorry, is her sister-in-law, that they were not working for her any longer as of June 11th. She told me that I believe they moved to California, but that she believed Mr. Tran was working at the New Image in Carson City. And she was told anecdotally of the incident of Mr. Tran, and when he indicated to her that was Miss Hall had come in on the date, November 1st, 2010, and when she came in, he could see some infection on her finger. So this backs up from the next, which is 11. I don't know how far you want me to go on this. But it seems to me that if I was a client, again, with cutting my fingernails too short, that if I wanted to have my nails done, I would want to have them done. And we all know that clients, and this is leading into other things that we're going to be discussing later, they all ask us for things and put us to the pressure of doing things that we don't want to do. And then we perform that. But what we have to remember is that we're held by law to be accountable for what we do. And it seems to me that they all had this conversation that she had an infection in her finger. And that is the basis for the relief.
My understanding, though, and you read straight from the transcript, but my understanding of what this testimony is Mr. Green's testimony about his interview with Miss Tran about what her brother told him about what happened previously. So that's what Mr. Green is testifying to. I'm sure it's as accurate as he can make it, frankly, but it's gone through about three renditions of hearsay by this point. So
I see what you're saying, and in all due respect, but we were there, so we heard it directly.
Right.
So
Right.
you weren't there, but we all were there.
Right. I'm just making sure that we aren't saying that that's Ms. Tran's direct testimony, or that she had the conversation when this event was happening, because she didn't. These are the conversations after the event. Right. They weren't consulting with her.
But it goes down in the transcripts when they talk to her.
After the event, right.
It goes through.
Yes.
Correct.
Yes.
I see what you're saying.
I'd like to say something, if it's okay here. Ms. Trans did, at the last hearing, show us the Chinese oil that she gave the lady to take care and treat whatever was wrong with her finger.
Right. Okay.
Okay.
All right, I have a question of Ms. Bradley. Ms. Bradley, we have 5 claims of relief here. We have factual allegations to support these 5 claims of relief.
To me. I think that'd be to me.
That's for you? I was just going to ask if you could tell me which allegation goes with which relief, but no. Okay, I won't.
Any further questions of the witness from the board? Okay. Any further testimony, sir?
No further testimony or evidence, no.
Ms. Bradley?
I have nothing more to present. I would just like to make a closing when you're ready.
at your pleasure.
Okay, thank you. I would submit that the testimony and evidence presented to the board does support a finding that the factual allegations have been proven, factual allegations 1 through 49, and that the violations of law, and there's 5 of them, have been proven by the evidence today. I would remind the board that the burden of proof is substantial evidence. So substantial evidence is something such that a reasonable person could conclude that the acts occurred. The board doesn't have to make a finding that it's beyond a reasonable doubt like we often hear. This isn't a criminal case. And so it's just substantial evidence. So we have to put forth substantial evidence that the violations and the factual allegations have been proven. Looking at the factual allegations, the first several are background information that I believe are supported by the exhibits. So factual allegation 1, the complaint was received by the board. That's Exhibit 3, I believe. And then there's information regarding where the salon is. Again, those are in the exhibits. And then we heard Mr. Green's testimony regarding his interview with Ms. Hall. And so we have a lot of facts here regarding what Ms. Hall told to Mr. Green. And then on we get to number 24, and now it's Mr. Green and Ms. Scott went to Dainty Nails to speak to the owner, and so there's facts regarding that conversation. And then he went to speak to Mr. Tran on that same day, March 14, 2012. And so there's facts regarding that conversation there. These are all facts as related to Mr. Green. So, for example, it says Tran stated, Tran further stated, Tran reported. So these are all things that are being told to Mr. Green. And then on or about March 16th, we have information regarding Mr. Green's conversation with Ms. Nguyen. And then 48 is the summary of the citation history and the prior inspection history for Dainty Nails. We had testimony from Mr. Green regarding the reasons why a person or a salon may employ unlicensed individuals and may not follow all the sanitation rules set forth by the board, one of which may be to save money or have customers be treated more quickly at the salon. Also, you all as licensees have expertise and knowledge about what happens in a salon and why things may be done. You've seen things and experienced things, and the law does allow you to use your own personal knowledge and expertise as you decide the case. So some of the determinations and the findings you make can be based on your own experience as experts, as practitioners in the field. So I would submit that the first violation of law, which is failing to employ proper sanitizing and or infection control procedures, has been proven. We have testimony regarding the inspection the day of the investigation, previous citations. We have, I think, more than satisfied substantial evidence in this regard that there's a pattern of not following the proper procedures at the salon. The second claim for relief deals with performing a service on a client with an infectious or communicable disease, and you've heard lots of testimony about that, and I would submit that you have heard enough information that you can find that that's also been proven. Third claim for relief is regarding performing a nail service on a client with infected or inflamed skin, and that's in violation of NAC 644365. And again, I would submit that the testimony and exhibits support that has been proven. And then the fourth claim for relief deals with gross malpractice. And I know it's the position of board staff, and I would submit to you as well that proper sanitation and infection control is one of the foundational aspects of the field. And so failing to follow proper sanitation and infection control procedures constitutes gross malpractice. Gross malpractice means it's something that's so significant that everyone should know. It's like a foundational thing that is not being followed, and that's why that's in here and why we've asserted that was gross malpractice. And then the fifth claim for relief is that in failing to employ proper sanitizing or infection control procedures, or by doing a service on someone knowing that maybe you shouldn't do the service, that's an unfair, unjust practice, method, or dealing. That violates the law, as we know. You've talked about that today, performing a service, but it's also something that obviously the business has an incentive to do the service, even if maybe they shouldn't, because they receive a financial compensation for it. And so that's why that is there, as well as, failing to follow sanitation procedures. So I would submit that the testimony and evidence that you have received do prove the facts and allegations as listed in the complaint. You will notice that there's information regarding MRSA and the factual allegations, and again, that's background information. We're not asking you to find that Ms. Hall did contract MRSA in the salon, because obviously, first of all, there's no violation of law for that. Nowhere in the NRS does it say it's against the law to give someone MRSA. But it does say you must follow the appropriate procedures for infection and sanitation, and you cannot work on somebody that has an open wound or an inflamed skin or things like that. And so the information is in there. Ms. Hall did testify about that under oath. There are medical records that show that she did have MRSA, and that's why she filed the complaint. So that's background information. It's not being offered to prove the truth that she did, in fact, get MRSA at the salon, or, I think it's undisputed that she got it based on the information you have. And so that's why all of that's there. And then, again, I think you have a summary of Mr. Green's testimony and the inspector's testimony. And so I would ask that you find that all of the factual allegations and the violations of law have been proven. Thank you.
Thank you, Ms. Bradley.
Thank you. Thank you for granting the request for rehearing. Thank you, Ms. Bradley, Mr. Green. A little bit of a strange situation, a confusing situation where it seems we're all agreed now that this board is not going to be making a determination on exactly when or how Ms. Hall contracted her MRSA, yet about 90% of the effort on this case, I think, was dedicated to proving that. So it's a little bit of a strange situation. There are 5 claims for relief. Ms. Tran is aware and fully expects this board to rely on the reports of its investigators regarding the sanitation procedures, and likely the board will impose a violation, will impose a fine. Would ask that the fine be reasonable and ask that she be allowed a reasonable amount of time to pay it. That's the first claim for relief, though. The second, third, fourth, and fifth claims for relief are more complex. And one exception, though, to what I would expect this board to adopt from the inspector's reports, although there's no doubt that the inspectors reported the testimony as best they can, or as best they could in the circumstances, going through 3 or 4 different parties. There's no evidence that Miss Hall's thumb was green when she came to Dainty Nails, and frankly, it's not really credible. We have testimony. Testimony in the transcript is that they're a little pink, a little red. The only evidence we have that it was green is that the thumb was green is Mr. Green's recitation of an interview with Louis Tran. But the pictures don't substantiate that. Ms. Hall's testimony doesn't substantiate that. And more than that, even when Ms. Hall says she came back to the salon because her finger was a little swollen, and they gave her some a Chinese oil, that in my mind seems to preclude the idea that her finger was green. So that is the one issue that really is not the one issue from the inspector's reports that really is not substantiated in our records here. The second claim for relief, performing a nail service on a client with an infectious or communicable disease. Really, we haven't been able to establish by substantial evidence that Ms. Hall had a communicable or infectious disease on the date that they performed the nail service. All the testimony was reviewed by the board. I think the closest we come, possibly the third claim for relief, an inflamed or infected skin condition. Still, we don't really have substantial evidence of an infected skin condition. I suppose that the testimony of pinkness or redness around the thumb relates to the possibility of an inflamed skin condition. Fourth claim for relief is really redundant of the others. Well, it incorporates the others. Alleged flame and infected skin containing a fungus can't be substantiated. The fifth claim for relief, really, the bad faith doesn't really fit at all. That's not part, the bad faith is not part of the allegations of fact in the complaint. Ms. Bradley tried to save this fifth claim for relief today by coming up with this theory of cost-saving measures. There's no evidence of cost-saving measures, and the fifth claim for relief should be dismissed. So I fully expect that there will be a finding of at least one violation here. I would ask the board to consider, however, that it cannot adopt the findings of fact as a blanket finding, because again, many of the findings of fact relate to the claim of how Nancy Hall contracted her MRSA, and as such were even outside of what this board needed to consider today. So if there are findings of fact, conclusions, a violation, I think it needs to be a lot narrower than what we have in the complaint as it's been alleged. Happy to answer any further questions.
Could I make one brief
Thank you.
response? A brief response?
Of course.
Thank you. I just want to remind the board, too, that pursuant to NRS 644-510, that the actions and remedies are cumulative and not exclusive. So that does mean that if something is grounds for discipline under more than one statute, that you're not precluded from finding that. And then I did also want to remind you about hearsay. Again, it's admissible, but it can't be the sole evidence of guilt, so there must be other corroborating evidence. So when you make your findings, particularly with regard to the claims for relief under the law, I would request that you make sure that you do have some other evidence at least, not just hearsay that you're relying on when you make those findings. Thank you.
Mr. Matuska, would you like to?
I don't have any further comments. Just to repeat no, it's not even necessary. I don't have any further comments. I appreciate the board's indulgence this morning.
Thank you.
Thank you.
Okay, so a motion.
I would motion that we go through the factual allegations and findings of fact and determine which ones we believe to be true and which ones we don't believe to be true. I just should do that, right?
You just start motioning if that's what you'd like to do.
All right, let's.
Okay.
So let's. So.
1 through 5, yeah.
I'm also anticipating this might take a little while, and I don't know if we want to take lunch or something.
Yeah. So.
I mean, I
thoughts
don't know.
about that? Anybody hungry? Do we need to bang it out and get it done with? And
All right.
okay.
Okay.
Forward.
I would like to. I'll start with the factual allegations that I believe aren't all that factual or might be misinterpreted. The factual allegations.
Are you working on number 1 at all?
I'm working on 1 through 49.
Well, there's 5 claims of relief.
Right, but
What needs to happen at this point was you need to go through and decide whether or not the factual allegations set forth in the complaint have been proven. And so the first job you have is making that determination. Your second job would then be to go through the violations of law and determine if those have been substantiated.
Perry?
Can I make a motion we go to lunch instead? I thought we just had to go through the 5. Sorry,
Mr.
guys.
President,
Mr. Leader.
is it at all possible, and I this may be a legal question, that if Mr. Nixdorf has concerns about the factual allegations, that perhaps he makes a motion on the factual allegations that he does feel are factual, and he can indicate the numbers that he takes exception to? When I review the factual allegations of 1 through 49, I don't take any objections to any of the 1 through 49. So I'm happy to listen to the motion with any exceptions and then revisit those exceptions if Mr. Nixdorf if he felt that would be appropriate.
That's kind of how I was going to do it. I was going to go through just with the exceptions that I felt weren't proven to me.
Proceed, sir.
All right, number 8, and let's see here. Number 16 and number 15, they all refer to whether or not the instruments were sanitary or sanitary practices were used, and it doesn't appear that, to me, if he took his tools from a plastic box, I could say that that's where he keeps his sanitary items. Miss Hall wasn't able to tell whether the instruments were clean and sanitized. I don't necessarily believe, because the workplace was dusty, that the instruments were not clean or sanitary. That may or may not be true on various occasions, but in this particular instance, it wasn't proven to me beyond a reasonable doubt. I take exception to number 10 and number 14 because it says Hall further stated that when Gwynn drilled her left index finger, she drilled too deep and went through the nail, but Hall also reported there was no pain, no blood, and no discomfort in her nails at the time, where here we have a factual allegation where Ms. Hall specifically reports there's no pain, no blood, no discomfort in her nails at the time. So regardless of what other people are saying, she herself stated that nothing was wrong at the time. And
So 8, 10, 14, 15, and 16 so far,
yes,
just to reiterate?
Correct. Those are the ones that I have exceptions with and have not been proven beyond a shadow of a doubt to me.
Mr. President?
Mr. Leader.
Mr. Nixdorf, you know, I think you were reading into the factual allegations. You seem to indicate there's no mention in 15 or 16. There's no mention of whether that plastic box was a sanitary plastic box I mean, it's just a fact that that's what Mrs. Hall saw. Miss Hall indicated that he took his tools from a box in the drawer, and then he proceeded to apply the acrylic. That's what that statement says. There's no indicator of sanitary or unsanitary in that allegation.
Exactly.
So it's factual. It's not leading you to believe that it's sanitary or unsanitary. It's just a simple fact that that's what she saw. Him retrieve instruments from a box.
On the first claim of relief, it talks by failing to what we're trying to prove here is that we're failing to employ proper sanitizing and or infection control.
Then you can exercise your vote when it comes time to the first claims of relief. In the allegations, you don't want to read into the allegation that it's indicating sanitary or unsanitary. It's neither. The statement is what it is. Hall saw him remove tools from a plastic box. That's all. It's not saying that that box was unsanitary. It's not saying that the box was sanitary. Same thing with number 16. Hall said that she cannot say whether the tools were clean or not. It's a simple fact. There's no implication that allegation will lead you to vote in any way on your claims of relief. It is simply number 10. Hall further stated that when Wynn drilled her left index finger, she drilled too deep and went through the nail. There's no indicator of pain or blood in that allegation. It is just simply the fact, and it's coming from the first sentence of her statement. Then I saw a small hole on my nail bed. So again, that allegation is substantially, seemingly, prior to a vote, true. When you go to number 8, Hall indicated that she could not tell if the instruments used on her nails were clean or sanitized. She doesn't know.
She's just saying the station appeared to be a little dusty. Her comment of dusty has no indication of whether it was sanitary or unsanitary. She even indicates, I don't know. It just appeared dusty. That's an allegation. It does not reference the way that you're going to vote on your claims of relief. And finally, on your number 14, Hall reported that there was no pain, no blood, no discomfort at any time. That's what she said. There's no indicator of whether or not she feels that something happened. She's just remarking that there was no pain and no blood and no discomfort.
Thank you.
Mr. Nixdorf, was there anything else that you wanted to?
No, I'm good right now.
So I'll entertain a motion then.
I'd like to make a motion, please.
Mr. Leader, please.
I'll make a motion that the factual allegations 1 through 49 are in fact true.
I'll second that motion.
Any discussion? We have a motion and a second on the floor.
I'll have one more discussion while we're at it here. Number 4, Hall indicated that she patronized Dainty Nails approximately 3 or 4 times prior to November 1st, and we have testimony here today that says she was there 6 times prior to this allegation.
The testimony, the allegation is coming from Ms. Hall. The testimony today, quantifying it to 6, is coming from another individual. So you can't compare the two responses. One response is this individual's perception. Ms. Hall is making the allegation that she visited 3 or 4 times.
Mr. Nixdorf. Okay. Okay, so those in favor of... Alex, could you repeat that for the record? Your motion.
That the factual allegations were in fact true.
1 through 49?
Yes, sir.
Okay. All those in favor?
Aye.
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 Those opposed? That motion carries.
Mr. President, I'd like to make a motion for the first claim of relief.
Okay.
I'll second that.
Actually, I'm going to restate that so it's...
Sorry. I'm hungry. No.
I'll make a motion
stop.
that the violation of the law NAC 644.340 is in fact that the individual did fail to employ proper sanitation and infection control procedures.
Ms. Booth?
Ms. Bonaldi.
Oh, I'm sorry, Ms. Bonaldi?
No, I'll second that.
Okay. Any discussion with regards to the motion? Ms. Tran, did you have a comment to that?
No.
Okay. All right. Those in favor?
Aye.
Aye.
Aye. Those
Aye.
opposed? That motion carries. Mr. Leader?
You want me to make the motion?
Ms. Booth?
I'll make the motion to approve the allegations of NRS 644.430 as found.
Is there a second?
Mr. President, I believe that that motion should be that the respondent violated 644.360.
Oh, I'm sorry.
And the disciplinary action is under the 430.
Thank you, Alex, for catching that. I'd like to amend my motion to 644.360.
Is there a second to that motion?
I'll second.
Any discussion for the motion on the table? Okay. Those in favor of the second claim of relief?
Aye.
Aye.
Those opposed?
Nay.
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 That motion does not carry.
Mr. President, I'll make a motion for the third claim for relief that, in fact, the respondent did violate NAC 644.365.
Is there a second?
I'll second that.
Thank you, Ms. Booth. Any discussion? Okay. Those in favor?
Aye.
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 Those opposed? Nay. That motion carries.
I'll make a motion, Mr. President, to find the respondent did, in fact, commit gross malpractice and violated, NRS 644, is that 360? Is that supposed to be 360? Oh, it's, excuse me, NRS 644.4301C. Thank you.
I'll second that.
Any discussion for the motion that's on the table?
I would caution against the gross malpractice. I don't know that it's been proven, in my mind, that it's gross malpractice to do that.
Thank you, Mr. Nixdorf. The reason why I made that motion is because gross malpractice takes into account historical complaints and citations against this establishment, and that is the meaning of gross malpractice, is cumulative disregard for the law.
Any further discussion? Okay. Those in favor of this is the fourth claim of relief we're working on now?
Yes.
Yes. Those in favor?
Aye.
Aye.
Aye. Those opposed?
Nay.
That motion carries. Mr. Leader, 4 for 5.
Oh, no one else, huh? I'll make that motion that the respondent did, in fact, engage in unfair and unjust practice, and is ground, and there are grounds for disciplinary action under NRS 644.4301K.
Do I have a second?
I'll second.
Thank you, Ms. Bonaldi. Discussion? Mr. Nixdorf?
No.
Okay. Those in favor of
Aye.
upholding the fifth
Aye.
claim?
Aye.
Aye.
Those opposed? And that motion carries.
Ms. Bradley, I did have a question. I would like to know if the fines or if the claims of relief in that voting, I noticed that some of those decisions were not unanimous. Does that still make the decision a decision?
Yes. So the motion carries
We
by
do
a
not
majority of
need
a
to
vote.
have unanimous consent of the board for any of these voted items, correct?
That's correct.
And because our board operates with a majority.
Correct.
Thank you.
So now the board has to decide what fines to impose, if any, or other disciplinary actions they would like to take.
Didn't we do the fines prior, or are we going to redo?
So we would
Or
be
you need to do that
upholding.
now.
So we need to determine
You need
because
to
we
determine
found
them
that
that this is
4
a
of the 5.
So at this time, you've determined that the factual allegations have been proven and that 4 of the 5 violations of law have been committed. And so now we move into what action, either to impose a fine or other disciplinary measures to take that the board wishes to take at this time. Yes, prior to this, at the prior hearing, you imposed a $10,000 fine.
2,000 for each fine.
Correct.
5
but
violations,
that's-
2,000
This is a
each.
rehearing, so you now need to decide what discipline to impose, if any.
So can we make a motion to, on all four, or do we have to do each one individually?
It's the pleasure of the board.
Mr. President, I'd like to make a motion that we uphold the fines at $2,000 per claim of relief, all 5 claims.
Well, we've only determined that 4 were
we had the 4.
legitimate.
So for claims 1, 3, 4, and 5, each have the maximum $2,000 fine.
Do I have a second?
I would like to add to that.
Wait, we're looking for a second to the motion.
I'll second.
Okay, thank you. Discussion.
Discussion. Can we continue investigation, frequent investigation of the salon as we have before?
That's targeting.
Yeah, which is not considered. Yeah.
So just so the board is clear, NRS 644-430 subsection 2 sets forth the actions that the board may take at this time. You can refuse to issue a renewal license, revoke or suspend a license, place the licensee on probation, impose a fine not to exceed $2,000, or any combination thereof.
So could we add to that we put them on probation?
If the maker of the motion and the second agrees to amend their motion to include that.
I'd like to amend the motion. I'd like to amend the motion that the license be suspended until the fine is paid, and that the licensed establishment and the licensed individual be placed on probation for 1 year.
Would you like to amend your second, Ms. Long, to include
There is no
that?
individual that's licensed before you today, just so you know. This is just the establishment.
Oh, this is just the establishment? So again, I'll amend the motion to reflect just the establishment's license be placed on probation and the licensed establishment be suspended until the fine is paid.
I'll amend my second.
Okay, discussion a lot, actually.
Yeah, so in essence, you're putting her out of business until
we can't
pays
do,
her fine?
Can we do that? Are we allowed to do that as a board?
Yes.
This has gone on for quite some time. This matter happened in November of 2010, and may I remind you, someone is permanently disfigured from repeated violations of the law, permanently disfigured. I do not think that that is too much to ask.
Okay.
I don't believe that was proven. That MRSA and also and the disfigurement was directly involved here. We just proved that she worked on an inflamed and or infected nail. We didn't prove in any way, shape, or form that it led to the disfigurement of Ms. Hall.
I did not indicate that in my motion either.
I'm sorry.
Ms.
We had
Benaldi?
testimony that a doctor worked it out where the timeline proves true to when they were worked on, to when she got an inflamed finger, and then when she had the ailment, and it is binary, or however they stated that this worked out to be MRSA. Now, we all know there's different ways that comes about, and that's not what we're deliberating here, but this woman is disfigured. There is a cumulative violations. We've just agreed on all that. It's not like this is the first time and they worked on somebody and nothing happened. They have cumulative sanitation problems there. And they turn their back on the law continually.
There was the finger was questionably infected beforehand. Possibly they shouldn't have worked on it. They should have turned her away. In my opinion,
Well, that's the law. So that's what we've all voted on here. And now we're saying that we're not sure. I don't agree with that. I think it's completely, I think she's had plenty of time to get it straightened out. And I think we've had plenty of years here now that she should have saved the money for the fine. The fine should be paid. And if she can't pay the fine, then she needs to get a loan or whatever she needs to do to pay the fine. And not continue with these practices.
I just like to
scares
say,
me.
We're here to protect the general public. That's what our job is really to do here, and I think that's what we need to do today.
Mr. Nixdorf, do you have any other comments?
I don't think we've conclusively proved that MRSA and the disfigurement of Ms. Hall was directly caused by this establishment.
We didn't prove that.
Correct. And so therefore I don't feel we should be penalizing her for the fact that someone is disfigured that they may or may not have gotten in this salon. And I think it's completely unjust to suspend her license for that. Paying the fine, that's a different story. But the suspension of license, I'm totally in disagreement with.
Mr. President, I will amend my motion to remove the license suspension.
So for the record, could you state the motion in its entirety one more time, please, Mr. Leader?
I made a motion to uphold the maximum penalty of $2,000 for claims 1, 3, 4, and 5 to include probation for up 1 year of the establishment.
I'll amend my second.
I have a question.
Ms. Booth, just for a moment.
Just 1 second. Could you actually, in your motion, state a time frame for when the licensee has to pay the fine? It comes into play with some other things.
To amend the motion to reflect the timeliness of the fine payment, I would hope to have that fine paid within 30 days.
And Ms. Long?
Anything else?
You're going to amend your
I will
second
amend my second
to say all that stuff,
reflect
all that
everything
junk?
that
Okay.
Mr. Leader has just motioned.
Any further discussion for the item on the table?
Is it normal procedure for us to give somebody 30 days or less? I mean, how does that affect what we normally do, and how is that consistent with what we've done in the past?
I'd have to turn to Ms. Bradley for that. I just know that for purposes, if the fine is not paid, there are provisions that allow you to go to collections and revoke the license or deny a renewal of a license based on that. There's some new changes made by the 2013 legislative session. So a time frame for when the payment, the fine needs to be paid should be included in any sort of motion.
I would just like to be consistent with some of our past decisions.
We haven't had very many hearings where you've imposed a larger fine. Most of the time you're doing citation appeals. So I'm not sure I have that information. I mean, it is common that you have requested, I think, attorney's fees be paid within a specified time period. I don't recall. I don't know if Mr. Landry has any information he can recall regarding time frame. 30 days.
Excuse me, may I say something?
Ms. Blasco, go ahead.
I just wanted to say
usually, I was only going to say that usually we allow people to set up a payment plan in the office, and the one thing that we ask them to do is pay it by their next renewal.
Under the circumstances of the egregious behavior, I am not willing to amend my motion for a timed payment plan. The 30 days, if anything, if this continues, I'm going to amend my motion again to reflect that if the fine is not paid within 30 days, that the license for the establishment be suspended until the fine is paid in full.
Ms. Long?
It is. It is an amendment to my motion.
So you are amending this?
I am.
I will amend my second once again.
If I could just put on the record, Mr. Mateska just reminded me that the last time, I believe you gave 1 year for the fine to be paid.
Now we have a lesser fine.
Yeah.
So.
But a year has gone by.
No, a year. I don't think a year elapsed.
Yeah.
Well, not
the
quite
amended
because of
order
the
went out
order.
in May.
Right.
of 2013, so they have until May of 2014 to pay the fine that was in place, and then it was appealed.
I also want to remind the board that this establishment has had a change in owner after some of these cumulative disregarding of the law. So if I'm to be correct, there were some complaints made, some citations issued, and then there was an establishment license change in an attempt to kind of keep going forward because of these 1-year payment plans that we sometimes do.
Bless you.
I'm not willing to be that negotiable on how this fine should be paid and the timeliness of the timeliness of the payment. I've made an amendment to the motion that the fine should be paid within 30 days, and if it's not, the license is suspended until the fine is paid.
I'm sorry, so I just want to be clear here. We had a fine and a payment schedule set up, but no payments were made.
A deadline, I believe.
A deadline, but was there a payment plan, Mrs. Belasco? No payments.
There hasn't been a final order.
No, they're appealing the
So then, okay.
the first time around.
Okay. Started back over a year ago. Right. No, I was there. Thank you.
I think that Mr. Nixdorf had a great comment about consistency, and I know that that's always been a priority of his, and I highly agree with that. We've already compromised consistency with this, just going through this whole ordeal. We've compromised our consistency, changed our minds, readdressed everything, and I think 30 days is very fair.
Call for the vote.
So I'd like to call for the vote now. All those in favor?
Aye.
Aye. Those opposed?
Aye.
She was a yay. That motion carries.
The board has the option to also impose the costs associated with this hearing and the time it's taken to investigate and put forth this hearing. So you could also make a motion to impose the costs associated with this matter.
I make a motion to impose the costs.
You need to probably include a dollar amount. I think last time there was a cap on the costs.
You can do it as not to exceed.
Normally, we like to let the person know how much they're going to be expected to pay. And so I believe last time there was a cap on the costs.
I would like to make a motion not to exceed $1,500.
Is there a second?
I'll second.
Any discussion for the motion on the table? I'll take a vote then. Those in favor?
Aye.
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 Those opposed? Nay. That was one nay for Mr. Leader. That motion carries.
Is there a time frame for the payment of the costs?
Ms. Booth,
I'm sorry.
is there a time frame for the payment of the costs?
The 30 days.
So then I'll entertain a motion to that effect.
I make a motion that it be paid within 30 days.
The costs for the
cost for the
hearing here
attorney
today.
and the hearing.
And I'll second.
I just want to be sure of the 30 days because the order has to be prepared and sent. So when does that 30 days start for both of these 30-day things?
It would be the date of the order. So I will need time to draft the order, and then I'll send it to Ms. Bradford, who will obtain Mr. Hoffman's signature on it, and then she will send it out. So most likely the order will not be mailed any sooner than 30 days from today.
So we're looking at 60 days total time.
Effectively, I think
Okay.
it would be closer to 60, yes.
Okay.
And so I would like to make sure that administrative staff is directed to that essentially the 60th day, if you will, that's when that license goes into suspension. It's 30 days, but
It'll be 30 days from the date of the order.
The
So
date of
as
the
soon
order.
as that
Right.
is signed by Mr. Hoffman, that's when the clock starts to tick.
and so Mr.
Until
Landry.
you know, until you know when
Right.
the order has been drafted and given to Mr. Hoffman, you can't really put a a
So,
time frame on that.
Since I can't put the time frame on it, Mr. Landry, that date needs to be clearly marked that that license is suspended if that fine is not paid.
So noted, and it will be carried out by administrative staff.
Thank you.
So, vote then. Those in favor?
Aye.
Aye. Those opposed? That motion carries.
I think if I use this thing,
Okay. The State Board will be in contact with you and send you all pertinent information and details. Thank you so much for your time today. Appreciate it. Thank you. And that's lunch. How long? Mr. Leader, you're the president before. How long do we? Lunch is an hour? 45 minutes? Okay, so it is, wristwatch is fast. It is 1:30, so we'll be back at 2:15.
Cafeteria downstairs, coffee across the street, coffee across the street, and mom and pop dining.
I want us all to have lunch.
Choices.
Annie, you guys ready over there? Miss Curtis,
Yes.
Miss Tran, you guys are ready? With our very exceedingly long
Yes.
delay? Okay. So we're calling the meeting back to order at 2:37 p.m. Okay. The next item on the agenda, God, it feels like we haven't talked about the agenda in 5 hours. Is the petition to appear for Stan Winston School of Character Arts.
I think Ms. Coate is not here. She's coming in right now.
She's coming in right now. All right, look at that.
Could I make a brief statement before we start this one? I just want to remind you that I would appreciate it if we could try to refrain from talking about any pending litigation or other matters that might be pending that the board's aware
pending
of.
litigation, bad.
Yeah, so
Okay.
let's just try to, when we
For the
discuss
record.
item 10, to just talk about item 10 and nothing else. Thank you.
No, we're on item 10. Did I? Okay, so agenda item number 10, the petition to appear for Stan Winston School of Character Arts. Could you please state your name for the record? There's a button for the microphone right in front of you. There you go.
We see you love this job. I do. I love my job. My name is Bonnie Lynn Cote. I work for Stan Winston School of Character Arts out of Los Angeles, California. How are you guys today?
Lovely, thank you. Thank you for your patience. We know it was a little drawn out this morning, but please
Really fine.
present what you need to present to us.
Okay, so I have been licensed in the state of Nevada for many, many years, and I started out, like anybody, as a cosmetology student. Not intentionally what I wanted to do with my life. I wanted to pursue special effects makeup, and now with the recent popularity of shows like Face Off and others coming down the pipeline, we have realized that there is a largely underregulated market happening. And we are very, very primarily concerned with the safety and sanitation and the education of cosmetologists or other people like me who wish to pursue this career in its entirety. So we are branching out into a new forum where we would like to be included in cosmetology schools. Oh, thank you. I am too. It's my project. And I'm really nervous. I apologize for that. But we brought you a sample DVD of Lance Anderson, who worked with Stan for over 40 years. We use similar tools in both industries. Stan, for the majority of his career, he brought special effects out of unregulated garages into an OSHA and a safe environment. When you have a $20 million actor sitting in your chair, you do not want to melt something into his eyes or damage his or her skin. And we are seeing a giant resurgence in the practical effects market. So we really want makeup artists, cosmetology people, novice. We want them to learn properly and safely.
Okay.
I have a question.
Miss Booth.
Now, does the makeup artistry in the movie world, do you have different unions you have to belong to and take different tests? So is there a testing process that you would be teaching to the students so they could pass those tests?
Mostly there are a lot of makeup schools in the greater Los Angeles area that will charge a student upward of anywhere from $16,000 to $30,000 for a makeup arts education with a minor in studio setting hair. It's a certificate. It's not regulated by the State Board of cosmetology in California. It's not regulated here. They go, they pay their dues in the industry, and if they're lucky and they can do 60 jobs a year, they will become 706 members. It is very, very hard to do that, and we know that. Our school, we are primarily online. However, like I said, we are branching out. We would like to see, and there is no union in Nevada, but we would like to see some form of regulation, and we would like the permission from the board to be able to approach cosmetology schools and integrate the makeup arts program that we have that is prosthetic based and hair laying in and things that are within our art and science.
I have a question for you.
Yes,
What stops you from doing this right now? Why not just approach a school and just convince them that you need to be part of their school?
That is an excellent question, because I did approach my campus with it. And then I got an email from a prior board member or from my director from a prior board meeting, that it was in the board's opinion that these makeup schools popping up were very underregulated and kind of a free-for-all. So taking people's money and kind of squandering and so on and so forth. And being of an ethical background, I would much rather have the board's permission before I proceed.
But you're not proposing to open a makeup school outside of a school of cosmetology, correct? You're
Not currently.
Okay.
I have another question. This might be of Mr. Landry or the licensing. Is there anything that we'd have to put into the laws to cover makeup of this type? Okay. There's Mr. Landry today.
No, there's currently nothing that would preclude the teaching of cosmetic arts as a licensed instructor in the state of Nevada in a licensed cosmetology school in the state of Nevada. There's nothing precluding that. We do have exemptions, to the other topic that Ms. Cote was speaking to. We do have exemption for all of the shows. So the resort shows that are out there, they are exempt from, as you all know, they're exempt from our guidelines. So for those people that practice at Cirque du Soleil, any of the news agencies and all, they're exempt from our practice.
Is that, when you say exempt, does that mean the person that's teaching the class is exempt?
They're not under our jurisdiction,
That's
is what he's saying.
That's correct.
He means the people practicing, not the people teaching.
Right, the people applying makeup to those shows are exempt from.
Applying makeup are exempt.
They do not have to be they do not have to be a licensed cosmetologist, esthetician, nail tech if they're doing nails, or hair designer if they're doing just hair. They do not have to be licensed by the Board of Cosmetology to practice that craft within the resort setting. So if you're doing within and it's movies, TVs, and any of the resort shows.
I just want to clarify, because I think, I'm not sure earlier when you talked about the board and a decision by the board. I mean, the area is regulated. The law says that if any establishment that's teaching a branch of cosmetology for a fee must follow the provisions of a school. And so I want to make sure we're clear that it's not that the area is unregulated. The way the law currently stands is makeup schools need to be occurring within a licensed school. And students do take, commonly, classes in makeup. And I've seen some very fancy photos that different schools do, turning students into avatars and, a Simpson character and things like that. So it's not that these things aren't being taught, but they need to be taught in a licensed school. So that's where the law in Nevada currently stands. So I want to make sure we're clear that it's not unregulated or a free-for-all. In fact, the law says if you're teaching it, it has to be in a licensed school. Not that the law can't be changed, and I think the board has previously maybe even voiced a willingness to pursue that with the legislature, but unfortunately the NRS says anytime it's being taught, it has to be in a licensed school.
And in a licensed school, does Ms. Cote have to be a licensed instructor?
Yes.
Yes, she does.
Which she already is.
Okay, good to know.
So have you approached any of the schools? Because I originally, before even getting cosmetology, went to Joe Blasco in LA. So I know where you're coming from with this. It's very exciting, but it's very, very different than just traditional or even airbrush makeup. I mean, it's a completely different animal altogether. So would you go into these schools and offer an option to be able to come in, for the students to come in to do that? And what kind of incentives are you prepared to offer those? I mean, those kind of schools, I'm sure there's some kind of, ideas that you have. Obviously, you're here and it's well thought out, and you seem like a very educated woman. I would love to hear what options you have on approaching these schools and how we can help.
Okay, well, what we would like to do is structure a 900-hour program similar to the esthetician program, where they would spend 150 hours working out of the Milady makeup text, workbook, whole 9 yards, online testing, follow that curriculum guide. At that point, begin a phase 2 program where their core training would be on prosthetic appliances. And
now, is this something that, and this I guess ask anybody here, is this something that already licensed, a licensee,
I would like it to be, yes,
can go back into that school and be able to take this class? Because that would be really attractive to a lot of the licensees I know personally in Las Vegas, area, I'm sure in Reno as well. That'd be really an exciting thing to do, to be able to go back and refresh those skills.
that is exactly what I would like to see happen eventually. But like I said, I did not want to proceed without board permission. It is just not in my nature to do that. But we would love other people that are licensed to come back in and really come play with us. We have, our curriculum starts with prosthetic makeup, and it goes all the way through full animatronic. Yeah. And it's taught by pretty much everybody who ever worked for Stan Winston in his 40-year career. And then the core members went over to Legacy Special Effects, and we have been an online school, so people are doing the makeup themselves or they're subscribers to our online school. And I have been sampling it in my school. I teach a special effects program that encompasses the month of October. And I've seen some really talented students who really want more. So we figured if you could structure a program and then encompass our traditional aspects with the Milady text, and then give them the beauty makeup, give them the editorial makeup, the airbrushing. When I was in school, I was more about making my doll head gross. I mean, for lack of a better term, really. I was more about that.
I have a question for Miss Annie. Can you hear me, Miss Annie?
I hear you. What is the question?
My question to you is, can a program like this go directly into one of the schools without coming up with any rules for the prosthetics or something like that? Could she go open up a class today with the laws that we have on the books?
With the laws that you have on the books, there is nothing that prevents her from going into the school to teach makeup.
I'm talking basically about the prosthetic portion of it.
That would fall under makeup.
Okay, good. So there's
to what degree the school would want to carry it would be up to the school.
Okay.
It still falls under makeup. So there is nothing that prevents that type of curriculum being taught.
Great, thank
within
you,
the
Annie.
school.
It looks like you can go do it.
I have one question just to clarify. There's nothing to prevent a student from taking a class in a school of cosmetology that is not interested in becoming a cosmetologist, that they can provide classes to any person they wish to, regardless of whether they're going to be a hairdresser or cosmetologist of any kind, correct?
Well, I mean, the purpose of going to school would be to get licensed in whatever form you, be it manicuring,
sure, but she's going to be
trying
to collect students that may or may not want to be cosmetologists. They just want this information? And is there anything that will stop a person from enrolling or being in that establishment that is not interested in being a cosmetologist or in this field?
Well, what do they come out as? Makeup demonstrators?
It doesn't matter what they come out as. They come out as people who have taken her class, certified. It's not.
How do you do the makeup artistry right now?
Well, see, they could go to LA and they could work in there, or they could go to work for these resorts where they now have a skill set, but they don't have to have a license to work in that resort, for instance. So they would prefer some gainful employment. Maybe they just want to do it just for themselves, just for who knows what motivates a person to go to that school. My question is can a school enroll people who do not wish to have a cosmetological test
or aesthetic license
or aesthetic license
No,
or
then
anything
they just
of
go
that
to
sort?
LA and take her class privately. But is there an option for her to be able to also offer CEUs? Is that an option?
As a licensed instructor.
She is a licensed instructor.
In the footprint of a school.
Absolutely.
So
offer CEUs, get a CEU form from the State Board office as well, and submit that. That would be an exciting option for instructors to be able to take these CEUs.
So I guess my
Brings a
question
valid
is to
point
staff,
up, yeah.
right? Is there is nothing that precludes a person from enrolling in a school who does not wish to have the current completion of a.
You are correct, Mr. Nixdorf. There's no requirement to be licensed upon completion of any single course or accumulation of courses, 1,800 hours and beyond. There's no requirement for licensure. So any school has the ability to teach any course to any person, and the culmination of that does not have to be licensure.
So then you wouldn't need, to the best of my knowledge, you wouldn't need our approval because we can't really approve it. All we can do is say you can't do that because there's a law that says you can't. And if there's no law that says you can't, I think you have a great idea. I'd love it.
Yeah, I do as well.
Good luck.
So can I entertain a motion then?
Yeah, what is there a motion to make?
Well, there's an agenda item on the agenda that Ms. Cote would like to have.
How about I make this motion?
Mr. President, I'll make that motion.
Thank you, Mr. Leader.
Just for clarification, there's no requirement in the NRS or NAC for a licensed cosmetology school to offer specialty makeup courses, but I would like to authorize Stan Winston School of Character Arts and the representative Bonnie Cote, who is a licensed instructor, to be able to offer independent specialty makeup courses to be taught in existing cosmetology schools that are licensed in Nevada.
I'll second.
Any discussion?
Yeah, I just have one quick question. So once you're there, you're teaching in schools, are you going to be offering a certification?
We want to have that very structured program, like I said, with the 900 hours, and model it directly off of our cosmetology license, which would include portfolio and testing as well. We want to have testing. We also have a business fundamentals program. The third phase of the program would be set etiquette and a live online course where they would interact with a working special effects artist. And they will have a final project. They will have Q&A moderated through Google. We use Google Hangouts currently. Moderated. They're given a project. They have a demo. They do a Q&A. They work on their project for a week. They reconvene with that particular instructor, and then they go forward. And as well as more of how to behave on a set, how to increase the drive, how to increase the motivation, how to find the jobs out there, because there really are a lot of jobs out there, but the career placement is difficult. You really have to be motivated to go get it. It took me 20 years to get to this point.
Can we as a board expect to, probably through staff, I would imagine, receive whatever curriculum you come up with moving forward as to...
Absolutely.
Okay.
And
Absolutely.
I have one more question. I guess it would be for Sarah. So let's say a gal goes in, she just takes a makeup course, and now she's going to work, I don't know, open up her own makeup school or makeup store and sell makeup. Are we regulating that or not regulating that? Would they have to be an esthetician first, then take the makeup course? Or
It sounds like they just want to allow students to take these courses in the school. So I think it would be students of any type, meaning, I mean, from what I'm hearing, students who have no licensure at all, and then students who maybe don't want to pursue licensure, and then maybe people, I mean, I don't know how often it happens, but maybe a licensed person goes back to school every now and then to take a class. However that works, I mean, the key for the board is that anytime a branch of cosmetology is taught, it has to be in a licensed school. And so here, you can't force people to get licensure. Certainly the contract that they have would still be reviewed by the board, and then the hours would count for something, meaning there could be students who get esthetician licenses and maybe take a couple of these classes, I don't know, as a part of their program.
Okay, but if they just go in for makeup and then they go to get a job, don't we regulate like even Estee Lauder counters and such?
No, that's demonstration purposes, and we're not.
Retail establishments are actually expressly limited by the legislature. So, like the big department stores that have people at those counters, they're totally independent. And part of the reason for that is obviously those big department stores have insurance and things like that. So it's not maybe completely unsafe for the consumer, but those are completely not regulated by you. And then there are people that are makeup demonstrators that work in establishments. And so again, those would be regulated by you. And then someone who wants to open a makeup store, I think it would be similar to a retail establishment, and there's a lot of those, and they maybe put makeup on to show.
So we wouldn't regulate in any way. So she would be doing makeup, accepting money, and we're not regulating it.
Well, she's doing this. Her classes have to do with the school. I mean, she can only do this as a licensed instructor, which she is, in a licensed establishment. This would be a course that the school could offer.
But in addition to everything, I guess the lack of communication is this. So she's not saying that only Estes take it, or only Cosmos, or only nail people. It's anybody goes in, and then they can go get a job as a makeup artist and then accept money for it. And it really has nothing to do with us. So I just don't see that. I mean, why does it have to be in a school if we're not even regulating it?
Because to be an instructor in the state of Nevada, especially with regards to makeup, it has to be in the footprint of a school. That's the NRS's.
And the law also says that any time any branch of cosmetology is taught, it has to be in a licensed school, period. So if you're teaching cosmetology of any kind, whether it's haircutting, makeup, waxing, any type of cosmetology has to be done in a licensed school. And so makeup is part of cosmetology, so it has to be done in a licensed school. Who takes the class is really up to the school and the student and the instructor, who they accept in the classes.
Pardon me for interjecting, but I'm going to interject right here. Part of my design on this program with my co-founder and founder, my bosses at Stan Winston, Matt Winston, and Eric Gray Lidoff, is to include, per board inclusion, a safety and sanitation test every year, and they, just like we do with threading, and a certification process. I really think it should be highly mandated that way.
I think it's better for you to have that certification. It's more, professional, which is nice, and them going to school and obtaining that certification would be great. It just seems, I don't know, we're going to make everybody go to school, but then when they get done, we really don't care. So it just seems silly to me why they have to go to school in the first place. But it's the law is the law. So
it's not the providence of the board to make them get certified after they go through school and all that.
Yeah, and we're not making them go to school. The key is that if you're teaching cosmetology, it has to be done in a school.
Okay,
these people could go and try and get a job in this industry without going to school at all. I mean, I don't know that the odds are very good they'd get jobs. Okay, it does happen apparently. So, I mean, they don't even have to go to school. We're not requiring that. We're just requiring that in Nevada, if cosmetology is taught, any branch must be done in a licensed school, period.
I think it's a good idea.
Yeah, I think those that work in the industry and aren't licensed in it, they're just lucky. They just hopped onto a set with somebody and hooked on with a makeup artist and learned back in the day, and they've been doing it forever. And a lot of people have done that. I've worked on movies before, and I just got lucky. You just at the right place at the right time. So I think your idea is great.
So while we're on this topic, I have one last question.
Yes,
not so much of you, more of the staff. Supposing an esthetician takes your class, and now they have an esthetician's license, and now they come under the regulation of the Board of Cosmetology, can that person then go work at a resort or a makeup store without any conflict, right? Because they are literally practicing cosmetology outside of a cosmetological establishment.
They can, because it's specifically exempted that activity in performing an activity at a resort for a show, for a movie production or a TV. They specifically are not performing cosmetology services as licensed cosmetology services as defined in the state. Those specific activities are exempt. So they are exempt from all regulation, including ours, whether they're licensed or not.
It'd be similar to an esthetician who works in a doctor's office. In that situation, the person isn't actually working under their personal license. They're working under the doctor's license. And the same would be true in this case. If an esthetician wants to go work at a show set in Las Vegas, there's nothing wrong with that. And maybe being licensed helps them get the job. But at that point, they're actually not really working under their license anymore. They wouldn't even be required to keep it current because they're exempted out from having licensure.
Mr. Leader, there was a motion somewhere in the beginning of all this.
Yes.
I second it.
Okay. Any further discussion? All right, so let's have the vote then. All those in favor?
Aye.
Aye. Those opposed?
Joanna?
Okay, so that is unanimous.
I look forward to hearing
You said something
and seeing
about
all.
DVDs, so yeah.
Yes.
Good luck.
Yeah.
Facial hair application and hair knotting. Who likes the wig?
I'd be interested in it.
Sure.
I'll take whatever I get.
Pass it back to Neil.
Oh, go ahead.
That's fine.
I don't know. You guys can toss them around and check them out.
We'll trade.
Switch. Enjoy. There's more online if you guys.
Thank you.
Okay.
You didn't want this one. Yes.
Agenda item number 11. Is Miss Madden present?
She's in.
Get nailed 24/7?
Isn't she in Las Vegas? She's in Las Vegas.
Annie, is she there?
She's not present.
Okay. So I guess we're just going to move right past that? Or do we make a motion? Because it was on the agenda, we have to make a motion?
Well, if she's not there, she's asking for a variance. I think you can deny the variance because she's not present today, or you can review the materials and make a different decision, whatever you're comfortable with. But, normally they're present. I think she wants a variance for a nail salon kiosk. And apparently, it looks like from looking at the staff report that she hadn't provided staff with the specific variance request as of the date of the recommendation. So it may be good
So
to
she
just...
wants a variance, but we don't even know what.
Yeah, so I'm
All right.
thinking it might be appropriate to, if you're of the opinion, you can deny it, and then she can always come back in the future.
Okay, so I'll entertain a motion.
I make a motion that we deny the variance for Beth Madden.
I'll second.
Motioned and seconded. Mr. Leader, did you have comments?
Well, I just wanted to refer to Ms. Bonaldi's comments at a prior meeting when we were being given just excellent support documentation for that kiosk, that nail kiosk. I believe it was in the LA or the Las Vegas airport.
Yeah.
And that presentation was just so outstanding. It's very difficult when somebody provides this type of request without that supporting documentation, because I always want to compare it to
try and visualize what it is they're asking.
Well, and particularly to that one presentation, because it was just absolutely outstanding, and it made making the decision so much easier. So I would just like to see that staff maybe stay on top of things like this, even if they're not going to provide this supporting documentation prior to the meeting. I think you should at least advise them, maybe go back to our records and pull pull that supporting documentation from that prior and kind of give them an indicator that it could sort of look similar to this presentation, and the likelihood would be so much greater for them, if that makes sense.
I'd like to add to that. I think that probably this shouldn't have even come forward to this point if they haven't supplied all the data to staff in order to go forward. Because it's just a waste of time. It's a waste of our time to read it. So I think if they don't supply all the documentation needed to go to even review it, then we shouldn't have to get to this point.
The only hesitance I have is they requested to appear before the board. They have that right as a licensee. We have continually asked for detailed documentation. We gave them the variance request checklist so that they would know, if they're asking for things, these are the things we're looking for. So again, if the board instructs me to do that, I can't execute on that. My only hesitation is when someone asks to appear before the board.
Right, it's their right. Yeah.
Exactly.
So let's have the vote then.
She could have brought it today. I mean, it sounds like she didn't have it as of the day that the staff recommendation was written, but it would have been, possible she could have brought it all today, and maybe you could have made a decision. So the issue we have is she didn't provide it ahead of time. She's not here today to give you additional information.
Can I ask this question? Isn't all this information online? Don't we put this all online, the board packet?
No, not the entire board packet, no.
Oh, you don't? Because if somebody had a question and wanted to protest, I was going to say, they don't even know what we're talking about here. So that was just my thought is if the general public out there was opposed to it, they could go online, look at what was going on, and then make an objection. But if it's not here, they can't review it.
Well, actually, under the open meeting law, all supporting materials the board makes available to anyone who asks. So on the meeting agenda, it says to contact Ms. Bradford, and she will provide the supporting materials to anybody who asks.
Yeah, so it's not there for anybody even to make an objection to it if it was going in an area where they didn't like or something. So that's my thought, that we're doing something that the general public can't even weigh in on.
So let's have the vote then. All those in favor of the motion?
Aye.
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 Those opposed? That motion carries. Agenda item number 12. Looking for Sayeda Rauf. Am I saying that right, or am I butchering that immensely? Annie, is she there? Is there anybody there beside
Yes,
you?
she's walking up to the podium.
Oh, okay. Thank you.
Mhm.
Hello.
Hi.
Could you please state your name for the board, please?
My name is Saida Rauf.
And Ms. Rauf, why are you in front of us today?
I'm just here to appeal petition for opening up a booth, like a mini salon at the Fantastic Indoor Swap Meet here in Las Vegas, which is, I know the state board requires the distance from the door of the salon to the restrooms to be only 100 feet, but the distance in this particular location is 140 feet from the restrooms. So I'm just here to appeal and see if I could, if you guys can approve that or if not.
Okay. Mr. Leader.
Ms. Rauf, on your application, you indicated it was 140 meters, but did you mean 140 feet?
Yes.
And is there a dispensary sink? I noticed you said that there's hot.
There is a hot and cold running water sink, but they are willing to install a dispensary sink as well as soon as if it's approved and inspected.
And do you have any self-contained wastewater that you'll be concerned with?
I didn't get that. I'm sorry.
Well, on the variances for this type of kiosk, it is because they've been using portable sinks, and with a portable
No, it's not a.
Right, that's what
I'm sorry, it's not a kiosk.
Right.
It's a booth. It's
a booth.
It's like a small salon. It's not a kiosk.
Okay. And so there's no portable wastewater that's happening. It's
No.
plumbed for wastewater.
Yes, everything. Yes, everything is plumbed so that it's just like a regular shampoo bowl and a sink.
Thank you.
Any other questions?
Are you doing hair or nails?
Just hair and makeup. I don't do nails, and no, I do not like to do any nails in there. So just eyebrow threading and hair, mostly hair, like highlighting, coloring, cutting, extensions, as well as makeup. I'm a makeup artist as well, so just those.
So do you get an establishment license?
Well, of course.
No, I need to get that. I need to get it approved first, so that's why I'm
Oh,
here.
then you can get
before
it.
I get
So
a-
basically, you're asking for 144 feet to the restroom, and then you can get, if we approve that, you can get your establishment license?
That is correct.
Okay, thank you.
Mr. President, I'd like to make the motion to approve the petitioner Saida Ralph's request to deviate from NAC 644.320 and NRS 644.111, 644.120 to include an additional 40 feet distance from her establishment to the restroom.
I second that.
Okay, so we have a motion with a second. Any further discussion to that, Ms. Benaldi? No? Okay. Okay, so I'll call for the vote. Those in favor of the motion?
Aye.
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 Those opposed? That motion carries.
Thank you.
You're welcome.
Did we have a vote from Ms. Tran?
Yeah, she said yes. She voted in the affirmative.
Yes. Yes.
Okay. So staff will take care of that, and all right. Agenda item number 13, petition to appear. Page, is it Schlumpberger? Schlumpberger? Yeah, butchering it no matter how I do it. So can you state your name for the record, since I butchered it?
It's Paige Schlumberger.
Schlumberger. I was just overthinking it. Thank you.
I'm very German.
May I just ask a quick question before your presentation? Is the microcurrent technology, is that the equivalent of galvanic?
Hi, this is Tara Valdez. I'm along with Paige. I'm the COO, co-founder, and also an esthetician. So I'll be answering a number of questions. So Paige and I will tag team each other, if you will.
So when it's called a microcurrent or electrical nerve simulator, is it galvanic? Is that how we know it?
It's no, it's a different technology, being that galvanic is a direct current, either positive or negative, and microcurrent's an alternating current. So along the same lines, but a little bit different. It's also a lower amount of current than galvanic. But in some of your 9-in-1 machines, the steamers, galvanic, high frequency, sometimes microcurrent is also present.
Thank you.
So I'll just begin, and please feel free to stop us at any time. We'll walk through the different items. But Paige and I are here today to get your approval and blessing for NuFace to be used within your spas in the state of Nevada. We've been, the Carol Cole Company, who's the manufacturer of NuFace, is a company based out of San Diego, California, and we've been operating for 9 years now. Carol Cole, who is also my mother, has been working with microcurrent technology for over 30 years. She's been working within San Diego as well as LA, treating clients with microcurrent technology. So NuFace is the first and only handheld device that's FDA cleared for facial stimulation for over-the-counter use. So no prescription is necessary. So currently our distribution looks like, we grew up in the spa industry, so that's where we specialize. However, you can find NuFace on QVC, Ulta, Neiman Marcus, Nordstrom's, Bergdorf, as well as online. So in your packet, you will find one of the biggest items is the NuFace packaging, which is the sleeve. Can I have that page? Yeah. And you've probably read this, but with NuFace, it's the NuFace Trinity. It's a facial toning device, so it's clinically tested to improve contour, tone, and reduce fine lines and wrinkles. So currently, it is used in the treatment room by professional estheticians and then retailed to the clients to maintain the results at home. So the treatment's very relaxing, soothing. It really feels like a facial massage. I say it's even better than a facial massage because it's so relaxing. And you will find on one of the pages a Skin Fit facial. That's the protocol that we recommend to our estheticians to use in treatment room. Being that we are FDA regulated, we go through stringent audits as well as approval processes of what the labeling mentions, our user manuals, instructions for use. We also do a usability study to make sure that the users understand how to use the device properly without causing any adverse reactions. So all of that information is present in the user manual, which we also provided for you. We also have a quick start guide, which allows users to begin using their device quickly. As we all know, when we purchase something, we maybe don't necessarily read the user manuals thoroughly, but we just want to get to the treatment. So we also include a quick start guide so our customers can learn how to use the device effectively, as well as some of the frequently asked questions. We did include our a summary of our 510K. So as I mentioned before, NuFace is FDA cleared. We're a Class 2 medical device for over-the-counter use. So we are FDA cleared for facial stimulation. So again, what we would love to get your blessing on is for your estheticians in the state of Nevada to use the device in treatment room.
Mr. President, just as a friendly reminder, cosmetologists who are licensed are also able to perform aesthetics.
So noted.
So I'd like to make a motion that we add this list to our list of approved devices.
Do I have a second?
I'll second that motion.
Do you have any conversation?
Now, after it's been motioned and seconded, would you like to?
I have a question.
Okay.
Are we ready for discussion? So
Yes.
I just was wondering, with this device, I think it's fantastic. Have you guys been sued for any of your restrictions over the last 9 years? Like
restrictions.
Like it states don't use on children, pregnant women, subject to seizures, cancer tumors. Have people come back with you on you guys for any of these in the last 9 years?
No.
Okay, good. Thank you.
Mr. President.
Mr. Leader.
Is it Ms. Cole? Ms. Cole?
Valdez.
Ms. Valdez.
Valdez.
You know, I received the packaging and the quick start guide and the facts. Where was my device? Just kidding.
Need those to be sure.
It's on its way.
Okay, so
I
let's.
knew you were going to ask that question, actually.
So let's have the vote then. All those in favor of the motion before the board?
Aye.
Aye. Aye. Those opposed? That motion carries. Thank you so much.
Thank you. Thank you very much.
Okay. Agenda item number 14. Board will consider the presentation of the proposal for the Nevada State Board of Cosmetology seal as allowed under NRS 644.080.3. Mr. Landry.
Yes, make this short and sweet. We are allowed to have a seal. We have not adopted a seal. The proposed seal is shown on the board packet, where we're borrowing liberally from the Attorney General's office. They have their own official seal, and we would replace in the board packet from office of the with board of would be on the top. Attorney General would be replaced with cosmetology. It's basically the state of Nevada seal with the silver ring around it, since we are the silver state.
Okay.
I'd like to make a motion that we do adopt the seal as it's been provided.
I'll second.
So we have a motion and a second. Is there any discussion? All right, I'll have the vote then. Those in favor?
Aye.
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 Those opposed? That motion carries. Agenda item 15.
No, I'm not.
The presentation of proposed Nevada State Board of Cosmetology best practices. Mr. Landry, you're on again.
Yes, again, short and sweet. This practice guide was taken from a national consultant who reviewed hundreds of board operations. It really basically defines who does what. Board focuses on policies and strategic direction. The executive director focuses on operations and achieving the strategic directives of the board. And again, I didn't write this document. I adapted this document from a national document that this consulting group had put together.
My question is, how do you want us to use this document?
If you adopt it, then what I would do is part of the process that they outline is that we do a self-evaluation, and we could prepare those for the board members. It would allow us to have a self-evaluation, so each board member anonymously could fill it out, and then you could discuss it as a board, either at a meeting or retreat. The other thing that it does is it identifies and lays out all the responsibilities of the board, the responsibilities of the executive director, and where we work on things jointly or separately. And again, this is from a national study. This is not from my recommendations, but I do agree with. I've worked with other boards in the past, and this is fairly standard on. You do policies and procedures. I don't vote. I run the operations. You don't run operations, and that's kind of the division between the two.
I'd like to make a comment. Is that okay with Neil?
You're a board member. Comment away.
Okay. I just think this would be better served if we had, like at our retreat or something, if we went over this. As I was reading it, it said under board member role, and it told me that I needed to be obedient. That's usually something I ask my dog to do, and he never does it. But I just think I would like to, I myself would like to do at a retreat, really go over this and dissect it, because I don't feel like I had enough time. The self-evaluation, it says to do it annually. We have a hard time doing some important things, and I would hate to think that we would be bogged down taking a self-evaluation and answering some of these questions. And I thought maybe that we could I like some of the things that are said in here, but I think there's some of it that's redundant, and I think that we should really go through this and decide what best fits this board. That's just my opinion.
So if that's how you want to proceed, you could propose a motion if you'd like.
I'd like to make a motion at the next board retreat that we go over this and we come up with a policy for our board at that time.
Is there a second?
I'll second.
Any further discussion? So essentially what we're doing is moving this to a board retreat and not deciding it at this time, correct?
Correct.
Okay. Any further discussion?
Mr. President, I would then like to have administration schedule that board retreat.
Okay. So noted. Let's have the vote then. Those in favor of the motion on the table?
Aye.
Aye. Aye.
Aye.
Those opposed? That motion carries. Agenda item number 16. Mr. Landry.
Again, I took the strategic plan that was presented last time, made some modifications or revisions based on board comments. I revised the vision. I revised the strategic themes. I added key results indicators, which are those things that the administrative staff would, or that I would be reporting to the board, and also the key performance indicators for staff. Those are the items that we're going to be reporting internally on a daily basis to ensure that operations are going smoothly. I also added, there was some comment about the vision statement and what its purpose was. So I added from government studies and from governmental agencies, mostly federal agencies, city, state, and local, at the back of the strategic plan, so you'd see what the purpose of the vision is to clarify that. But I did remove the word, in particular, the word dream, and changed it to the best of their potential.
I love it.
Okay. Any other questions, comments for Mr. Landry? Mr. Nixdorf?
Mr. Landry, how do you intend to use this document?
What we plan on doing with this is, for our daily operations, we're going to be reporting on a daily basis the key performance indicators. They will be posted at the office so that all staff will be able to see them. We've already started implementing some of the things that made sense from an operations standpoint, like arranging people into teams so that people that are working on similar activities are logistically located across from each other to enable teamwork to happen more rapidly. And then we also will take the key result indicators, those results that we get from our daily performance, and those will be reported to the board. I don't see a whole lot of difference in daily operations, but we have started and initiated 27 different strategic projects in order to promote and further the vision of the board.
That seems like a lot of strategic projects. There's a lot going on. There's a lot being implemented since you've come on. Is there a way that we can track this? I'm in marketing, you're in marketing. Is there a way we can track this through the staff on both Reno and Las Vegas, and maybe even like an anonymous, how's it going for you kind of thing that we can put out to everybody? I mean, and they don't have to put their name on it. It's literally just, how's it going? Tell us your feedback about what, you've implemented as in being in office. Is that something we can implement? I would love to see the results of that. I know that you would too. I think that it would work with, I think the office managers would be happy about it. I know the board would be very interested. I mean, I assume they would, because we have a very curious board. I know I would be very interested. How can we implement something like that?
That's actually one of the strategic projects. It's employee satisfaction survey that is planned for us to do, and it will be done anonymously. We have the ability through technology to do online surveys where we don't ask for with a page that only staff can get to. So we do plan on having that. The employee satisfaction survey is one of the 27 strategic projects that we have slated.
Is there a way we can do that sooner than later, just to kind of track and see how it's going? It's like I think that would be a really interesting outcome to be able to see how it's going, because we see what you're doing and we think it's fabulous. So it's like, but I think it's be really valuable to see how it's going on both ends of the spectrum, both in Reno and Las Vegas.
There's no problem in pushing that particular project up. The implementation of an anonymous survey, we have the technology already in place with in-house, so that would not be a problem. We could certainly have that done and accomplished before the next board meeting.
So can I make a motion to have something like implemented in the next, say, 45 days?
I need to just check legally.
Okay, yeah, that's fine.
Mr. President, I have a question.
I have one too.
Mr. Landry, I was just reading the balance scorecard report, the stakeholder, and at the bottom of it, there's, I think, 3 or 4 of these pages, but we are talking about increasing the abundance for the student pass rates in theory, law, and practical. And I can see that your target is the 100%, but I want to make sure that increasing that pass rate, we're not degrading the passing score. I mean, I don't want to lower or minimize the passing score just so we can increase the passing rate. And we've spoken before that I would actually like to see the passing score
edged up a couple of percentage points.
We currently have no interest in changing the scoring technology, the scoring pass rate. That all being set by Nick. We don't create the test. It's a nationwide test that we administer. We have nothing that we want to do as far as changing it. Just we're not going to be satisfied as board staff until we've worked with the schools and figure out a way together that we want to have the highest pass rate in the United States. And 100% is the goal. We may never reach that. I'm a realist on that, but that is the targeted goal. And so we're going to measure ourselves against how close can we get.
I had a motion. Was that okay, Sarah? Yeah. Okay. So I'd like to make a motion to have an anonymous administrative staff survey done on how the tracking has been since Mr. Landry has implemented his position with the state board within the next 45 days.
I'll second that.
So there's a motion and a second. Any further discussion?
Yes, I have a question.
Okay.
Now, I know I'm not knowledgeable a lot about computers, but the staff would go and take this on a computer. But I do know that you can track computers and know where computers are around the office. So how would the staff feel comfortable taking a computerized test? I would think that test should be administered from somebody outside.
It actually is. The company is Adobe, the same ones who do PDFs. It's called Adobe Form Central. They would be the ones administering. Staff would not be required to do the test from their desktop. They could do it from their iPad, from their phone, from their home,
right.
Wherever it's completely
and completely
up to them.
anonymous. They could write whatever they want.
We have no method of tracking their use in Adobe in that specific form. I shouldn't say we don't. There's probably someone in IT that does.
Sure.
We have no interest in doing that.
I just want to make sure the board would have those results and we'd all be able to share them together and integrate those together. So that's
it for me.
Okay, so let's have a vote then. Yes? Any further discussion, Mr. Nixdorf? No? Okay. Those in favor of the motion before the board?
Aye.
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 Those opposed? That motion carries.
So I did have one question regarding your foundation elements for key performance indicators, and you put in there understand human behavior. Could you explain why you put that in there?
I'm sorry, Mr. Nixdorf, could you repeat the question?
Under foundation elements for key performance indicators, you have a list, and on that list, number 5 is understand human behavior. I'm just kind of curious why you put that in there.
That's from guidelines. There's actually a specific key performance indicator book, about 300 pages that I've read, and it focuses on key performance indicators within government agencies, and it came from that book. And it's really to operate most effectively as an agency staff. You need to understand human behavior, and that's part of the things we ascribe to. I have you'll see in the executive director hiring sequence that I was asked to come up with. I asked for the ability to do personality profiles, and that's something I expect to do for all staff as we go forward in the future.
So this particular item leads to personality profiles that we utilize. Does that lead to potential discrimination?
It does not. I've shared my personality profile with staff and with management staff, and I'd be happy to share it with the board also. Basically, there's no right or wrong in personality profile. What personality profiles are for is so that you understand where someone's coming from. If they're more checklist oriented, which I am, versus creative elements, which other workers at the board are. Other workers at the agency are. It allows us to understand where they're coming from. It's not to be held against them in any way, shape, or form. It's not an evaluation. The personality profile is so that people who are working together who have different points of view have the ability to understand the other. And it's more an understanding document than it's not used for any evaluation in any shape.
Thank you. That's my concern.
Okay, so would any board member propose either an approval or a denial of the strategic plan? Okay, I guess not. Yes, Ms. Long.
I just have a question, Mr. Landry. Is the Breeze system integrated in here at all, that your plan to bring in something like that?
It is not. We're still studying what California is going through as far
I
as...
had to ask. I didn't see it in there, but I thought it's so attractive.
They have not... they've not successfully launched at this point, even though their plans were to. Especially, and the Cosmetology Board was one of the first 5 agencies that they were going to do. That has not been accomplished yet, but I'm in contact with the executive director in California to find out when they do finally get things going, how does that go for them?
Yeah, I would love for Nevada to have that. That's amazing. Thank you.
So I'd like to entertain a motion now to either approve or deny the strategic plan for the State Board of
I'll
Cosmetology.
make a motion.
Okay.
I'll make a motion that we adopt this strategic plan November 2013 as a working document that, as our working document strategic plan.
And a second.
I'll second.
Further discussion, Ms. Long?
Oh, no, thank you. I'm with Mr. Nixdorf on that.
Any further discussion? Okay, so I'll call for the vote then. Those in favor of the motion before the board?
Aye.
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 Those opposed? That motion carries. Mr. Landry, item 17, technology architecture.
Again, fast, but there's some important things in here, and it involves money, so I don't want to go too fast on this. The goal for going in accordance with the strategic plan in the direction we're moving, technology enable all stakeholders, whether that's the public, the board, staff, schools, instructors, students, licensees, and salon owners, allow them all to interact electronically, which is the way board staff sees the world moving. There are various components within this, and I'll just summarize them at a very high level. There was a request to check into video enabling the boardroom, our current boardroom. I had the person who did 7 different boardrooms and different agencies within the state come in to do an estimate. The estimate they gave me is about $5,000 in design. They thought, without going through the detailed design, a rough ballpark was $50,000 to do that, to do the actual $45,000 additional to do the actual installation. This would be something that goes out to bid because it is above the $10,000 threshold from the state. So that's one area. The second is desktop upgrades. We have upgraded the screens, and we had the money to do the screens to get productivity up with the staff to allow them to work on a larger surface, see more windows open at the same time, especially when they're working with our licensing and testing and permitting software, Versa. That upgrade to upgrade the desktops, meaning the computer component of that, is $15,000. Las Vegas and Reno video enabling conference rooms, $15,000 to cut down on staff travel time to have to video enable both rooms. To have that network upgrades is in order to be able to have the video conferencing and also to do a state-run telephone system, and I have that as a further item down the list. The network has to be upgraded. The network itself is overloaded, in particular in the Las Vegas office, which is causing timeouts on a daily basis, multiple times per day. So and all of these estimates came from state IT. They're the ones who we contacted. We had a meeting with them, and they got back with proposals on what these costs would be. Network wiring, which would actually be to pull wiring across from the state board office across to the taxi cab authority and to the, I can't remember the other agency. There's another state agency that would be intertwined. What that gives us is a failback position in the Las Vegas office, and this also includes wiring in the Reno office, rewiring so that we can hook into the state telephone system. But the upside for the wiring upgrade in the Las Vegas office in particular is that we would then have the ability to have a failover to both the taxi cab authority and the other agencies. So if our network connection went down, if our internet connection went down, or our telephone service went down, we could then switch over and be in business. We would not, it would be more a disaster recovery and preparedness issue. The internet upgrade, getting a line that's about 3 times as fast as we have now, is there's a $0 cost. There's actually a cost savings because going the cable modem route rather than a T1 connection is much cheaper. Total on all of those is $110,000. I'll go through the rest of the pieces, and then I'd entertain questions and suggestions. The core system that we currently use is Versa. We're going to be approaching a $9,000 a month figure for that for our operation maintenance and server upkeep. There are other less expensive, potentially more productive systems. I actually had a conversation with Versa and another company, GL Solutions, and we're in continuing talks. Staff is not satisfied with the operation of Versa as it sits today. That is.
Yeah, why is it so costly to maintain it?
Well, why is it so costly? Because if that's at $9,000 per month, right now it's yearly we're at $46,000, I believe.
That's only one. The operation, the maintenance contract is only one component of the total cost. We have, in addition to that, we have servers that we maintain. We pay DoIT for housing those servers. There's the total cost of running the Versa system with support that we paid, the $40,000 or $46,000 that we're talking about this year is going up 5% next year, and there are other additional costs like 6 servers that sit within the state DoIT. We pay rental space on that. We pay network bandwidth for that. When you sum together everything for that system, and again projecting next year with the increases, we have built-in increases in our contract. That it's a very expensive system, as are all licensing, testing, and inspection systems. But we don't feel it's currently serving our needs. I had a meeting with the Versa people last week.
Are they adjusting the invoice from last year from the lack of their slacking?
They have agreed. They have agreed not to, that we don't have to pay anything until they fix one piece of the things that we were asking for. So we're
there's many. I understand there are many. So
absolutely, and they have also said that they will put a time frame on the rest of them.
Very good.
I've been told that this has been promised in the past, and this is not a new promise. So I just wanted to alert the board to
have they
what's
not been
going on.
Had a big changeover inside Versa themselves, and they're having a learning curve there too. So appreciating that, still no excuse on their part, but.
Right.
We should.
They self-admitted that it is their. I was waiting to see where the blame was going to lie. They self-admit it's on their end, and it's their technical end, the programmers and DBAs that is the problem, and we concur that is the problem. It's not with their business interface, the people that we speak with.
And administratively, are there going to be others that are going to be able to do that besides just one person in the office, so we can expand that a little bit and not just rely on the heavy workload of one person?
Absolutely. That's part of why we're evaluating all of the technology is we don't want a single point of failure in the technology, nor do we want a single point of failure in staff that it all runs through one person.
Absolutely. Everybody, there should be some cross, things, everybody, all for the good of the public and, of course, the licensees.
Exactly.
Thank you, Mr. Landry.
I had a question. So today, this proposed technology that you're proposing here, if we said, let's send it out to bid to see what the true cost is that what our goal is today, is to find out what is it going to cost to do this? I mean, it all looks reasonable to me, but...
The only guesstimate is the video conferencing of the boardroom. The rest of these figures that you see are hard cost. I've gotten quotes. The rest of them are, if you wish to move forward with them, those are the costs. These are not in budget now. That's why I'm bringing it up to the board. If you want to proceed with any of these are all out of budget. They would need a budget variance approval, because one of the things we're not going to do is everything has to be within budget, part of my operations with the board. The other thing is if it's going to be out of budget, it has to be approved by the board prior to us doing that, so that we will always pass our audit, and that's of primary importance.
Okay, my next question would be then, what would be the proposal if we went out? I don't know, I guess maybe I have to hear from finance if this was something that are the funds there that we could go out of budget to do this. I mean, we can't just go out of budget and there's no money there. So that's what my question would be. Can we handle this if we went out of budget?
From a cash flow perspective, and I'll let Ms. Blasco give any of the details, but we do have in your board packet, we ended the fiscal year. We were supposed to have a $270,000 loss. We were actually to the positive, so there was nearly a $300,000 swing there. And in the first 6 months, actually 5 months of the year, we're actually $60,000 ahead of plan on where we projected our budget would be. So we're $60,000 to the good this year. The first 6 months, we're about $300,000. So about $360,000 of where you thought you were going to be, we're actually to the good on that.
So if we're only 60,000 good, we need 110 here.
You're 300,000 from last year. You're 60,000 from this year, so you're 360,000 ahead.
Ahead, okay.
Is that from not spending, or is that from what we're saving? Do you know? Is that from we're not spending so much, so we're ahead, or is that because we've actually technically saved it? Oh, sorry.
It's a combination of both. I mean, if we have had income that has been greater than what we anticipated, so that gave us more money in the coffers, and we spent less than what we said we would, so that adds additional revenue. The net effect is the cash position of the board and the net asset value of the board has increased $360,000 more than what was proposed to be at this
both.
point. Right.
So currently, total, what are we spending on technology? And you're saying that Versa, I believe it's only, 4 years old currently? So we spent, I don't know, 50 grand on that previously?
I believe the installation and customization of that was between $300,000 and $400,000.
That's a little different. So we spent all that money. It's only 4 years old. We're unhappy with it, and now we're proposing to change it up?
I'm not proposing a final change. All I'm saying is we're investigating options. This was just to give kind of an order of magnitude of what the two systems are as far as the core system. We're going to continue to investigate and look at them. I'm having much more detailed informational meetings. The GL Solutions is a different approach. We don't have any servers. We don't have any technology. They maintain and manage all of that for a one lump sum price, fixed fee each month, and that's the $8,000 quote.
The $8,000. And what are we paying currently for Versa per month?
When you total everything up next year, now I'm projecting on the 2014 budget, next year we'll be spending close to $9,000, and that's again,
per month.
Per month.
Mr. Landry, I noticed that there's no budget for firewall protection or security. What's the goal to make sure that, because my thought is that if all licenses are displayed for the public view, they can, a certain member of the public or a disgruntled ex-husband or something could retrieve a license number and then be able to perhaps access an address or something without adequate security.
That's actually protected by the State Department of Information Technology. It used to be called DO IT, now it's called Enterprise Information Technology Services, EITS. The state actually provides that. We don't provide that in-house, nor would I suggest we should. My proposal is we need to move to getting out of the technology business as far as us running it, let professionals run it and use them as a service. The trend that you'll see in the industry today is software as a service, where you don't bring the technology in-house. That's all outsourced, and you let your workers do what they're best at. We are not technology professionals, and that's one of the businesses we need to get out of. We do have a server that we use for shared files between Las Vegas and Reno, and part of this proposal of rewiring and restructuring is to get that server out of our building and put that in the state DO IT office, so that we're out of the technology business. We are not technology specialists.
And that's covered in this budget here? Okay.
Just a few more pieces quickly. The phone system, state of Nevada switching over is a zero cost. There is about $1,000 zero cost for the state. The state would not charge us to use the state system. That's a service that we would get for that. There's about $1,000 a month savings, but there is a one-time expense in buying new phones to work on the state system of $10,000. So there's about a less than a 1 year payback on that particular area.
So 10 months to break even on that.
Correct.
No charge deal.
Correct.
Gotcha.
And then there's also some board members were asking about automating and using technology within the board meetings, and so that we wouldn't have to spend as much time and effort on paperwork. There's a package called Novus Agenda. They do about 1,500 to 2,000 different boards around the country, and theirs is a fixed fee, a $350 a month fee, where all board members as well as staff would have an individual login. You could go in, take a look at the board packets, make notes on that, and then have that available to you during the board meeting. So that's another thing that I've investigated. And finally, the inspection technology. In the current mode, we do have laptops, but those do not allow us to send information back from the field. And at NIC, there was a pretty impressive demonstration, as well as I spoke with Adam Higginbotham. He's the executive director at West Virginia, for the West Virginia State Board of Cosmetology and Barbers, and they use Galaxy Notes very effectively to do their inspections. So there's an inspection that you do from a handheld device. When you're done with it, you submit it, and it goes back to the board office. That way you're not required to come back to the office at end of day to do the downloads. You can probably, in his estimation, pick up another 2 to 3 inspections per day.
So it's a real-time transference of information without...
Correct. Gotcha. Without having, and again, that's instead of going to what we currently do is they come back to the office, they plug their laptop into the network and download that information.
All this stuff.
Exactly.
Yeah. Would you be able to do reports, analytics, metrics, all that stuff off that? You'd be able. It'll be all.
Absolutely, and the ability for the Galaxy Note, it's what's called a phablet. It's a phone-tablet combination. What it allows you to do is they could actually pull up information from the board, from our website, and from right now Versa Mobile, that would allow them to actually look into the files. So when they're
ask things
exactly, instead of having to call the office, being able to look up those things themselves and see, does that licensee's picture match the person I'm speaking to right now?
Or if they've added an extra manicure table, or if there's another room that they've added for this. Okay.
So you said Versa Mobile. Is it exclusive to Versa? So for whatever reason, say in the future we decide we don't want Versa anymore, which is probably going to be a future agenda item, just as a little spoiler alert for everybody else. Are we committed to, do we have to stay, is the technology specific to just Versa Mobile, so that in the future, if we're switching to a different
No, the technology is not. The technology is independent of the core system you're using, and the Versa system. The only reason I mentioned Versa Mobile, we already own that packet.
Okay, yeah.
So we would be able to move forward with the implementation, whether or not we change the core system or not.
Okay. Any further discussion?
I just have a question. So if we were to have the meeting notes before us, would we be having all this paper as well, or we'd have laptops and then everybody bring their own, or would the board have them?
That the particular implementation of how we would do that is still not determined. That's something I would want to know from the individual board members. Some people are more accustomed to their own devices and might want to use that. Others would want to have a device preloaded with the information at the board meeting. That would be a future discussion topic. I just tried to lay out kind of a vision of this is where I think we should head. Whether we fund it today, whether we fund it next board meeting, or 2 years in the future, I just wanted to lay it out on the table that if you wanted to get moving with any of these are the costs, and this is what it would take to move forward.
I think the less paper, the better. I think we move toward paperless. I mean, in my opinion, I know Perry would use his iPad.
I'd like to make a motion that we move forward with the proposed technology architecture and budget it, providing that since we can afford it, it sounds like. So I would like to make a motion that we move forward.
And before the motion is finished, I just want to let you know, whatever you're approving, it's not a snap your fingers and it's done.
Right.
This is probably going to extend beyond this current fiscal year budgeting cycle as far as getting all the technology.
We'll have it done next week.
Right. So this is just the architecture to start the process.
Exactly. And
we're not approving that you do anything.
As a working
just
document, yes.
Just that you move forward.
That you move forward and you get us the quotes and the
I'd like
estimates.
more detail, yeah.
I'll second that motion.
Okay, so there's a motion and a second. Any further discussion? Mr. Nixdorf.
We're not approving all this as...
We're approving this as a loosely worded, moving forward, basic structure for technological advancement.
Are we allocating funds towards this?
No. We're just approving that Mr. Landry can move forward to try and figure out if we can accomplish going paperless and cutting costs for Versa. Boy, I'm back on that one again.
So
and
before this
so on
is-
and so forth. But this is just a architecture for what moving forward.
So, Mr. Landy, before any of this is implemented, are we going to see a little more of this?
You'll see a detailed plan on each this is the overall architecture, and if this is the direction the board wants to head in the very next board meeting, I'll probably have in front. I would definitely have in front of you the phone system,
solids, okay.
so that we can, it's something that we can get savings on immediately. I do that, and then any other things that we can move to in a rapid fashion that will actually gain benefit, gain cost reductions.
Okay, so that basically this is a working document. Nothing's going to be spent or implemented until next meeting. Is that clear? Is that
That is correct.
Okay, thank you.
Okay, there's a motion and a second, so let's go ahead and have the vote for the motion so we can take a little 5-minute break for Mr. Nelson.
And Ms. Long.
And Ms. Long. Those in favor?
Aye.
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 Those opposed? That motion carries. Okay, so 5-minute recess, please.
That's what we do down the professional standards association.
Okay, so we're back in session at 4:02. And we have a half hour to accomplish what we need to today, so we should consider that as we move forward.
Mr. President, I might propose that item number 19, the discussion of the executive director hiring process, be postponed to a subsequent meeting, as well as the presentation on the alternative solutions to cosmetology wedding services, item number 18.
I'll second that.
Was that in the form of a motion?
Oh, I don't know if we need to make a motion for
So
it.
that's in the form of a motion then?
Yes.
Oh, it is.
And seconded by Ms. Booth.
Yes.
Any further discussion? So I'll call for a vote then. We're, in an effort to speeding things up, for those of you in Vegas, we're going to be moving item 18 and 19 to a future board meeting. So I'll call for the vote then. Those in favor?
Aye.
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 That carries unanimously, I believe. Okay. Item number 20, travel policy. Mr. Landry.
This item was put on the agenda just to clarify and get clear what staff needs to do as far as preparation for board meetings, how the board meetings are conducted, board travel, all of that. There's no written policy. And so what I'm trying to do is get something that the board, this board can be changed by later boards, but this board wants to do as far as travel policy. In the area of air, the board meeting logistics, are you required to be at all of the same place? Are you allowed to be remote, remote locations? Air travel policy, the mode and method of travel, hotel travel policy, car travel policy, and meals. So just so I get input from the board so I can execute with the board's wishes.
Well,
I would like to say something.
For me personally, Ms. Tran, I've missed you today, and I would like to propose that all the board members be in the same room for meetings. I don't know how you feel, but for your very first meeting, I certainly would have liked to have you join us in person. And I'm not that I'm disappointed, but I'm, reluctant to repeat this.
Well, this was an emergency. I was planning to come up to Reno, but my father is visiting me from Florida. And so he had a mild heart attack this weekend, and he is in the hospital at this moment while I'm at this meeting. So it's just my mom and dad. There's no one here to help them.
I'm sorry to hear that.
I had to cancel.
Well,
and he's in the hospital as this minute, So I'm kind of
appreciate you
worried about
taking
them
the
right
time.
now. So.
Well, I'm sorry to hear that.
No problem, yeah.
I wish you all the best with your family, and hopefully at our next
Thank you.
meeting, we'll have the opportunity to enjoy you in person.
So
I definitely, would be there. I mean, there's no doubt about that, but this wasn't a last minute. I mean, he just collapsed and, so there was nothing I can do about that but be here for them.
So
I missed all you too,
So
Let
for me,
us
that
know
makes
how
a
we can
case-
help.
Yeah, so for me, this makes a case for item 1B. Board members are allowed to either travel to each of the 4 board meetings in designated locations or attend at the closest location. So that's,
Okay.
I would like to see 1B as far as staff.
I agree.
So
I'd like to keep it as is, as it's been.
there's not
It
anything
hasn't- there
that's
isn't
established.
No,
That's
it
why
hasn't been.
we're-
I guess how it's.
Well, things are changing.
Things are
Well,
changing.
I don't think you ever officially had a policy, but I think in the past the practice generally was everybody flew to the same location or drove to the same
Okay,
location.
so Mr. Leader and Mr. Nixdorf, there was also Mr. Landry. Beyond just the travel of the board, you said staff. So on. I'm sorry, I'm not remembering the exact.
I wanted to say something about this, the first part.
Okay.
I'm sorry, I didn't get to say anything about that. I didn't mean to upset you.
You didn't upset me. Go ahead.
Okay, I think if we could word it where that we're required to be together, But if something happens, like in this situation, to have it approved and that they are excused from not being here, that they either go to the nearest location or dial in by phone, even a phone conference, if they should have to go out of state because somebody was ill. I think as long as they try to participate, but I think the general rule for me would be that we all meet together. But if we can't, then that person would be excused if they even teleconferenced.
Yeah, I mean, I think in a situation like this, I think we're fortunate that she's here remotely, because it could be, if you had a situation like that you just wouldn't be available for the meeting, and that happens. People get sick, or people in their family get sick, and they can't make it that day sometimes.
Well, much as I love all of you, I do value my Sundays, and a travel day for me is better spent at home. So I'm still in the mode of to be able to choose what I would like to do, and I think that's where I want to be at.
Perry, would you consider traveling in the morning of the meeting, like an early morning flight?
Oh, no, I like my sleep.
Okay. Any further discussion with regards to a travel policy? There were other items with that, which is what I was...
Oh, I'm sorry.
So I would like to make a quick motion to this, right? Because then we can break this down with staff guidelines here, the staff recommendations. I'll say on number 1, I would like to make a motion that we adopt B. And that would be the end of my motion on number 1. Then we can discuss the other items.
Okay, so your motion is, please, can you restate that?
That we adopt 1B. Board members are allowed to either travel to each of the 4 board meetings in the designated location or attend at the closest location to them as the policy for Mr. Landry to follow.
Is there a second? Ms. Long? Any further discussion?
Mr. President, I just feel that perhaps this is another discussion that we could postpone to another meeting, because there are some budgetary restrictions to some of these recommendations, and I just would feel more comfortable in the time allotted to perhaps review this at a subsequent meeting.
I agree.
Could we possibly just do 1B as travel, so the next meeting we'd have that choice, or those who would care to have that choice, or would you rather just see the whole thing tabled until the next meeting, Alex?
Well, there is a motion on the table in a second, so we could solve that particular piece of the puzzle and still leave the rest for future agenda items.
Let's do it.
Okay, so I'll have the vote then, please. Those in favor of the motion before the board?
Aye.
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 Those opposed?
Nay.
That motion carries.
So then I'll follow that by tabling a discussion, making a motion to table items 2 and 3 and 4 for the next meeting.
Is there a second?
And 5 maybe also?
And 5, I'm sorry, I missed page 2.
I'll second.
I'll second that. Oh, I'm sorry.
No, it's okay. Go with second.
So the motion has been doubly seconded, and is there any further discussion?
I'd just like to make one little comment here, is then we won't have any changes then until this has been discussed.
For the travel, that you'd be able to either attend or go to your closest.
Right, but all the
Vote.
rest will stay as it has
Until
been
we
in the
decide.
past. Okay, thank you.
So we'll call for the vote then. Those in favor?
Aye.
Aye.
Aye. Those opposed? That motion carries. Okay. That moves us to item 21, holiday schedule and board meeting dates. Mr. Landry.
This is just the published holiday schedule from the state HR website, and then the board meeting dates were just mimicking or mirroring what was done this year. There was some talk and discussion among board members about Las Vegas in August is not a particularly pleasant time to be there. But
Well, as much as I love snow, it seems kind of warm in August down in Vegas.
But you run into the same problem with an alternating schedule that February in Reno can be quite snowy. So just The staff has no recommendation. This is just a mirror. If board wants to adopt this, fine. If board wants to change this, fine. We just need to know so we know what meetings we need to be publishing and what the schedule is going to be.
I'll motion to approve the 2014 holiday schedule.
And
Is there a second?
I'm going to second that with the understanding that that includes the 2014 board meeting dates.
Do you want me to amend that motion? I'll amend the motion as being, I move to approve the 2014 holiday schedule as well as the 2014 board meeting dates as well.
And my second reflects that amendment.
Thank you, Mr. Levy.
Is there any further discussion to that?
Yeah, I have a question. Why is it that we have to rotate? Why can't we just do, I mean, since we're doing video conferencing anyways, why can't we do Vegas when it's cold here and do the northern location when it's warm in the northern location? Why does it have to be alternating?
I think just that it was put on as an agenda item. It's really, if I can be honest, I was kind of complaining about how hot it was in Vegas in August, so it's probably my fault.
Well, that's what I'm saying. Why can't we have Reno in August and then Vegas in November?
I think it's for the convenience of the licensees who want to approach the board, because then it just gives them that.
But now we're on video conferencing.
Right, but that's been
so they
changed,
can
yes,
go to
with the
their
video
closest location.
conferencing.
So why don't we just make it convenient for us and switch those up? I mean, what's so hard about that?
Well, and truthfully, there's no reason to. I can come to Carson City instead of going to Vegas. So.
Well, yeah.
The board
Vegas,
has
Reno.
But I'd like to go. I'd like to spend a warmer time in Vegas. That would be nicer in February and November. Thank you.
Well, you now can travel remotely from Vegas if you want to be down there in the warm weather when the board meeting's up here where it's cold.
I see.
So there's
not liking that.
No, I mean, I think what was approved is that you either fly to the location of the meeting or you go to the one closest to you. If you're already here and the meeting's here, you come here.
Okay.
I think it sounds like maybe what Jeanette's wanting to do is modify the schedule so that would be Las Vegas, Reno, Las Vegas. I don't know if there's a second to that, if she wants to make that a motion.
Well,
there's actually a motion and a second on the
It's just
table
discussion
already.
right now. So I was just saying, why can't we amend that to make it where we're in Vegas when it's nicer to be in Vegas?
Well, there's a motion and a second on the table, so we would have to.
Well,
amend it?
Yeah, I can amend it. So
August 4th would be Reno and November 3rd would be Vegas.
Okay, I'll amend my motion to the 2014 holiday schedule to stay the same. The 2014 board meeting dates would read as February 3rd, Vegas, May 5th, Reno, August 4th, Reno, November 3rd, Vegas.
My second reflects that amendment.
Okay, is there any further discussion to the motion and the second on the? Okay, I'll have the vote then. All those in favor?
Aye.
Aye. Those
Aye.
opposed? That motion carries. Okay, so we tabled previously a discussion about the executive director's report, and we have 15 minutes, no pressure, to go through all the items that those of you of the board that wanted to discuss this with Mr. Landry. So I'll open up the microphone to that.
Mr. Landry, I had previously asked to have this document separated because when I look at the audited financial statements for the fiscal year ending June 30th, 2013, in the letter of October 11th from Holdsworth, Russo and Company, there was a Versa Access Control Profile Override and Edit function. Has that been corrected? Because this is the second time that their audit has expressed this concern.
I was unaware of the first time, but I'm aware of this time. And what the audit concern was is that they would simply like to have a report created in Versa that would allow a reporting to show every time the fees were overridden for any reason whatsoever, who the person overriding was, and that's controlled. That's not everyone has that overriding capability in the system, but those that are authorized to override the system for fees, that there be a report that we could take and look at from an audit standpoint. We are currently working on that, putting the specifications together to be able to do that within Versa, but I was unaware that that was a previous comment, but for the comment this time, it was not, That was the only comment on suggested improvements, and I asked if it was major or minor. It is a minor comment, but we are going to address it.
Also, when we move to page 14, it's note number 3, deposits with financial institutions. I wanted to double check, what was it then on this page? Oh, I was very surprised that we, what was this? Oh, that we had this foreign currency stuff going on in that investments. Like, what are those with the banks of Baroda? I've never even heard of that country. And this Bank of China, Bank of India. What are those?
I'll have Ms. Blasco go over the details of that. She's much more familiar with that than I am.
I looked into this when I was reading this, and what these are, from the best I can glean from this, is they're certificates of deposit that we have that give us a high interest rate, and they're not in foreign currencies. They're in U.S. dollars, because in those reports that you were reading, it talked specifically about how we have no risk regarding foreign currency risk. So if we have money invested in them, it's in U.S. dollars, and this is pretty typical of international banks, where they can invest your money for you at an interest rate and not actually have it in their currency.
Okay. Ms. Blasco, did you need to add to that comment?
No, Mr. Nixdorf is correct.
Thank you.
And I wish I could say we were getting great interest rates, but we still are not.
No.
It's inching up very little bit.
A couple page later, on page 18, note number 9, the leases. I'm very surprised that we're paying an interest rate of 26.57% on a photocopier that we only owe $4,400. Here we're talking about spending $110,000. Why can't we just buy that copier outright? I mean, 26%, that's like highway robbery. We should have never even agreed to that interest rate in the first place.
I didn't. That was previous board action, previous director.
So is there a prepayment penalty that we can just pay off that $4,400 balance and get out of that interest payment? Or is there a prepayment penalty?
I have not reviewed that specifically, but I can review that and give a report back to the board on what the cost would be to get out of that lease, to buy out the equipment, or to exit that lease and enter into a new lease with other equipment.
Well, I can I say something as treasurer? I have asked Ms. Blasco about it, and she explained it very simply. Debbie, could you just explain, because I know we've talked about this when I came in to sign the checks about the copiers. Could you explain to Mr. Leader what you explained to me?
I'm not sure what that was. Last year was the first year that we had to account for the lease differently. We had to pick it up as a capital asset. And instead of just making a straight out lease payment expense, we had to break it down to a fair market value, interest, break it into interest, break it into principal, and set it up as a payable kind of thing. And that's because some of the rules and regulations in GAAP had changed. So this lease was a lease, and now we have to account for it this way. So yes, it does look a little off when they say, oh, the interest rate is 26.57%. But it also includes, our leases on the copiers also include all the toner. We don't purchase that separately, so that is actually a savings for the office. So you have to look at the whole picture.
Does that include the maintenance too, Ms. Blasco?
Yes, it does.
Okay. So
yes, it does.
And as a side note, Ms. Blasco, in the executive director report, it did indicate that that you were going to be moving to North Carolina to be closer to your family. So I just want to say to you that I really appreciated your professional integrity as our accountant in the State Board of Cosmetology. You've done just an absolute marvelous job since I've been on board, and that's been about 7 years now, and I really have enjoyed working with you, and I wish you and your family all the best.
Thank you.
Myself as well, Ms. Blasco. It's a shame to see you go. We're sorry to lose you.
Agreed. I'll second that.
Thank you.
Those are mine.
Was there any other concerns, cares, comments for Mr. Landry?
Just for clarification, the couple recommendations you said you're taking care of. Okay, now, that's what I thought I heard you say, but I wasn't sure.
So I'll entertain a motion then.
Move to approve the budget,
No, it's not a budget. It's the executive director's report.
but we didn't go through all of it.
Well, those were the items that I had separated out from the report from the
Wanted to
beginning.
discuss.
Yeah, and so those items were what I wanted to discuss. We've discussed them. Now it's
Well, you've never actually voted to approve the consent agenda.
right.
Consent
Move to
agenda.
approve the
We're
consent
discussing the
agenda.
executive director's report.
Yeah,
I
it's
thought.
on the consent agenda, so I think if you're all okay now with it, I think you should vote to approve the consent
I'd
agenda.
like to make a motion then, Mr. President, that we do approve the consent agenda with those questions having been asked and answered.
Is
I'll
there-
second.
And a second from Ms. Benaldi. Any further discussion?
No.
I'll call for the vote then. Those in favor of the motion before the board?
Aye.
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 Aye. Those opposed? That motion carries. Agenda item number 22, future agenda items. Is there any board member that wishes to propose that?
I think with Ms. Blasco sadly leaving us, we need to put on the agenda on possibly hiring somebody to replace her.
Do we want that agenda item to include the discussion as to whether or not we'd be hiring an inside accountant
Or an external.
farming out the
Yes.
accounting to an outside firm?
Absolutely.
Okay.
I'm not sure that that's our purview. I think we hired Mr. Landry to be able to do that.
I mean, the board can do whatever it wants, but typically in the operations mode, I would do the hiring and firing of the replacement for Ms. Blasco.
Okay. Anything else? Any other board members want to propose future agenda items? Okay. Agenda item 23, comments from the public. Is there any public members left in Vegas?
There are no public members in Vegas.
I thought the medical records were supposed to be shredded because it's privacy issues.
As long as we're sure those are going to be shredded, that just says recycle on it. I just wanted to make sure that we're not just throwing them in a trash.
I'm going to take that box back to the Board of Cosmetology office for shredding.
All right. Well, if there's no further comments, then I believe we can adjourn for the day. Aren't we all so happy about that? Thank you so much. Meeting adjourned.
Yay. Thank you.
I hope your family feels better, Joanna.
Thank you very much.
Thank you so much. It's a pleasure to have you with us. Deborah, I'm sorry to
Thank
see
you.
you go. I'm kind of bummed.
Thank you.
You're not
Won't be for a little bit yet.
the best thing.
Oh, goody.